Next week or one day.
Take that. I'll take it up on Thursday. I'll take it up on Tuesday, next Tuesday, some. Yes, yes. Take it.
11.
16.
Yes. No urgency for the interim order vacation or now. Yes. No. Look at it someday next week. Yes.
DRT fresh matters, my lordship.
Fresh matter, no memo to be given, matters will come.
That's the
Yes.
urgency. C option sale is on day after tomorrow, my lordship.
Let it be. We will, if required, we can put the clock back. Yes.
My lords, respondent bank has obtained a possession order from a lower court.
Fresh matter.
It's a fresh matter.
It will come. Yes, next.
It's regarding stay application. It's almost 4 times we have put this matter. I use my deal.
Is it a fresh matter?
No,
Huh?
emergency matter.
Huh?
It's an emergency. It's regarding warrant matter.
What is that? Is it a DRT matter? Is it FC matter?
It's MFA matter.
MFA? Yes.
Your lordship,
This is
claim.
a PMXC matter, my lord. There's a function that is held on 14th of this month, my lord. So there's urgency in this matter. We have filed an application for dismissal of visitation.
Yes. Next.
It will be listed tomorrow.
One submission, my lord.
Tomorrow.
With my last leave, my lord. One matter, my lord, is a fresh matter. The warrant was issued, your lordship. On 11/12/2025, it was listed, your lordship. By oversight, I did not notice, your lordship. It came to be adjourned. Can I request, my lord, to fresh matter only, my lord?
It is a fresh matter.
By mistake, my
How
lord,
can it be
I did
oversight?
notice, your lordship, on 11/12, my lord.
Oh, it's difficult for the court
I
at the
know,
back end to
I
accommodate all
understand the difficulty, my
Leave
lord,
it,
but,
we'll see, we'll
but
see.
for that only, my lord, I am making
See, we'll
submission.
see. Yes.
Next, any day, tomorrow, day after tomorrow.
We'll see. Yes.
Refund bank issued a physical notice with the help of the police. 13th, there is urgency in the matter, my dear.
Fresh DRT matters, fresh family court matters, please do not mention. They will come. Yes, next.
There is urgency.
If it is no urgency, anything can be, we can set it right. Yes.
Scheduled
DRT matter,
tomorrow,
no?
tomorrow, my lord, that is.
Yes.
DRT matter, my lord.
DRT.
Some third party filed petition and obtained interim stay.
Fresh matter.
No, my lord, for vacating interim stay.
No, no, vacating will not hear this side of the vacation. Yes.
My lord,
Huh?
DRT matter.
Fresh matter?
No,
Huh.
the responding bank applicant has obtained saying this. The matter was dismissed by the coordinate bank. They filed IA to recall that date. And the last date, the order was recalled and the IA was alert. So we were recommending the day.
No, all these matters, I'll not hear this because there are so many other matters to be heard. Fresh matters are pending. Vacate petitions will not be heard. Yes.
Considering, it's a old matter, your lordship, old matter, considering that the borrower has lost the title by virtue of Supreme Court order in SLP 27617, this honorable court has passed an interim order not to proceed. In spite of that, suppressing that, they are for the action for that, your lordship.
We will say, not.
No, it is, no, this honorable court has passed an order considering the Supreme Court order. And it has been communicated to them. In spite of that, absolute disrespect to this honorable court, they are proceeding.
Then you have to move a contempt.
No, but see, this is a consequential cause of action. So we have moved the contempt also, as well as say this. This is technically, because that's what in
So what
Supreme
is
Court
the-
matter.
What is the order that you are expecting from this court?
No,
now?
this court is that, your lordship, the borrower has lost the title by virtue of the Supreme Court order.
Yes.
In spite of that, suppressing those things, they are proceeding with the recovery proceeding. The borrower who mortgaged the property does not have the title. So then we are before this honorable court. Honorable court was pleased to pass an order considering the SLP order.
Yes.
Now they are proceeding with, we served, hand summons were made. In spite of that, they are not willing to come before this honorable court, putting rowdies and everybody. That is the reason, your lordship. This is absolute disrespect to this honorable court. No, that my humble submission is that this is a old matter where this honorable court. Yes.
My lord, GMF, my lord,
DRT matters, I'm not, no fresh matters.
my lord,
Don't have to mention, they will come.
my lord, there's urgency. My lord, there's urgency in the matter. GMFC, we have filed, my lord, we have filed a GMFC on criminal miscellaneous case which has come up from a family court. The petitioner in this case was not given an opportunity for the cross-examination to
The
become.
fresh matter.
My lord, tomorrow is the final
So
hearing.
what we can do?
My lord, I need an opportunity to
Not
be,
possible, not possible, I cannot.
My lord,
Today there are about 96 matters.
my lord, the petition will be infructuous if at all, if it is not allowed.
That the court can't help it. Yes.
My lords,
call the-
my lords, old matter, my lords. My lords, matter pertains to Employees Compensation Act, my lords. The petition appellant, my lords, is 80-year-old, my lords. His deposit around 15 lakhs before this honorable court, my lords. My lords, a date may be fixed, my lords. Any date after vacation also is fine.
For fixing a date, a memo. That you can ask the court after the vacation.
My
not
lord, it's
now.
been more than 6 months, my lords.
My lord.
Not been
No, no,
listed, my
no, no.
lords.
I'll not fix the next.
My lord, if,
My lordship, this is,
My lords, the memo will be taken up, my lords.
I will take all the memos and I will not post it. Take all the memos, if that's what they want. Take all the memos. Just call the list.
my,
KPD matter and surface matter, one matter, KPD and surface matter, my lord, partly heard. One matter is already reserved, another matter has to be.
my lord,
Are not possible.
my lord,
The matter was
My lord,
before court all
I'm
12. my
appearing
lord.
before because there is
mentioning
urgency in the
my
case. Otherwise, he will lose the case for the final hearing. He was not given an opportunity to finish his cross-examination also. And in fact, the wife
When did you
was,
file the petition?
my lord, last week, my lord, of Thursday we filed.
Then if it is numbered, it will come. I have directed them to list all the fresh matters.
I understand, my
Not
lord,
even-
but
not even
it'll
to
be
keep it,
infructuous if
even a day.
the final hearing or the arguments are done, completed tomorrow. The case itself will become, or the petition will become infructuous.
If it is numbered, it will come. Tell
My-
again instruct the section to post
My lords, this
all the
was-
matters.
my lordship, GMFC,
This was
Actually,
partially heard matter.
Huh?
My lord, this was partially heard matter, but the date was given when there was no sitting, my lords. Kindly post it, any date may be given.
We will see. Take that. Just call the list.
my lordship,
Wait, adjournment.
GMFC, it is a very urgent, child college fees has to be paid. And since from 2 years, the husband has not given any compensation and as well as he's not,
File this petition.
yeah, this 2023.
2023 matter, now at the back end of the vacation, it is urgent.
Madam, this is fifth time I am filing memo, my lordship.
No, I'll not take up any matter of old matters. Yes.
Both part-heard matters.
My lords, one urgency.
Keep putting, sir.
My lords, one urgency, my lords. And on 18/8, this trial court had disposed one writ petition directing the lower court to dispose the maintenance application within 30 days. However, even on 6th December, the matter has been adjourned to 12th January. The matter application hasn't been disposed.
Direction for that, another direction.
My lords, for being
Also have the work. No,
for being
we-
spoken to, my lords, it's posted for orders only, my lords, but the orders haven't been passed from 2 hearings. The matter has just been adjourned.
How many times the court will pass orders on the same application?
My lords, urgency from one, application has been pending from over a year, my lords.
Let it be. Yes, call the list.
My lords,
My-
my lords, auction is held today, my lords.
Let it.
I'm a farmer by profession. I had availed 3 loans, my lords. Section 14 of Surface Act has been allowed, my
Let all
lords.
the DRT matters come once they are numbered in the usual course. Now, if the auction is done today, tomorrow, day after tomorrow, we can still pass orders. For that, out of turn, will not take up any matter. Yes, call the list.
My lordship,
Matter is for reporting settlement, kindly the matter may be.
Yes.
My lords, at least the memo may be accepted.
my lordship, this is very urgency for college fees. So
Yes,
this is
call the
fifth time
list.
I am filing my
I'll
lordship.
not take up this matter with this side of the vacation.
Page-wise adjournments, page numbers, list 1, page number 7, cell number 25 to 30. Page number 8, cell number 31 to 37. Page number 9, cell number 38 to 42. Page number 10, cell number 43 to 54.
Serial number 51, my lords, and for the petitioner, a week's time may be granted, my lords.
Who moved the memo?
Madam,
My lord, senior is unwell.
No, who moved the memo?
Fresh matter, my lords.
51.
51.
51 is CH moved, court moved.
Yes, my lords.
Who moved it? And who is asking for time? Why are you asking for time?
Apologies,
This
my
is
lords.
matter after vacation.
Grateful, my lords.
Serial number 48, my lords. For the
Yes,
petitioner, my lords, it may be taken next week, my lords. Senior is unwell, my lords.
yes, after vacation.
Cell number, page number 11, cell number 55 to cell number 60. Page number 12, 61 to 66.
My lords, serial number 63, my lords. My lords, in this, my lords, my MFA 8701 has to be delinked, my lord. It is connected by mistake, my lords.
It is not connected with
No,
this.
it is not, my lord. Both are different
Then
subject
council
matters.
submits that MFA 8637 is not connected to 8701 accordingly. D-Link MFA 8637 of 2020. Yes, next.
Page number third.
Hmm. Huh? You represent whom? Who have you informed the other side?
Ravi Kumar NR.
Huh? Let other side be there when the matter is adjourned. If they have anything, they can submit. Yes.
Page,
Huh? To the respondent counsel. At the request of learned counsel, the petition lists this matter after vacation. It is submitted that the same is already informed to the counsel for the respondent.
page
Yes.
number 13, cell number 67 to 74. Page number 14, cell number 75 to 80. Page number 15, 81 to 88. Page number 16, cell number 89 to 92.
Yes, call the
Page
list.
number 17, 93.
My lord,
Page-
serial number 93, my lord. Short accommodation, my lord. Appearing for petitioner.
90.
93, my lord.
Nandish Patil.
Where is the other side?
Nandish
Will
Patil.
inform, my
SV
lord.
Prakash.
Will inform.
Who will inform? You have to inform
My-
and make a mention.
My,
Wait
kindly-
for your turn. Yes, call the list.
Page number 1, list number 1, part-type matter, serial number 1, Jaiprakash Reddy M. For petitioner, Prasanna VR, Prasanna Kumar.
What happened?
Lots, there was one round of mediation which took place at the respondent's office, but that could not yield much result.
That person is not present at the time of mediation.
Then what's the purpose?
But we have made efforts.
Both are sit together.
But we have strictly said, we have advised Milords for mediation. In fact, my
You
client.
then will pass orders on the merits of it.
Not merits, then I may be heard, Milord. Merits, then because it's a review petition, I may be heard.
I will take note of this aspect, the subsequent development, and also in review in the these kind of allegations.
Milords?
I will take note of the subsequent development also about the allegations against the wife the husband has made in the report of the DNA report. That I will also have to take a
That
note
would
of.
prejudice my entire case of trial, Milords, if this observation is.
We have to take a note of it.
Let's-
Because you just like that, you can't be, left like that, making allegations against women. Just
Yes,
for the
I
sake of denying maintenance.
Milords, I understand, Milords, what is falling from my lords. Milords, but if a trial goes on, Milords, I would be entitled to my defense. Otherwise, Milords, this would be taken on the face of it and would prejudice my
That's why
entire
you come up with what is, if you do not want the court to make any of these observations, tell your client, I'll pass out this matter, tell your client, let him come up with what is the maintenance that he is going to grant. Then I will not record all this. And I'll straight away pass an order directing him to pay the maintenance.
That's my request for tomorrow, Milords. Tomorrow, your lord.
Tomorrow in the top of the list.
Great.
And I'm telling tomorrow, tell your client, I'm going to take note of all this and I'm going to observe. And let him come out with whatever amount he is ready to pay. Then we'll pass an order.
Milords, one thing which I could concur with my client is, Milords, insofar as the child's expenses, Milords, we were able to be successful to say the respondent is ready.
How much he was ready to pay?
Milords, whatever the expenses which he was bearing to the first child, he is ready to bear the entire expenses even for the second.
What are the expenses of the child?
Educational expenses.
Reduced already. Educational expenses and medical expenses.
That he says he is ready to bear.
Yes, let him bear because he is.
In that case, then I'll pass that order that he is ready to pay.
What about the mother? The Lordship mother is an advocate. She is a junior to this junior.
What is his income?
Milords, his income, Milords, he was employed. Now, Milords, he is unemployed. His job
He
is.
is having crores of rupees properties. We have given. Even your Lordship McKenzie has not given a.
Milords, that is all rejected. All those properties were taken into consideration and rejected by the earlier courts. Income tax returns were filed as per Rajneesh versus
Even
Nayam,
rent
Milords.
itself is
All
90,000
those were
is fine.
disputed. Milords, the
No,
fact
tell the
finding.
court, what is his income?
According to him, 90,000 is trying the rent.
90,000. Now, what is he paying for the first child?
Not for the first child, my lord.
5,000. That too,
No, child is with him.
Child is with him. My lords, all the,
Second child is with her.
Yes.
The first child is with him. So what are the expenses that are borne for the first child?
my lords, all his educational expenses, he's studying abroad, and his medical expenses. My lords, all the expenses are being taken care. My lords, the father is ready to take care of this child. Bear the expenses. My lords, to that extent, my lords, we have convinced him.
How much it is coming, the expenses of the child?
Lords, I'll place everything on record tomorrow, my lords.
Yes, tomorrow.
Tomorrow we will also place.
Cell number 2 for dismissal.
But one thing is there. Now, looking at his income, which is there on record, and the expenses that he is bearing, for the first child, and what he is ready to bear for the second child. So beyond that, if it is beyond his capacity, we can't say that entire 90,000 to pay to the, that we will decide. So accordingly, you can, yes, tomorrow.
Cell number
Yes,
2.
Once-
Vijay
once-
Kumar.
On submission.
I am for the appellant, my lord. I am for the appellant.
Respondent, I filled in a crop MFA, my lord,
Hmm.
and also filed in a wakalat, my lord. They have challenged one, there was two common judgments. Only one case has been challenged before this honorable court. I filed in a crop, my lord. Crop number 128 of
Delete
2020.
from the caption dismissal, list along with MFA.
FR number 128 of 2025.
So and so after vacation. Next.
Please.
Cell number 3. Cell number ಬರ್ಕೊಡಿ. Cell number 3.
Picked up here for respondent
And
bank.
Suresh.
Interim order is complied with.
No, my lord.
The present writ petition is filed. Questioning the sale notice dated 24/5/2024. And also seeking a direction to the respondent for regularizing the loan account. When this matter came up for hearing, a coordinate bench of this court on 25/6/2024 has granted stay on the condition that had passed an order restraining the bank from confirming the auction sale conducted on 18/6/2024 till the next date of hearing, subject to the petitioners depositing a sum of rupees 15 lakhs with the respondent bank on or before 27/7/2024. Then this matter came up on several occasions before this court. And the matter came up on 9/12/2025. As there was no representation, the matter was directed to be listed today under the caption for dismissal. Today also there is no representation on behalf of the petitioner. Then counsel appearing for the respondent submits that the petitioner has not complied with the interim order. Accordingly, the writ petition is dismissed for non-prosecution. Yes, next. Next.
Cell number 4.
I appeared for petitioner, madam. Senior was hospitalized in the last date of hearing, hence we could not appear before this court. Kindly allot the case by course of time, my lord. I will do complaints of the office objection, my lord. There is only one office objection, my lord.
What remains this petition? Writ petition of 2024. No interim order in this. What is that your respondent is not served so far? No notice is ordered. Directing the respondent number 2 and 3 to adjust the excess interest amount collected with the respondent number 2 and 3 from petitioners at the rate of 15.9% instead of 8.80% from the date of expiry of the 3 years of the loan transaction. Why will the court do all this? The petitioner shall serve the hand summons on the respondent and also comply with the office objections during the course of the day. List this matter immediately after vacation.
Much obliged.
Serial number
Read
5.
it from caption dismissal. Yes, 5.
5. Giri Kumar SV.
Respondent bank.
Shetty. Vijay Shetty.
Intermod is complied with in this?
No, my lord.
Not complied. The present writ petition is filed. Questioning the demand notice dated 16/5/2024. And also to patch the possession notice dated 23/7/2024, issued by the second respondent bank. A coordinate bench of this court has granted an interim order on 23/8/2024 on the condition that the petitioner shall deposit 25% of the outstanding amount within 4 weeks from the day. When the matter came up on 11/11/2025 before this court, the learned counsel for the respondent bank on the day submitted that the interim order No, you said that on the day that interim order is complied.
Previous.
On the day it is submitted that the interim order is complied with.
Milord, interim order is complied.
It is submitted that the interim order is complied with by the petitioner. And it is submitted with the learned counsel for the petitioner that he wants to pay the amount and he'll get instructions. And accordingly, the matter was directed to be listed on 9/12/2025. On 9/12/2025, when the matter is listed before this court, there is no representation on behalf of the petitioner, as the matter is directed to be listed for dismissal today. In spite of the fact that the matter is listed for dismissal today, there is no representation on behalf of the petitioner. It appears that the petitioner is not interested to pursue the matter, dismissed for non-prosecution. Yes, 6.
Serial number 6. Kiran CR. KV Lokesh.
Yes.
Interim order is complied, my lords, but no amount is forthcoming thereafter. Yesterday it was there.
What is the outstanding amount?
Outstanding amount is almost 60 lakhs as on today, my lords. 50 lakhs, 56 lakhs as on the day of I issued demand notice in 2019.
What is the property mortgage?
Property mortgage is a residential building.
Ten lakhs is paid.
10 lakhs is paid. As on today, the due is 83 lakhs, almost 84 lakhs as on today.
Please come. An interim order was granted by a coordinate bench of this court on 28/10/2024. When counsel submits that the interim order is complied with. Matter came up on 9/12, no representation. As a matter is listed today, same order. Yes, dismissed.
Serial number 7. For order serial number 7, AM Venkatesh.
As a week's time.
Yes, please.
Week's time default order.
Lordship,
Your
Lordship, the driver of the R4 is a driver, my lord. The R5 and 6 are the owners, my lord.
So, I'm asking to comply with the order to pay the process.
Please.
Serial number 8.
A week's time default order. Yes, 8.
8. Memo
Appellant,
for
my
return
lord.
of LC.
But it's a case of injury, it can be dismissed.
My lord, we have not yet filed the wakalat, my lord.
No, what is this memo for return of TCR?
They have deposited the amount before the tribunal. LCR before this honorable court, they are unable to withdraw the amount, my lord. Climate, my lord.
Memo is filed seeking return of the TCR for the purpose of withdrawing the amount deposited. The registry shall return the TCR. Yes.
Serial number 9.
Appeal for the
Jagdish
appellant in this
HD.
case, ma'am. Permitted to withdraw the appeal, my lords. The owner appeal, I have deposited 25,000 before this court, my lords. Kindly refund the amount in the.
You're the owner of the vehicle.
Owner of the vehicle, my lords. I have settled.
The appeal is filed by the owner of the vehicle. And at the time of filing, an amount of rupees 50,000.
25,000.
25,000 is deposited before this court. A memo is filed seeking to withdraw the appeal. Appeal is dismissed or withdrawn. Registry is directed to return the amount
But in appellant in favor of appellant number 1, my lords.
in favor of appellant number 1.
Please.
Cell number 10. Cell number 10.
Let's appear for the appellant, my lords. Insurance company appeal challenging liability, my lords. The office has raised an objection regarding maintainability, my lords. Here, as on the date of accident, there was no valid policy, my lords. So the appeal is maintainable.
There is no policy.
Yes, my lords.
The land council, the office has raised the objection with regard to maintainability. As the amount that is awarded is less than 1 lakh.
Yes, ma'am.
Land council appearing for the appellant submits that as on the date of the accident, there is no policy. And when there is no policy, the insurance company is not liable to pay the compensation. As they're questioning the liability, the appeal is maintainable. The office objection with regard to the maintainability is overruled. Next, where is that IA? I number 2 of 25 on the same ground. Same. It is submitted that there is no policy as on the date of so and so. Considering the submission, they shall be stayed 50%, 4 weeks. Notice to the respondent.
Cell number
Yes,
11.
sir.
Om Shekaraya RP.
The respondent number 1 and 2, my lordship. I was supposed to file my objection, my lordship. My objection is ready. I have set it for signature, my lordship.
He has taken time.
So 1 week time,
After
maybe
hearing
next
that-
Tuesday, it may be posted on next Tuesday. I'll file my detailed objection as to MSME.
This is under MSME.
Preliminary
scheme, my
objection
lord.
is being filed today, my lordship. I'm serving a copy on the.
When have you filed your wakalat?
My lordship, 1 second. Wakalat. 5/4/2023, my lordship.
So you filed wakalat in 23.
Yes, ma'am.
And in 25, you asked for time for filing.
No, my
objection.
lordship, preliminary objection is ready. I am filing for preliminary objection as to.
How many
question of law.
objections are required?
My lordship, regarding MSME, a detailed objection is supposed to be filed, my lordship, in this.
No, that's what is the
as-
stand taken by him in the writ
Yes, my
petition.
lordship. We have sent it for
No,
approval,
as
my
per the
lordship.
writ
because-
rules now, can you file your objections now?
My lordship,
As per the writ rules, can you file the objection after 3 years?
no, my lordship. I pray for a short.
No, there should be
Next
some
week,
reasonableness.
my lordship, next Tuesday, I'll definitely file my objection.
How many times it comes up on 4/11? It comes up before that also on 15/7, 4/11, 10/11. Land counsel for the respondent shall file objections if any by the next date of hearing.
Yes,
This is matter on 25/11.
yes, my lordship.
How much time is given to you? 2 weeks time is given.
My lordship, one short accommodation.
You have an interim order?
No, my lord.
No, we'll grant
No.
interim order.
My lordship, in this, the sale certificate has also been issued, my lordship.
Now then
The
why are
property-
you not vigilant in pursuing the
My
matter?
lordship, previously on 25/11, we had sent for approval, my lordship, but till today, the documents are.
Because they are not sending, no, we will grant
My
the
lordship, no,
stay
my
of all further.
I apologize for not filing the objection, my lordship.
This is matter immediately after vacation.
My lord. Date, next week, my lord. Date.
Next week, it's not possible. There are so many matters coming up every day.
My
Yes,
interim order.
My lordship, no interim order may be
yes,
granted.
next.
Cell number 12. Number
Appearing for respondent, my
The
lordship.
copy served on them?
Yes, Your Honor.
Copy received, my lordship. Lordship, in this
Uh,
case, in 2020, interim order was
complied,
granted, my
Your
lordship.
Honor.
From 2022, my lordship, interim order granted, my lordship. Till
Yes.
now, they are not paid any EMI. Interim order complied by them, but they are not
Yeah,
paid.
interim order is complied, Your Honor, and he's ready to make the installment also, he's ready to make the
Only-
payment.
No, where is this question of ready to make 2022?
But bank is not
Why the,
giving any
why the
statement of
matter is
its funds,
pending
Your
here? Now, what is the relief you sought before this court? Let us see.
They are sought for.
Not to take the physical portion of the.
Why
Portion.
they shouldn't take?
He has paid, he has complied the order, Your
No,
Honor.
no, let's see. Let's see. We can't allow these kind of prayers before the court. Issue a writ of mandamus, grant an interim injunction in the present suit to restrain the respondent from all surface proceedings by staying the position notice. Why?
He has complied the order, Your Honor, and he has gone to
Not
the
about
bank
complying
and
with the
bank is,
order.
he's ready to say one-time settlement also, Your Honor. If the bank is ready, he's ready to make the one-time.
It's not about that. When you're filing a writ petition before the court, you should make out a legal ground. And what is this prayer? Can any order be granted like this? Issue a writ of mandamus to stay all further proceedings.
Bankers, I'm ready to settle the matter.
What is the outstanding amount?
Some 25 lakhs, in that 5 lakhs he has already
From
paid.
3 years
5 lakhs you have paid in
in 2022,
2022.
my lord.
And why should this court interfere in these kind of cases? You have borrowed the money. That's your responsibility to pay to the bank. And why should we interfere without any legal ground?
Give me a short date, Your Honor, then
I'm listing this matter on Monday. On Monday, I'll pass orders on the merits of the matter.
Please.
We can't pass orders like this. This is matter on Monday. No further adjournment.
Please, madam.
Yes, 13.
13. Gangadharappa, C for petitioner.
My lord, in this, I have filed the application for vacating the stay, my
Yes.
lord. My lord, this is the third round of litigation. In the
No, let
earlier
him
petition, my lord,
argue first. What is the writ petition about?
my lord, writ petition, they have challenged the section 14 order.
So 14 order.
Yes. On what ground?
Possession notice was not served on me.
Huh?
Possession notice was not served on me.
Hmm.
That's ground I have to,
That's the only ground.
yes. Interim order also completed. Maybe
What is the outstanding amount?
My lord, as on today, 2 crores 20 lakhs 996.72 rupees.
What is
And
interim
only
order?
7.5 lakhs has been paid as per the interim order. My lord, one more fact, my lord, in the earlier writ petition, 2228 of 2023,
One
the
minute,
same 228 of 2023. The same order which is challenged in this writ petition was challenged there also. There was an order to pay the 30% of the outstanding amount that was not complied. The writ petition attained finality and we were permitted to take the physical possession, my lord. Later on, my lord, they will come up with the ground that in this writ petition, the possession notice is served. Only on that, and then the interim order was granted. Later on, time was extended. We had taken the physical possession also, my lord. And then now only 7.5 lakhs have been paid. Thereafter, they have not come forward to pay 1 rupee also.
I pleaded in earlier writ petition filed by me, page number 8, Your Honor. The respondent bank has issued a notice.
No, possession notice is not served or you're agreed by any of the proceedings on 13-4. Go before the RT. Why should this court interfere? And for an outstanding of 2.5 crores, why should there be a stay on 7 lakhs?
Within 2 months, I regularize the account or close the account. Permit me to.
For that, you have to go before the tribunal.
Liberty
We will
to
not
be made.
consider. You've been enjoying the stay for just like that. Earlier at petition 23, now 24. Why the court is coming in the way of the bank without any reason?
Oh, yeah,
We can't entertain
I
this
paid
kind of
entire amount
petition.
within 2 months, 2-3 months. On or before March 31st, I close the entire loan account. My
File an
submission.
affidavit then.
Yes, sir.
File an affidavit.
Monday.
File an affidavit. Undertaking affidavit.
I consent by party.
I'll list this matter on Monday. By Monday, if undertaking affidavit is not filed, that by February you are going to pay the entire outstanding amount. I will on Monday itself, I'll dismiss this writ petition.
Tuesday.
Then counsel for the petitioner submits that what the entire outstanding amount they're ready to pay by February. And in that regard,
On or before.
On or before?
March 31st.
On or before March 31st.
2 crore.
The petitioner shall file an affidavit before this court in that regard. If the affidavit is not filed by Monday, the affidavit shall be filed by Monday, giving a copy to the counsel for the matter will come on Tuesday. Shall be filed by Monday by serving the advance copy on the counsel for the respondent bank. List this matter on Tuesday. If the undertaking affidavit is not filed, this court will not hear any further arguments and the writ petition will be dismissed on the ground. Yes.
2.25. My respondent counsel submit that outstanding is 2.25 crore. That amount may be.
Is it correct?
My lord,
Or you want to get
that I will
Inform him.
inform.
Yes.
Cell number 14, HR Sunil Kumar, Vijay S for respondent.
My lord, I have filed
interim order earlier, in all the matters, wherever, yes.
My lord, I have filed a revised affidavit, ma'am. My lord, after deducting I have paid a day before yesterday, I have paid 10 lakhs before this honorable court, my
Oh,
lord.
that affidavit is filed. Where is
Revised
it?
affidavit I have filed yesterday.
Where is it?
After payment of 10 lakhs, my lord, the dues is as on that day is 27 lakhs to 12,150.
You have the copy of it?
Yes, ma'am.
Copy of the affidavit.
I'm ready to close the loan on or before
Let's
31st
read
March.
your, I submit that, read paragraph 3 of your affidavit.
I submit that I have handed over a DD for rupees 10 lakhs. I submit that after deducting the said sum of rupees 10 lakhs from the balance payable by me, as per the statement furnished by the respondent, I am liable to pay 27 lakhs 12,150. I submit that after taking physical possession of the property, I and my family members are taking shelter in my friend's house. I submit that my daughter gave birth a new child and I have no alternative accommodation for me and my family. I submit that I am ready to close.
Yes,
the
Mr. So that deliver the position of the property.
My lord, we are taken 4 rental houses, one petitioner house. We will go. We are taking 4 rental houses, one petitioner house. My lord. We will hand over one whatever
Yes,
the
wherever
petitioner.
he is
My
staying.
lord, please, ma'am, because
After the full
she's a
settlement, we
single
will
lady,
give
my
for,
lord.
rental
She
houses.
has no income. She is depending upon this rental income only.
All
Anyhow,
rental
my
houses
lord,
are
As
leased
per
in the.
redelivery of the possession. Now you said that she's they're staying somewhere in the friend's house. As far as for your residence purpose, wherever you want, which house, that will be, the portion will be redelivered.
My lord,
And on 28 to 2026, when you pay 31/3/2026, when you pay the remaining
my
amount,
lord,
they will redeliver
she
all
doesn't
the
have,
houses.
please, my lord, she doesn't have any income, my lord. She depends on this rental income only.
How much how much income you derive from that property?
My lord, 3 premises she has let out a rent. Out of that, she is getting around 10 to 12,000 per month.
That powder we can't pass. If you want, I'll ask them, as far as the house which you are residing, that portion they will redeliver.
My lord, they can't do anything because they cannot sell the property, the rental premises. If they wanted to sell the property, entire property, they have to sell. Keeping the rental premises, there is no use for the bank, my lord. Anyhow, my lord, I have filed and I'm undertaking a private to close the loan account before March. If I am deviated in any installments, my lord, I have no objection to take possession of the property by the bank. I will give voluntary the possession.
Please come.
They can't proceed against the rental premises, my lord.
The present petition is filed, seeking the following prayer, extract the prayer. On 26/3/2025, a coordinate bench of this court has passed an order whereby directing the petitioner to deposit 20% of the amount within 6 weeks from the date of order. The first chunk of 10% shall be deposited within 3 weeks, and the second chunk of 10% shall be deposited within 3 weeks. When the matter came up on 3/12/2025, for the first time you paid on that day, the DD.
Yes, my lord.
On 3/12. On 3/12/2025, the petitioner had handed over a DD for an amount of rupees 10 lakh to the respondent counsel appearing for the bank. On the day, it is stated that he'll come up with an affidavit that when he'll be paying the remaining amount. No, on 8/12, that is handed over. 8/12. The bank has furnished the particulars about the outstanding, and according to the bank, the outstanding is an amount of rupees. How much?
27
After deducting the 10 lakhs, my lord,
After
27 lakhs,
deducting 10 lakhs, the outstanding is 27 lakhs.
12,150.
12,140. It is stated that The bank has taken physical possession of the property and the family members are taking shelter in a friend's house. And the petitioner's daughter gave birth to a child and he has no alternate, and the petitioner has no alternative accommodation for her and the family. It is stated that they are ready to close the loan amount on or before 31/3/2026. They'll pay an amount of rupees 6 lakhs on 31/12/2025, an amount of rupees 9 lakhs on 28/2/2025, remaining balance of rupees 12,12,150 on or before 31/3/2026.
9 lakhs, 26 on or before 28 to
So
2006.
6 lakhs on or before 31/12, 9 lakhs on or before 28/2, and 12 lakhs 12,150 on or before 31/3.
With
It
applicable
is
interest.
stated that in case of any default in payment of the amount, the respondent bank can take the position. It is stated that in view of the undertaking filed by the petitioner, the position may be redelivered to the petitioner. Learned counsel appearing for the respondent bank submits that there are four
rental houses.
four houses. As far as the house where the petitioner is residing, the bank is ready to redeliver the possession. But for the other premises, the position will continue with the bank. In response to that, land counsel appearing for the petitioner submits that even if the respondent bank wants to sell the property, they cannot sell the same independently. And as the petitioner has already given an undertaking that if he defaults in paying the amount, the bank can take the portion of the property. There may be a direction to the bank to redeliver the possession. Next para. Having heard the counsels on either side, what is the material on record? This court has perused the affidavit that is filed before this court, where he has undertaken to pay the entire amount by 31/3/2026, and the schedule is also given. Considering the affidavit and the fact that is a residential premises, this court deems it appropriate to pass the following order. 1. The petitioner shall pay the amount, whatever that 6,000, again in the point number 1. So if there is any default of the amount, any one installment, the bank is always at liberty to take possession of the property. Considering the affidavit that is filed, the bank shall immediately redeliver the possession of the property. Yes. Disposed of. Next.
Cell number
Achha,
15.
Appearing to the
Balaji Harish.
respondent bank. My lord, this is a petition by the tenant.
I appear for the
Lord, and he's been enjoying the stay for the last 3-4 months from April. Lord, and they
May I
are
just make my
relying on
submission, my
the
lords?
unregistered.
May I make my
unregistered
submission,
lease.
my lords?
My lord, one.
Yes.
I appear for the petitioner in this matter, my lord. This petition has been filed by me seeking to quash the auction notice that has been issued by the respondent number 1 bank. I am in occupation of the premises and I am running a ITI college out of the said premises, my lords. My lords may kindly see my prayers at
When is
page
interim
number.
order?
The auction of the property has been stayed by the interim order, my lords.
Returnable by 11/6. There shall be an interim order of stay as prayed for till the next date of hearing.
Auction was stayed, my lord. Auction conducted by the bank was stayed, but he's a tenant, my lord. The dues are more than 1 crore, unregistered agreement. And my lord,
My
they
lord,
have to
may
be
I see-
adjudicated by in DRT under section 17(4)(a). They have no
My lord, may
right
see-
here.
My lord, may see page 14 of the petition, my lord. Just my prayers, my lord. I am not coming in way of the auction, my lord. The prayers may be found at page 14, paragraph 20, my lords. I am seeking that the auction notice issued on 26/3/2025 be set aside and a fresh auction giving notice to me and including the details of my possession to the potential auction purchasers, a fresh auction notice be published in that, including all my details. That is my only relief.
That the
madam.
auction was not conducted.
No, because of the interim stay, it was on 2/5,
So
so
then we will-
6/5.
No, we will set aside because this repetition becomes infructuous.
Yes, my lord. Prayer is
As the
infructuous.
auction could not be conducted.
Yes, my lord.
We will leave it open to the bank to proceed in accordance with.
Yes, my lord, but then they are claiming in respect of B and C, their tenancy has to be adjudicated by DRT.
No, nothing, no order I'm passing.
Yes, my lord.
That day, the auction, you couldn't conduct the auction. This
Yes, my
petition
lord.
has become infructuous.
Yes.
In accordance with law, you proceed. If he is agreed, he'll go to the DRT.
Let them go to DRT. Yes, my lord.
Yes,
This may be
please
disposed
come.
of. Yes, my lord.
The present writ petition is filed, seeking the following prayer. Extract the prayer. The brief facts of the case are: the petitioner is a trust established through a trust deed executed and registered under provisions of the Trust Act on 29/6/2011 in the Sub-Registrar's Office, Channapatna Town, Ramnagara District.
No, my lord, it's not registered, my lord. It's not a registered lease agreement. This is the trust deed, my lord.
I'm saying about a trust deed,
Yes.
not the lease.
Yes, yes, yes.
The second respondent is the owner of the property. The second respondent has restored the property to the respondent on 4/5/2023. As the second respondent has defaulted in paying the amount, as he has availed the loan from the bank has initiated the proceedings under the Surface Act. On 5/4/2025, it is stated that on 5/4/2025, it came to the notice of the petitioner that the first respondent issued an e-auction notice dated 26/3/2025 in respect of the scheduled property from which the institute is currently operating. It is the case that the first respondent did not provide any notice to the petitioner, and the said e-auction notice also fails to disclose the fact that the institute is being operated by the petitioner from part of the property that is set to be auctioned. He has approached the bank on 7/4/2025 with a written representation to this effect. And he has requested the bank to modify the auction notice to include the fact that the petitioner is a legal possessor of the scheduled property and include a condition that the petitioner be allowed to continue to operate the institution therefrom in the event of sale. It is the grievance of the petitioner that the petitioner's concerns were not addressed by the respondent bank, which compelled him to come before this court. A coordinate bench of this court on
2/5, my lord. 2/5.
yes, on 2/5/2025 has granted interim order of stay as prayed for till the next date of hearing. It is submitted by the land counsel for the respondent that in view of the said order, the bank would not conduct the auction on that day. It is submitted that if the petitioner is agreed with the auction notice and if he has any right, enforceable right, the remedy available to him to approach the DRT, but he cannot come before the court. It is submitted that the lease rental agreement is an unregistered one. And without any legal right, petitioner could stall the proceedings right from 2/5/2025. As such, the writ petition needs to be dismissed.
Pending it.
Land counsel for the petitioner submits that he is entitled for a notice if as the auction was not conducted on the day, the respondent bank can conduct the auction and they should follow the procedure, and in accordance with law they can conduct the auction. Next, having heard the consensus on either side, this is the material on record. The petitioner is a tenant Second respondent is a borrower. As the second respondent there was a default, the petitioner bank, the first respondent bank has initiated the proceedings under the Surface Act. If the petitioner is aggrieved by any of the proceedings that are initiated by the bank, he could have approached the DRT where he has an effective and alternative remedy. In this case, the petitioner's lease deed is an unregistered lease deed. Be that as it may, or if the petitioner has any legal right to enforce, the remedy is before the DRT. The present writ petition is filed questioning the e-auction notice. In view of the interim order passed by this court, the e-auction could not take place. Hence, the writ petition has become infructuous. Accordingly, this court is passing the following order. The writ petition has been the writ petition is dismissed as infructuous, giving liberty to the petitioner to avail the appropriate remedies in case of any action. Yes.
Cell number 16.
In this case, my lord, I represent the petitioner. I had filed the affidavit of undertaking, my lord, as per the direction of this honorable court.
My lord,
Along
now-
with that, my lord,
Now they have served it, my lord.
my lord, I was not having her number, my lord.
Yes.
It's all right. My lord, now they have undertaken to pay on or before 25/12/2025 first installment. Second, it follows January and February, my lord. My lord, now the position has been taken already. And on the payment of first installment only, they'll be entitled for the position. My
I'm
lord,
not-
and then
I consider that, my lord.
tenants are there. They have to give an undertaking. If the second installment is not paid, they will voluntarily vacate the premises and hand it.
That's not
hand
so
over.
in this. They didn't
No,
say
no,
so.
my lord, they have
My
not.
my lord, the installments will be paid as per the time.
No. What she is saying is the first
My
installment
lord, we
is in the
can, we
month of
cannot
December.
assume about the second installment unless the first
My lord, we
installment is
should have
complied.
the,
No. What she is saying is if you fail to pay any of the installment, you should voluntarily give portion to them. That should be there in the affidavit. She is fair in
That
Please,
I'll include, my lord. Apart from that, my lord,
Tuesday.
apart from that, I had filed one more application, my lord, seeking to amend the prayer. I need to include one more prayer, my lord, that has also been
What is the
filed. My lord, the prayer is to declare that the e-auction held on 26/11, my lord, in spite of in violation of the interim order of this honorable court, is also now should be declared as null and void. To that extent, my lord, I had filed
the payment, we will not go ahead with it at all.
my lord,
And then
that
please
is
come
that
up
is
with your-
imperative.
We will
But
see.
but
Please
my lord,
come up with this affidavit. Learn counsel for the petitioner submits that he has filed an affidavit before this court undertaking to clear the entire amount by February.
February
Yes, ma'am.
25 to
25 to
2026.
2026. Learn counsel appearing for the respondent submits that they have already taken the possession. If the petitioner pays the first installment, once the petitioner pays the first installment by December 20,
25/12. they have
25
undertaken.
on or before 25.
then they will redeliver the portion of the property. And if there is if the petitioner, the other installments of January or February, if the petitioner fails to pay, he shall give an undertaking that he will voluntarily surrender the portion to the bank. The next, the petitioner shall file a affidavit in that regard. List this matter on Tuesday.
Cell number
My
17.
lord, my application also may be recorded.
That they will see.
That may be recorded, my lord.
That I will see on that day when the
No, it's already filed. It's already filed. my lord.
We will see on that.
Please.
Yes, 17.
Cell number 17. Girish, Ajay, Atulyan.
Appealing for the petitioner, Lordship.
Yes.
1 week accommodation, Lordship. I have to try to contact the client, Lordship. He is unable to.
About what? What accommodation?
Lordship, 1 week accommodation. We have challenged the order of.
Unappears for the
petition
petitioner,
notice
office is
issued by
directed to
the.
list this petition. What is that you are questioning? What is the impugned?
Impugned is the position notice, my Lordship. At page.
What is wrong with that?
Lordship.
What is wrong with the possession notice?
Lordship,
Why are you before this court?
I instructed to my client to deposit some amount, Lordship.
No, some amount. What is some amount?
Lord, the
You
last,
should make out a legal ground coming before this court. We will not grant any order like on some amount. You have to make out a legal ground. Why are you before this court? And if you are ready to pay the amount, if you file an undertaking, I'll dispose of the writ petition. Only two ways.
that's why, Lordship, I sought 1 week time to contact my
Why,
client.
from when this matter is pending?
My lord, it will
When the
be-
matter comes up before the court, you will not appear. This is on 24/9/2025.
No, Lordship, my mother is
This is a
not,
matter on Wednesday, no further time will be
my
granted.
mother is not well, my lord. Subsequently, she expired, my lord.
Anyway,
That's-
Wednesday,
She's in hospital. That's why last date I have not appeared.
Wednesday.
Wednesday.
Cell number
Yes.
18. Kalleshappa case for petitioner KV Lokesh.
My lord, appearing for appellant's counsel as proxy, my lord, I've been informed that the account is closed, my lord.
Account is closed.
Yes, account is closed.
What is the writ petition about?
But they've not furnished the petition copy also. 28130 of 2025. They've challenged the possession notice, my lord.
No representation for dismissal tomorrow. So that let him come and say.
Great.
Just next.
Tell.
Lord, I had filed an application, I had filed a memo for deletion, my lord, even the amendment petition is also filed. My lord, this is a 13B petition I had filed it before the family court, my lord. My lord, lordship can kindly see that page 22, my lord, the order passed. My lord, the dispense, 6 months
First of all, memo
dispensary
is
statutory
filed seeking
representation is
deletion of
also
R1 and,
filed.
R2.
My lord, only ground, my lord, instead of sending the matter to the mediation center, my lord, the learned judge has passed an order that directed me to produce the parents of the petitioners, my lord.
Let's see that, where is that order?
My lord, page 22, my lord,
20.
for appearance of the parties and their parents for conciliation. Along with the hair photo ID, he is on 28.
When was
My lord,
this order passed?
28/10/2025. Again, my lord, the same order, same page, my lord, asked for it.
No, you're
Petitioners
agreed-
and the councils.
No, you're agreed by the order of the court.
My lord, what had happened in the 13B is already filed. My lord, matter has to be sent to the mediation center for the reporting of conciliation. In spite of that, my lord, this is second round, my lord, the learned judge says to present the parents of both the parties. My lord, petitioner's parents, my lord, they stay in a remote village. 2018 was a marriage. Both are majors.
I think now she's not insisting. Earlier she was
No,
insisting
it's
like
the
that.
second round also same thing. My lordship can kindly see me. List on to comply
Have this
the.
matter tomorrow. We'll have this matter tomorrow. Yes, Anika. Give this copy to the R&S. Yes.
Cell number 19 tomorrow. Cell number 20. Arjun Rao for petitioner.
Lord, 20, I may be permitted to appear for the petitioner's
This
counsel.
maintainability of writ petition
Lord,
before this.
Lord, this order is passed by DRT 1 Chennai. I think the office has raised an objection as to how this writ petition comes here. Could your lordship kindly take, there was a notification in 2022. Court officer. All matters above 100 crores relating to DRT Bangalore were transferred to Chennai. Please look at page 3, my lord. Excuse me. DRT 1 Chennai, jurisdiction, column number 5. All applications involving debt amounts of 100 crores and above, if otherwise falling under the jurisdiction of DRT so-and-so, Madurai, then the last but one line, DRT Bangalore. So the DRT Bangalore matters above 100 crores are going to Chennai, my lord. Therefore, the writ petition will lie here. This is my first submission. And my lord, there are 4 other writ petitions that have been filed by the same parties, my lord. And they are pending before this court. I'll give your lordships the numbers also. This is the first objection.
Objection with
My lord,
regard to the maintainability is overruled. Yes.
my lord, what has happened in this matter is, my lord, there is a company that took a loan. They are the principal borrowers. They took a loan. My lord, my husband, late husband, my lord, he was the owner of Coffee Day. My lord, he was the guarantor for that loan. Lord, he died. Therefore, I am now being prosecuted as the LRs of the deceased corporate guarantor. What has happened is the company that borrowed the loan went into liquidation. And before NCLT, my lord, the CIRP process was initiated and the order is passed, my lord, at annexure C at page 92. Order dated 10/3/2021.
What is impugned in this?
I'll tell you, Lordship. My lord,
Let's see
the borrower has gone into liquidation. The borrower's assets have been taken over by the resolution professional. The resolution professional has held an auction, and my lord, the successful resolution applicant is now in charge of the property. Now, the borrower files an application before DRT saying now that the resolution professional is seized of the matter and the debt is due from the bank to the bank is being paid by the resolution professional, release me from the property, from the proceedings. Please look at page 204. Bank application is filed before DRT by the borrower. 204. Be pleased to strike out the applicant, namely first defendant, from the array of
Company matter is before NCLT or the company court?
Pardon?
The company matter is before the
Over.
NCLT or?
Over. Before NCLT, it was closed. Approving the resolution plan at page 109. So now, my lord, an application is filed at 204. And order comes to be filed at page 208, releasing the borrower, my lord. Please look at 208. This is 12/6/2024. This is an IA filed by D1, that is the borrower, for deletion of his name. Learned counsel for the applicant bank submits no relief is sought against D1. A memo is filed to that effect. The said memo at so-and-so has made. Next paragraph. Considering that no relief is sought against D1, the same stands allowed and the applicant bank is directed to round off defendant number 1 in the cost head. Now, if the borrower has gone, where is the question of prosecuting me?
You are
I'm the guarantor. I'm the guarantor. The borrower has been released because in NCLT, the principal borrower has gone into liquidation. The assets have been now taken over by a successful resolution applicant. Now, your lordship may kindly look at section 133 of the Contract Act. Section 133 of the Contract Act.
Then we'll issue notice to the respondent.
You know what it says, just 1 minute, your lordship. It's at page 19 of the writ petition. Ink page 19, para 27. I have extracted it.
Yes.
If the principal borrower and the creditor compromise, then the surety is discharged. Your lordship may look at any variance made without the surety's consent in the terms of contract between the principal debtor and the creditor discharges the surety as to transactions. Now he has gone out of the picture. Who principal borrower? Where is the question of prosecuting me, my lord? Therefore, I said, please close the proceedings. I have said, and the application is rejected, my lord. Therefore, I am now in before. Your lordship may issue notice till then, my lord, because the matter is on reopening day. Till then, your lordship may protect my interest, my lord. Wife and children are there, my lord. That's why.
No. What is the action that they're going to take now?
They will proceed against me to attach my properties. Because I am the only person remaining now. Because the borrower has gone, his name is rounded off.
So which is the respondent? Bank of Baroda.
Bank of
Who
Baroda.
appears for Bank of Baroda? Vignesh Shetty appear? You take notice. Mr. Vignesh Shetty is directed to take notice on behalf of the bank. List this matter on Monday. He'll get instructions. We will see.
Tuesday, my lord. Tuesday.
Cell number
No
20.
papers on it. Yes. 21.
Cell number 21.
I appeal for the
Bharat.
petition. Whereas the issuance of notice under section 13(4) is challenged this writ petition. Whereas the liability towards the respondent is not disputed, my lords. Up to February 2025, I was very regular in payment of EMIs, my lords. But afterwards, my lords, I had to close my business.
What is the outstanding?
Whereas 1,12,32,000, my lords.
Take out, please take out hand summons on the respondent.
My lords, I'll take the notice to the respondent.
You
Please,
appear?
Suresh, yes, ma'am.
What are your instructions?
Kindly direct them, furnish the copy, my lords. I'll take them.
Serve a copy on them.
Please, my lords.
And counsel the petition, serve a copy of the writ petition on the council. What is the council's name?
Please, Suresh.
Please, Suresh, appearing for the respondent. List this matter on Wednesday. Yes.
Cell number 22.
My lord.
Cell number 22. Ashok Kumar Shetty.
My lord. The petition is filed by the auction purchaser, my lord, challenging the forfeiting of the bid amount, my lord. The auction purchaser is ready to pay the entire amount because, my lord, immediately what happened? Immediately he approached the cooperative society for loan. So the cooperative society has sanctioned the loan but not transferred the amount to the bank. Therefore, he is unable to pay the
When was the
balance.
auction?
Auctions was on 26/6/2025.
26?
6/2025. Bid amount paid was 4 lakhs rupees. Immediately he paid another balancing of 6,10,000. That is a 25%.
What is the bid amount?
Bid amount is 40 lakhs 40,000.
40 lakhs, 40,000.
40,000.
Oh.
Another 30 lakhs 30,000 I have to pay my.
When is, it is on 26?
Immediately I have given a representations for extension of time. That was not considered. Thereafter, my lord, the order has.
How can
came
this
to-
court compel them to give time to you? It's for the
My lord,
bank.
I am ready to pay the amount, my lord. I
It's
will.
not question of ready or ready to
Right.
pay the amount. We are in the month of December,
Yes,
6
ma'am.
months. What is the time for
My
payment
lord,
of amount?
meanwhile, may I given the representation, my lord, the negotiation
Take out
is
notice,
going
I'm
on,
not
my lord.
inclined to-
Imme-
The petitioner, list this matter. Which is this bank?
It is a Union Bank of India, my lord.
Union Bank of India, who appears? You appear?
My lord, in the meanwhile, my lord,
No, meanwhile.
I will deposit entire amount, my lord, in the next week only.
I'll not pass those kind of orders without hearing the bank. List this matter next Wednesday. Mr. Vignesh Shetty is directed to take
Let us
notice. Serve papers on him.
Let us permit, my lord, to deposit the entire balance consideration within a week, my lord.
Yes, 23.
23. Anupam Agarwal.
Your Lordship, appearing for the petitioner.
Yes.
Your
And
Lordship.
in all the matters, wherever there is office objections, shall be complied with within 1 week. Default order. Yes.
Your Lordship, the petitioner has purchased this property, this flat, in the year.
What is the impugned order before this?
Your Lordship, the respondent number 1 has pasted one possession notice on the flat of the petitioner. Your Lordship, this matter is not related to, in which the petitioner is not the borrower from the respondent number 1. Your Lordship, the petitioner has purchased this flat.
Who appears for this?
Piramal.
Piramal, who appears?
Lordship, I don't know.
Piramal Finance Limited.
Take out hand summons.
Your Lordship, there is an urgency in this matter in which I seek for a interim order. Reason is that
Without hearing the respondent bank, I will not pass any
Your
orders.
Lordship,
If you can take hand summons, I can take immediately.
Your Lordship,
any day.
as per the possession notice which has been given by the respondent number 1, they have got an order from the CJM. Your Lordship, kindly request Your Lordship to see some of the papers and documents in which Your Lordship will be convinced that the petitioner is the genuine buyer of the property. Now, what has happened? Petitioner has purchased this property from the respondent number 224 by taking a loan from a bank, LIC bank, for which I have produced the document also. And the sale did happen in the year 15 March 2019. From then he was enjoying the property, and even the LIC has granted a loan of 35 lakhs. And he has been serving and paying the EMIs regularly. All of a sudden, on 3rd December 2025, last week, the respondent number 1 comes to the door of the petitioner and pastes this possession notice, alleging that there is another borrower by the name respondent number 6, who has taken a loan of,
From whom you have purchased the property?
I have purchased from respondent number 3 to 5. I have made them also the party.
Please take out notice.
Your Lordship, interim order is required, Your Lordship. Your Lordship, please.
I will have this matter on Wednesday.
Your Lordship,
by the time you serve the hand
Your
summons.
Lordship, this matter is not concerning to one person. There are 4 more people, similar cause,
Others are elected, like
similar
respondent
cause
bank.
of action, in which Your Lordship can see that there is a clear discrepancy in even the property number also. Your Lordship,
But we will see, unless the respondent comes,
Your Lordship,
I can't take
interim
whatever you say
protection
for
has
granted.
to be granted, Your Lordship.
This matter on Wednesday by the
Your
time
Lordship,
the petition
my
has served the
possession term is
summons
getting.
on the council, on the respondent.
Your Lordship, my time is getting over. They have already taken possession based on this or this kind of order in one of the other matter which is there in the listed today, Your Lordship. Your Lordship, kindly, Your Lordship, I praise Your Lordship, just look into the matter, Your Lordship. Page number 30, Your Lordship. Page number 30. Your Lordship, even there, Your Lordship can see there is a clear collusion between the respondent number 1.
I'm saying, even if you serve the hand summons today, I will take up the matter tomorrow. So can't it wait till tomorrow?
Your Lordship, that they have already told.
They will take, it's a symbolic position.
No, they are taking physical possession, Your Lordship.
We'll see. I will not interfere with
Your
that.
Lordship, they are taking the physical possession. In one of the serial number which is listed, in that they have already taken the physical possession. Even after I am producing that, I am having the registered sale deed. My entry is mentioned even in the encumbrance certificate. I am paying the society maintenance from the last 5 years.
I will direct them to redeliver the position to you on Wednesday if you say that all these. So first, let me hear the other side. The petition is permitted to take out hand summons on the respondent and file a memo to that effect. If the memo is filed, list the matter on Wednesday.
Your Lordship, at least an interim stay, Your Lordship, is required, Your Lordship, because petitioner is staying there, Your Lordship. Your Lordship can understand, Your Lordship, if no protection is granted tomorrow itself, they will, because they have taken a similar way, they have taken the property in possession. Your Lordship, it becomes huge hardship for the petitioner, and matter is not related to one person, Your Lordship. There are 4 more matters. Even the next matter is like that only, where there is a collusion between the other people. Now, I am being a genuine buyer. Even the Transfer of Property Act also provides me a guarantee and a protection that a genuine buyer who has
all the submissions you are making, I can appreciate only when the respondent is before the court.
Your Lordship, I agree to that, Your Lordship. I am just seeking an interim protection for at least one way, at least till
I will
next.
take it up the day after tomorrow. Please come, please serve the hand summons.
Yes, Your Lordship.
Yes, day after tomorrow. I will not grant any.
Your Lordship, if tomorrow if they come and take the position, Your Lordship.
Then I will take it up tomorrow, serve the hand summons.
Your Lordship, how will I come
Then
when they come in during the daytime, Your
I'll not
Lordship?
entertain
Your Lordship, at least a
No.
kind consideration may be given for a interim. I am not seeking a interim order forever. I'm just seeking saying that at least a coercive action should not.
Oh, why the bank will take action against the property if the property, you have purchased the property from R3. If R3 has mortgaged this property to the bank, without the mortgage, you purchase the property, will you become a
no, Your Lordship,
the
Your
bona fide
Lordship,
purchaser?
no, Your Lordship. I mentioned, I come to the point again, Your Lordship. This story is little different. Here, Your Lordship needs some kind of attention. Lordship, I have purchased this property with the bank loan of LIC, who happens to be respondent number 2, by taking a loan of 35 lakhs. My entries are there in the sale deed as well as in the encumbrance certificate. Your Lordship, kindly listen to this.
Yes, I'm listening.
Okay. After this, the respondent number 3 to 5, who happens to be landowner and developers, they have entered another sale agreement with a person by name, in this case, Zafir Ullah, who happens to be respondent number 6 in this case. Your Lordship, understand the modus operandi. They have the respondent 3 to 5. What I understand from all the transaction is that they have done only a unregistered sale agreement, and they have made them also a party to the sale. And based on that sale, the property, the respondent number Piramal, has lended the money to this person, respondent number 6. This is not a case of classic case of where the landowner has taken the project loan. Landowner has done a double sale, and the Piramal has funded that project, that double sale through him. Your Lordship, I have taken the entry from 2019. And Your Lordship can see that the collusion can be visible very clearly. Your Lordship, just your kind attention. Page number 30. What they have done, they have made this flat number. If my flat number is 308, what they have done, they have taken the flat number as G308, adding a prefix. So Your Lordship, there is a clear collusion and some kind of kickback, whatever it is, in which the because of the mistake or the fault or the this of the respondent number 1, because it was the duty of the respondent number 1, the bank also, to do a proper due diligence. Your Lordship, I produced to Your Lordship the sanction plan also and the brochure also.
Not, yes.
Your Lordship, in that sanction plan also, there is no mentioning of prefix G308 like that. Only simple number 08, 108, 208. Your Lordship, even the brochure also I am producing, which I came to know after filing of the petition.
When the possession notice was affixed on the premises?
3rd of December 2025. And based on this one, in this case, they have at least done a prefix of the possession notice, not possession, saying that vacate and I am coming after 7 days to take the physical possession. Your Lordship can see, they have clearly mentioned that they are going to take the physical possession. This is not symbolic possession which they have come for. They are taking the physical possession. And Your Lordship, in one of the other matter.
No, first you restrict your arguments to this.
This year, okay, the other bank has taken the possession by this moving the all the people and seizing the property also. At least I had some option to come before this honorable court, and I have done no delay in filing this writ petition also. Your Lordship, this case requires a immediate attention, at least in the form of interim prayer. Otherwise, Your Lordship, once the possession goes, Your Lordship knows what is the rule process of taking back from possession. And moreover, it will again goes into multiple form of litigation, because Your Lordship may say that, okay, respondent number 1 is
The residential property.
it's a residential property.
This is matter on Monday till such time.
Your Lordship,
Respondent
I
will
am
not take any coercive steps. If by Monday the hand summons are not served, on the list is matter on Tuesday. If by Monday the hand summons shall be served and memo shall be filed, otherwise the stay will be vacated on Tuesday.
Your Lordship,
This is
I am
matter
not
on Tuesday.
available on Monday and Tuesday, maybe listed on. I'm not, if required, I can.
I think you can't bargain for all this. You want an interim order, you have to stick to what the court says.
I stick to
Yes.
that.
Serial number 24.
Your Lordship, it is the same matter, same connected matter.
Yes, this also. And office objection shall be complied by Monday, or else the writ petition shall be dismissed on that ground. Yes, both the matters.
Serial number 25.
Your Lordship, there is another which has come in the later part of the list, 58 and 60. 58 and 60. Serial number 58.
All these matters together on Tuesday.
58 and 60.
Yeah, Lordship, in this 58, the possession is already taken by the bank.
So no interim order is required in 58.
Your Lordship, they may sell the property, Your Lordship.
Please don't, 58, no interim order is required. What about 60?
60, no.
Yes. 58, only 60 and these two matters, same order. In all the matters, objections to be complied with. List the matter on Tuesday. By Monday, memo has to be filed. If the memo is not filed serving the hand summons, I'll vacate the order on Tuesday. Yes, next.
Your Lordship, Wednesday, because I am not there, Your Lordship, just 1 day accommodation.
Yes, Wednesday.
Wednesday. Thank you, Lordship.
Oh. Yes.
Serial number 25.
My lord, this is IA for
Rajshekar
recalling the
S.
order. IA for recalling the order, my lord. My lord,
What recall?
On 4/8/25, my lord, there was an order to comply the office objection within 2 weeks, my lord.
Then why have we not complied with?
My lord, there was a delay in complying the office objection. By the time we complied, it was a conditional order, my lord.
IA number 1 of, IA number 2 of 25 is filed. IA number 3 of 25 is filed to recall the order dated 4/8/2025. IA number 2 of 25 is filed to condone the delay of 88 days in filing the recalling application. The coordinate bench of this court on 4/8/2025 has passed an order granting 2 weeks' time for complying with the objections. It is submitted that due to oversight, the same could not be complied with. Hence, the present application is filed, considering the reasons stated. The delay of 88 days is condoned, and I number 2 of 25 is allowed consequentially. I number 3 of 25 is allowed by recalling the order dated 4/8/2025. The petitioner shall comply with the office objections.
Complied, my lord.
Already complied. It
Already
is submitted that the office objections are already complied. Yes, next.
My lord,
Notice to the respondent.
My lord,
For 26,
my lord, can you give the date for next week, my lord? Because attachment warrant has already been issued in this case and stay is not granted, my lord. So
Where is the IA?
IA 1 of 25, my lord.
Is it a case of death or injury?
Injury, my lord.
How much is the amount granted?
10,58,288.
You are on what ground before this court?
My lord, he was only a year away from his retirement, my lord, but his future prospects, the earning capacity and all.
So admitted amounts are how much?
My lord,
Do that exercise. Pass over. Yes, next.
number 26,
Appeal for the appellant,
Twenty-six.
appeal by the corporation on case of injury. The appeal has been filed on challenging the question of negligence as well as the quantum. The doctor who has treated that claimant has said there is no disability. Then the claimant examined another doctor, private doctor, who has stated there is disability of 15% to the whole body. The tribunal, by relying on the evidence of a subsequent doctor, 4,30,141 has been awarded towards loss of future earning capacity.
How much is the total compensation?
Total compensation 7,33,291.
What is the admitted amounts?
Yes, ma'am.
What is, according to you, how much is the compensation?
Because he is not entitled for future loss of earning, 4,30,141.
So you admitted is only 3 lakhs.
3,33,000.
3 lakhs?
3 lakh, ma'am.
It is submitted that the court, when the court has considered the future prospects without any basis,
Future loss of earning.
future loss of earning without any basis, and granted the compensation which is on the higher side, considering the same, there shall be submission of the council, there shall be stay of all further proceedings on the condition that he shall pay 3 lakhs within 4 weeks, and on such deposit, the respondents are at liberty to withdraw. Notice to the respondent. Next,
cell number
27.
27, A.M. Venkatesh.
There is some lapse on my part, my not complying with the court order, my lord. Within 4
So
weeks.
no, this is second round from everybody, recalling the orders, first passing the orders, then recall the orders. What is this?
My lord, I'm sorry, my lord. I because of the intervacation, I could not do it.
In this, the IA number 5 of 25 is filed to condone the delay of 5 days in recalling. IA number 4 of 25 is filed to recall the order dated 8/9/2025. And IA number 5 of 25 is filed to condone the delay of 5 days in filing the recalling application. The coordinate of this court on 8/9/2025 has passed an order granting 4 weeks time to comply with the office objection, or else, and by a default order, it is submitted that due to oversight, the same like in the other thing, condone. This next
Notice has to.
notice the respondent.
My lord, stay is granted, my lord. My lord, there's no insurance for the vehicle which caused the accident. And
Of death or injury.
death, my lord. Death of 18-year boy, claimed by parents. The other vehicle, no negligence is attributed to me, and the cause of action, the court has held there is no negligence on my part. The other vehicle is responsible for the accident.
Then why the liability is fixed on you when
It is wrongly fixed by court, wrongly fixed by the tribunal.
Let us see. Where is that finding that there is no liability on you?
No, my lord, I will read that portion. My lord, issue number 1, my lord, will accept me.
Please come to that.
Madam, issue number 1. Issue number 1. Lord, I will ask you to come to issue number 1.
Yes.
Issue number 1.
Yes.
Whether petitioners proved that on 24/10/2008 at about 7:45 a.m. when the petitioner's son deceased Pawan was riding his motorcycle slowly and consciously, Hero Honda motorcycle bearing number KA 4579 being riding by its rider in rash and negligent manner and dashed to him due which he sustained grievous injuries and died in hospital. Uh,
Who is the, you have insured the motorcycle or not?
I'm not insured, madam. The other vehicle, uninsured vehicle has caused the accident. But court has held uninsured vehicle is responsible for the accident, but liability is fixed on me.
No, it says, clearly shows that
Yes.
the police have registered a case against the
Other vehicle.
rider of the motorcycle.
Yes.
Which vehicle is insured by you?
Yes, madam. I am disputed by my me.
Which vehicle is insured by you?
Yes.
ಯಾವ vehicle insure ಆಗಿದೆ ಹೇಳಿ ಅಂತ.
Madam, tomorrow I will also have it.
Yes,
I will-
tomorrow.
Tomorrow.
Because it's a case of death, I don't want to grant interim order just like that.
Tomorrow I will do.
Yes, tomorrow. Next.
Serial number 28.
Madam, IA3 is filed for dispensation of award, madam.
Where is this?
One,
In which case?
IA3, madam.
No, IA3 that is listed today. We will see tomorrow.
Tomorrow, madam. All the IS 1, 2, 3.
Yes. 28.
Serial number 28.
Appear for opponent. It is by owner, it's a small injury that I am the owner of the bus. The vehicle was insured for the period from 5/12/20 to 4/12/21. That in the check was, that is during that COVID time, the check was this one dishonored and notice that what they say notice have signed. But I have not received any this one notice sent by the insurance
Have
company.
you contested the claim petition?
Please, madam.
Have you contested before the tribunal?
Yes, I have placed ex parte alert. That's why.
Then-
That's why it filed appeal. There is a delay of 88 days. But there was a policy that.
How much
that
is granted compensation?
1,33,000 rupees granted. madam.
You don't contest and come before the court seeking stay
Oh,
with
sorry,
the
madam.
delay.
There was 88 days delay. madam. That lady that even I produced the exhibit that what they say they sent by notice that not received by her. It is
They must have placed before the court the evidence in that regard. What are the exhibits?
the exhibit this page 50 I produced the acknowledgement.
Cancel insurance policy, original check, endorsement of the Canara Bank, notice of insurance, postal acknowledgement is also filed.
Postal acknowledgement is not signed by the appellant. madam. It is not her that it was not known to her. That is my contention. madam.
Notice, we'll see.
Lots
Notice
of
will-
execution is going on for the
Let them-
time
let
being
them
at
go.
least that is on 13th madam, at least till next date of hearing. Till next date of hearing, then I deposit
Why
25,000.
why should we grant stay in that? You should prima facie make
It's-
out something.
No, it is only small injury, my lord. That's there was a policy.
That's
that I
only
paid
1
it.
lakh rupees, 1.5 lakh.
That it is true, my lord. At least till next date of your lordship, kindly till
There
next
is-
date.
We shouldn't grant, we shouldn't entertain these kind of petitions without any ground. Yes, notice to respond.
The notice, my lord, that is a notice, at least the what I exhibit they produced it. Notice not served on us when cancelling the insurance policy. That the notice must have been served. That's what the courts have held that. This notice has not served on. I have
Oh,
produced the
there is a
exhibit.
valid award passed by the tribunal.
It is
You
true,
don't
my lord, but
contest.
that award I challenge it.
The documents as per that award shows that they filed the acknowledgement before the court.
That acknowledgement.
Why should we
That
stay those
you will also
proceedings?
kindly have a look at page 50, that acknowledgement, whether it is served on the appellant or signed by her. It is not at all her signature.
Where is that? Have you filed?
Page 50, I produced it. There is no seal, that's I am this one.
Where is that? What seal
Page,
it
page
will have?
50, page 50 acknowledgement, that what they say, Kalavati as Chatra, they served, signature, Swikariswara, that is a signature of the person.
Signature there.
It is not her signature.
That we will decide now in, before this.
That
court.
I am sorry, my lord, it's not her signature. The somebody has this much signature. And this, they are produced it, because I was expert.
Those kind of things we can't decide.
That it will be decided at least till execution, that is on
Deposit,
13th.
deposit 1 lakh rupees.
I have deposited here 25,000, then 1 lakh is the entire amount.
75,000 you have already deposited.
25,000 I have deposited here, my statutory deposit.
Hmm.
That is there, my lord, your lordship kindly, till next date of at least this
No,
one.
no. How much you will deposit?
That is another 25,000 rupees, my lord, because 25.
What is the total amount?
1,33,000, my lord.
If the petitioner, shall deposit. It is submitted that the petitioner before this, the appellant before this court is the owner of the vehicle. It is submitted that the tribunal has fastened the liability on the insurance, on the owner of the vehicle on the ground that the insurance company has cancelled the policy. It is the case of the appellant that no communication is received by the owner of the vehicle. As such, still the insurance company is, so what will happen in this case? Even if that is the case that they have not served, what we say, insurance company to pay and recover from you. You will not succeed in this appeal.
The cancellation of, if the cancellation of this one insurance policy goes, then insurance company has to pay. Subsequently,
But it will go, it will not go. No, what will happen is, in that case also.
No, the courts have held that.
No, in that case also, the lawyers, the insurance company will pay and recover from you.
No, the courts have held that that is the.
That is all that law is for a third party, not to the owner of the vehicle. You will not succeed. At best, you will buy some time.
No, my lord.
Yes, the 75,000, it is submitted that, what is that? Liability on the owner of the vehicle. It is submitted that already an amount of rupees 25,000 is deposited. The petitioner shall, the appellant shall deposit an amount of rupees 50,000 in addition to the 25,000 already deposited within a period of 4 weeks. On such deposit, there should be stay of all further proceedings. And the respondent is at liberty to withdraw the money. Yes.
Number 29.
Notice to the delay has to be condoned, 88 days delay.
How can the delay be condoned without notice to the respondent?
88 days delay, madam. That was ex parte, this one, that's why I stated.
What are the requests you make will the court condone the delay without notice to respondents? Yes, next.
Number 29.
29, claimant's appeal for enhancement, my lord. Delay
Claim
of
number 1025 to condone the delay of 492 days for the reasons.
29 for 1, claimant filed application for withdrawal of amount, my lord.
492 days condone on condition that they are not entitled for interest for the delayed period.
KSRTC filed appeal and stay, obtained stay.
On what ground?
My lord, no document, they're claiming that they were passengers in the auto. The auto driver is not examined. There's no document to show that he was traveling in the auto. The discharge summary produces of the year 2023, whereas the accident is of the year 2020. So whether he was actually at the site at the time of the accident is.
The police complaint, FIR is not there.
FIR is there,
Then
but it's with respect to the vehicles, my lord, that he was not the owner of the auto. He claims that he was a passenger in that auto. That would have to be examined. I leave it to your lordship.
The IN number 1025 is filed for withdrawal of the amount.
And medical bills that have been produced are also only for 6,000 rupees.
IN number 1025 is filed seeking withdrawal of the amount. The IA is allowed and the respondent is at liberty to withdraw the amount deposited by the appellant insurance company. Yes.
KSRTC, my lord.
Let me 50% of the amount, my lords, because the
is
delivery was
8 lakh 50.
we have deposited
Posted amount.
Deposited amount 4 lakh 53,000, my lord. Awarded amount 8 lakh.
Entitled to withdraw 3 lakh rupees.
Grievously injured, my lord.
Number 30. Sushmita ji.
My lord, this case asked for the appellant, my lord. Kindly notice may be issued, please, my lord.
Yes, notice.
31.
Next matter also notice.
Cell number
Much
34.
obliged.
Notice.
Number 33.
Notice.
Cell number 34.
Notice.
Appellant in this
Cell
case.
number 35.
Respond number 1, kindly maybe.
Which case?
35, my lord, serial number. I have paper appellant.
Dispensation
number
to respondent number?
1, my lord.
Memo is filed seeking dispensation of notice to respondent 1. Dispense with the risk of appellant. Yes, notice.
Cell number 36. Bharat Kumar S.
Matter will be connected with another RPFC, my lords. 204 of 2023. My lords, and matter may be fixed for next week, my lords, because she has filed one recovery criminal misdemeanors in Udupi, my lords.
Just along with so and so on Tuesday.
Cell number 37.
Please, ma'am.
Satya Shetty. Vignesh Shetty for
I beg to
respondent.
appear. Lord, the main prayer here is, my lord, petitioners were the loanees, were taken loan from the bank. Subsequently, my lord, out of 3 properties, 2 properties were brought for sale. Our case is that, my lord, the entire amount has been satisfied and they had to refund us around 65 lakhs more. My lord, pending that, we gave a representation saying that give us the details of the amount which has been collected and what is the amount in which account it has been, my lord, the loan has been cleared. There are 5 loan accounts in the bank. Now, my lord, the petitioner is a proprietary concern who is now, my lord, 88 years old. Now, before I go on the merits of the matter, my lord, may I request your lordship to kindly turn to the order sheets, my lord.
No, you are questioning the sale notice.
Sale notice, my lord, there are various prayers, my lord, in the writ petition.
Let's see.
Yes, I will just.
You are questioning the sale notice, section
My lord,
4
the
order.
annexure A, my lord, has been, that's a notice which has been issued. My lord, a letter which has been issued saying that under Securitization Act, my lord, section 14, we are taking the possession. That was challenged. My lord, and if your lordship may kindly see clause C, my lord.
Already OA is pending.
My lord, OA is pending.
OA is for what relief?
Same relief, my lord, they have parallelly, my lord, under section 14, they have initiated a proceedings. OA also, they have initiated the proceedings. The amount which is there in OA is different. What they claim here is different. If a lordship.
No, why should you come before this court but not go to the DRT?
My lord, in OA, my lord, I have already represented. Now, my lord, as far as section 14, my lord, yes, my lord, I am before your lordships.
No,
Your lordships might say that.
Why don't you
My
go
lord,
there?
if I am able to satisfy your lordships from the orders which are already passed by this court, the brazen, my lord, orders which have been not followed by the bank, I will, my lord, just limit my prayer, my lord. It is more, my lord, I am before your lordship as a mercy petition, my lord, who is a 88 years old man. I will, my lord, just show to your lordship those orders, and I will say, my lord.
Initiative, what's happening?
My lord, my lord, what had happened, my lord, it is a matter of fact, we have sold 2 properties. We have given a benefit. Subsequent to that, they prepared an essay before the DRT. All the measures which I taken, my lord, confirmed by the DRT in essay number 1 of 2021. My lord, this aspect also, my lord, considered by DRT. Now, my lord, kindly see the my lord, relief sought before this honorable court. My lord, in page number 30, issue nature of cost is set aside this auction sale notice 21/6/2021. Subject to some my lord, interim, my lord, this honorable court granted interim order on my lord 31/7/2021, subject to my lord some condition. This honorable, my lord, they are not compliant. That is one. Subsequent to this, my lord, DRT pass an order. My lord, all the measures my lord upheld. Now, my lord, coming before this honorable court and my lord, very same relief or my lord, it is not maintainable.
What is that order of DRT?
This on DRT, my lord.
Have you filed that order?
Yes, I filed a counter. In fact, I produced the order copy also before this honorable court. Essay 1 of 2021.
And property was brought for sale. Sale notice was challenged. In respect of other 2 properties, my lord, which has already been confirmed. Now, my lord, I am not on that point at all. Your lordship, kindly, my lord, look into the order sheet for a minute, my lord, before your lordship can go into the merits of the matter. My lord, may I take your lordship to the order dated 20.
Matter is pending before this court.
Yes. Now, my lord, may I take your lordship to the order dated 28/2025, my lord. Prima facie, my lord, I will try to satisfy your lordship how, my lord, a fraud has been played on the petitioner. Then, my lord, I am at the mercy of your lordships. My lord, 28/2025, my lord.
Essay 21.
(2025) when gone to the
Yes, ma'am.
respondent directed to furnish a loan account extract.
Produced.
And
My lord, let me
indicate that
complete.
what was the
Yes,
amount due
yes,
2019 and onwards.
Yes. Now, my lord, subsequently, when the matter was called on the next day, learned counsel for the respondent has handed over the statement of account as per the order dated 2028. My lord, they produce only 2 loan accounts, my lord. There are 5 loan accounts. Let my friend say, my lord, they have produced the entire 5 loan. My lord, I will not. I will, my lord, take his word. My lord, entire 5 loan account statement was directed to be produced. They produced only 2 loan accounts. Now, my lord, may I take your lordship to the next order, my lord, which is on 24/9/2025. It was a detail after hearing the matter at length. This honorable court, my lord, passed the order 24/9/2025. May I just read that order, my lord?
Yes.
In ordinary course, this court could not have interfered with the impugned notice in view of the judgment of the Honorable Apex Court in so and so. However, it is observed that petitioner number 2 is now a senior citizen who has attempted to start an industrial unit by availing assistance from the respondent. For the reasons unknown, the unit was not commercially viable and the petitioner number 2 became a defaulter in the respondents. Respondent issued a notice under section 32 of the Securitization and Reconstruction of so and so Act on 26/6/2019, calling upon the petitioner to pay 5,61,12,833. The respondents then issued an order under section 13(4) of the Surface Act on 12/10/2022, during which interest period was compounded. The secured assets and the movables were auctioned on 6/1/2021 and on 21/8/2021, and the sum of 6 crore 30 lakhs was recovered. My lord, the 13(2), my lord, 5 crore 33, recovered is 6 crore 30. Respondent then initially proceeded under section 14 of the Surface Act, and the order was passed on 23/9/2022. A notice was issued by the respondent number 1 to the petitioner on 23/9/2022 to deliver possession of the house where he is living. It is evident between 2019, when the notice under section 13(2) was issued, till 2022, when the notice respondent submits that the petitioner are due a sum of 1 crore 36 lakhs. The demand of the respondent and is hard to fathom, as what was the due as on 26/6/2019 was 5 crore 61 lakhs 12,833, which has now compounded to 7 crore 96
Come to
lakhs.
11/11/2025 order.
Yes, my lord. I'll just, my lord, last.
I've seen this order.
My lord, here there is a direction. That is why, my lord, I'm just taking.
Asking them to revisit and.
My lord, yes, the last direction was the respondent, instead of being considerate, have acted like a Shylock in demanding the petitioner to pay huge amount. In view of the matter, this court considers that as fit case to direct the respondent bank to revisit the way of amount and recovered are applied, and consider work out a one-time settlement of dues as it existed on 26/6/2009 and pass appropriate orders in accordance with law. The learned counsel for the respondent shall report the action taken by the respondents on the next date of hearing. Now, your lordship may kindly turn to the next order, my lord, of your lordships, which has been passed. Now, my lord, on the next day, learned counsel for the respondent submit that bank has addressed a letter on 4/1/2025 asking the petitioner to come and submit an offer so that the account may be settled amicably. It is submitted that petitioner has not come forward to come up before the bank with any proposal. List this matter on so and so. By the time petitioner shall approach the bank, my lord, as per this direction, my lord, I have gone. I have given the representation also, my lord, to the bank. I will, my lord, submit it. There is no dispute about that fact also. My lord, my request to your lordship is, the earlier order clearly said they have to, my lord, produce the order which has been passed by them under OTS.
What has happened after this?
After this, nothing, my lord. I have gone and given as per your lordship's direction.
Correct. What had happened is honorable court directed me. If any proposal, if they're submitting before the bank, we should consider with all fairness, which we accepted. We given multiple opportunity. We have called them.
I'm asking you after 11/11/2025, when he came to your bank on 17/11/25.
My lord, I don't have any instruction on that effect.
My lord, it has been given, my lord. I will
let them
give
produce,
the
my lord, I'll take instruction. Apart from that, this all the issues, my lord, in SA number, my lord, 1 of 2021, the order passed by the DRT on 28th March 2025. My lord, all the my lord, contention which canvassed before this honorable court taken up before the DRT on, my lord, 28th March 2025, DRT dismissed it. No, my lord, the only question, in fact, my lord.
So saying that all issues, you can specifically say what are all the issues,
my lord,
one by one.
No, my lord.
What is that the DRT has settled?
Settled, my lord, in respect of my 13 to 13 for sale notice.
Oh, no,
by way of order dated, my lord.
Something about this account, this interest, all these issues have also come
all
up.
that, my lord, DRT is a competent court which you have given the calculation, DRT appraised, DRT looked into and pass an order.
Lord, let him produce, my lord. I am.
No,
Let
nothing to
him.
produce. It is your application, SA 1 of 2025, order dated, my lord, 20.
My lord, that was a sale notice which was challenged. My lord, that has been confirmed. We are not on that point because the two, my lord, properties which was brought on sale, we are not going on that question at all. What we are trying to say before your lordship is, after these two sales which has taken place, my lord, they are, my lord, they are supposed to pay us almost 69 lakhs back.
Forget about what has happened before the DRT and what has earlier happened. Now, subsequent to this order dated 11/11/2025, what happened? That I want to know.
My lord, we addressed a letter to my lord applicant. Come before us. We'll work out because
what he says, he came before your bank on 17/11.
As per so far as my lord, till today, my lord, bank, my lord, my client is not instructed.
Where is that
Anything they
communication?
submit, give it to me, my lord. I'll take an instruction to itself. I'll make submissions. My lord, now, my lord, my responsible submission is this. Bank willing to settle it. We understand, my lord, we are sold to property and we recovered some money. And it is not in dispute, my lord, they have to give some remaining money. Let them come before the bank. From the day one we are telling, come before us.
My lord, we have gone, my lord. When we go there, they will treat us like a dust. They will not even call us. They made us wait from morning till evening. A 88-year-old man, morning till evening, my lord.
To have a copy of it.
My lord, I have it, my lord. I'll take a printout and I will give. I'll just immediately, my lord, forward it to my friend.
It is submitted by the land council, the petition that on 11/11/2025, as per the order passed on 11/11/2025, the petitioner approached the bank on 17/11/2025 with a proposal. Then counsel for the respondent submits that he has no instruction. The counsel for the petition shall give a copy of the said proposal to the counsel for the respondent, and the respondent counsel shall get instructions by Thursday. Next Thursday. This is the matter on next Thursday.
My lord, I will give a copy, my lord. I will give a copy to my friend also. Let them also, my lord, comply with the order dated 24/9/25. Because what happens is, my lord, I will submit. What happens is, whatever we give a offer, they will not accept it.
The petitioner, it is submitted that on 24.
9/2020, my lord, that is on, I'm sorry. On 24/9/2025.
9/2025, an order is passed by a coordinate bench directing the bank to, what is that? They said that to revisit the.
Yes, my
loan
lord, to
amount.
revisit and pass a orders and produce it before this court.
Pass an order and produce the same before the court.
Yes.
The counsel for the respondent shall place before the court action taken by the bank pursuant to the order dated so and so.
Yes.
Which I already complied, along with the memo, letter dated 4/11/2023.
If that is so.
Give,
that
give
you
the
can-
give the copy
you can
to us.
say
we
so.
will see.
Yes, next.
Cell number 39, 38. Rakesh B. Bhatt.
The respondent number 1 and 2, my lord. My lord, in this, the learned senior counsel, Mr. D.R. Ravishankar has been engaged. Let them start their arguments. My lord.
That's the petitioner is neither a borrower nor a guarantor. Petitioner is a builder.
Go to file.
Lords,
Yes.
I propose, my lords, I start constructing a building, residential apartments, my lords. The third and fourth respondents here before my lords enter into agreement of sale, registered agreement of sale without possession to purchase, my lords, 2 flats and 2 flats, 4 flats, the building. My lord, based on that, they go to the bank and create a mortgage with the bank on the registered agreement of sale without possession. Now, then, my lords, they default. Of course, they pay me certain advances. The total sale consideration, according to us, is about 6
You are the
crore.
builder.
Lords,
You are the builder.
I am the builder and the owner of the building. Lords, I only am the property owner. So, my lords, under the terms of the agreement, they default in fulfilling the terms of the agreement and paying me the balance sale consideration and getting the flats registered in name. So, I also refund certain amounts, bank transfers back to them and forfeit certain amounts because the sale does not come through. In the meanwhile, they create a mortgage with the bank in 2015 based on the registered agreement of sale only. Then, my lords, the bank incidentally files a OA because they are declared as NPA. I am nowhere in the scene, but bank says, I have given a letter. The letter also I'll show to your lordships, the NOC which I have given. Then, my lords, the bank files a original application before the DRT, which your lordships would get at page 110. 110 in the writ petition, my lords.
Yes.
Annexure F, page 110. That's OA 558 of 2021, if your lordships have.
Yes.
In that, I am made a party in that, my lords. At page 115, your lordship, 112, your lordships would get. I am the third defendant therein.
Yes.
They say about the loan sanction and also about the agreement and mortgage having been created pursuant to the agreement of sale. Then, my lords, the prayer your lordships would get at page 117. Reliefs, my lords, at 118 it starts. Directing defendants personally and jointly to severally pay the applicant amount of rupees 9 crores 80. That amount is paid to the borrowers, not to me. My lords, in this
No,
OA,
where do they narrate about this agreement of sale and all in this application?
yes, they say that, my lords. If your lordship,
That will see.
yes, my lords, please come to the, my lords, about page 113. Under the heading limitation, if your lordships have, the applicant declares application is within time limitation period prescribed under 24 of recovery of debt dues to bank and financial institutions, read with limitation. The cause of action for this application initially arose when the defendant number 1 and 2 had approached the applicant bank seeking home loan on 17/2/2016, and it also arose when defendant 1 and 2 had entered into a home loan agreement dated 31/8/2015. So it should be 31/8. And it also accrued when the credit facility was accepted by defendant 1 and 2, and it also arose when defendant 1, 2, and 3 entered into agreement of sale and construction agreement dated 24/3/2014 with the builder, and it also accrued when defendants 1, 2, and 3 deposited the above agreements as contemplated under section 58F of the Transfer of Property Act with the applicant bank, and it also accrued when defendant 3 executed an NOC. Please see this, my lords. NOC mortgage letter with the applicant bank, and it also arose when defendants 1, 2, 3 defaulted in payment of interest.
Defendant number 3 is you.
Me.
Hmm.
So, my lords, they say I have executed a mortgage. Then they say I have given a letter NOC.
So now please come to the agreement of sale and then to the NOC.
My lords, agreement of sale, your lordship should get page 34, my lords. One such, your lordships have that page 34, my lords.
Yes.
It's dated 24/3/2014. It says only sale agreement without possession. And the prices are fixed. At page 41, if your lordship sees. And please come to the duration, which is at page 41 itself, from bottom, last para but one line. The duration of this agreement to sell is 24 months from this date.
50 lakhs is paid to the vendor. Then
No, totally, my lords, there were 4 flats to be.
tax shall be paid on or before 28th February 2014.
Yes, my lords, balance.
Hmm.
And 24 months was the due. Anyway, my lords, the issue is, now, my lords, we agreed to sell 4 flats to them. That is third and fourth defendants, 2 flats each.
Hmm.
Based on this, he creates a mortgage, the borrower.
Yes.
In this OM, my lords, unfortunately, I was placed as ex parte.
Hmm.
Now, my lords, having placed me ex parte, I did not know about this. What the bank does is, they issue 13-2, 13-4 during the pendency of this OA. They take securitization measures against the borrowers, to which I am not issued any notice. Then, my lords, section 14 petition is filed before the magistrate to take possession. These flats are not even completely constructed. 80% is done. 14, my lords, the magistrate passes an order in which I am not even a party anywhere, my lords, to hand over possession of those flats to the bank. At that point of time, I come to know. At that point of time, I come to know, and I approach this honorable court by filing a writ petition challenging the 14 order and the steps. Annexure K at page 160, because they had put my property for sale under securitization. Lords, it's an order dated 5th of April 23, if your lordship sees.
Yes.
In that, please come to my lords. I'll just read the order, my lords. It's only 162. The petitioner is before this court calling in question order dated 7/6/22 passed by so and so additional CCM in criminal miscellaneous 4091 of 21 and an auction notice dated 6/2/23. But please see para 3. The proceedings against the petitioner, the bank of or the borrower's galore, the bank is already before the debt recovery tribunal. And in the interregnum, the issuance of an auction sale notice by the respondent bank is what drives the petitioner to this court in the subject petition. Learned counsel for respondent submits auction which was slated to be held on 14th. So, my lords, immediately thereafter, I file an application before DRT to, my lord, set aside the order placing me ex parte, and I also file my written statement. That is kept pending. But then in the meanwhile, they issue a sales auction notice and sell the property. 4 flats are sold. They recover.
When the sale has taken place?
My lords, the sale takes place on 25/7, my lord, subject to 25/7/2023 is the sale certificate issue.
That is also over now. Sale certificate is also issued.
Yes, that is where what we have questioned here. To say, number one, it's only a registered agreement of sale. Registered agreement of sale, my lords, does not create a security interest. Now, my property, I am the owner of the land, and what they have done, not only that, 4 flats, my lords, undivided share in the land also.
What is that NOC given by you?
Yes, please come to that NOC which your lordships would get, my lords, at page. We have produced that along with the writ petition. Page 127 also, your lordship. 127. Typed copy, yeah. Huh? The typed copy is present, my lords, if your lordship comes to 128. Typed copy is available at 128, but please see there is no date. Your lordships have that, my lords. The original is at 127, but in that, please come to no date, but please see what it says, my lords.
Just to confirm that we have sold.
And please see what we say, my lords. That is one unnumbered 1, 2, 3, 4th para, my lords, from top. We further agree. Your lordships have that, my lords. It starts with, we further agree that in case the agreement of sale of the flat premises executed, if your lordships have that parameters, executed between ourselves and Mr. S. Devendra is terminated, or otherwise the flat premises purchase transaction is cancelled on account of non-payment of own contribution or for any other reason whatsoever, then your bank shall have priority over the sums of money advanced to Devendra and paid to us. And we hereby undertake to forthwith refund to you without demur such sums of money paid to us. So I only give an NOC whatever is paid through the bank to us. I am only guaranteeing only that money. It is not even a mortgage. And this we say, my lords, of course, we have said it does not have any date. It's blank. There is no sale deed itself. It's a created document. We probably used my signature. But my lords, this NOC also does not create a mortgage. And what it creates is only a right that whatever money you have paid to the borrower on account of purchase and which I have received, I will pay back in case he defaults. That is why they go and file a OA, my lords. Rightly so, they filed a OA. Now, my lords, the moment they auction the property, they withdraw the OA itself. That we have produced along with a memo saying that they withdraw the OA. Now, my lords, I am a builder and a owner of the apartment. Now, what is sold is not only the 4 flats, the undivided right in the land, my lords, is also set out in the agreement. But the undivided right over the entire extent of land, there are another few flats. They have sold that also to the.
How much he has paid to you?
My lords, please see, we have set out, my lords, in our synopsis, if your lordship takes the synopsis. My lords, it was filed on 9th of December 2025. There is old synopsis, new synopsis. That's why even I am getting confused. Lords, 9th of.
This is something dated 3/12.
No, my lords, it's dated 9th of December 2025. It's filed on 9th December. Synopsis. Otherwise, I have an extra copy only. It's not stitched, my lords. I'm sorry. It's only, but it's been filed, my lords. A copy was served on the other side also.
Yes, sir.
In that, please come to, my lords, number 3, that is 24/3/2014. Petitioner entered into 2 registered sale agreements with so and so I have set out, and total consideration amount received I have set out. Advance received 4/13/25, balance to be paid, time period 2 years. Then the next column is the other 2 apartments for R4. How much was paid? How much was? Then, my lords, please come to the last one column there. I'm sorry, serial number is not mentioned in that page. Since the sale agreements expired, your lordships have that, my lord. Petitioner has repaid part of the advance sale consideration received from respondent 3 and 4. In total, petitioner has repaid more than sum of rupees 2.30 crores to respondent 3 and 4 annexure X. That is a bank statement to show transfers having taken place. Now I am, one is, if it is not a security interest, you could not have created a mortgage. Now please see, so far as I am concerned, you have sold my flat. I don't get money from that man. I don't get any no money at all. Bank has simply sold. My lords, we have this list of authorities we have prepared.
Yes.
Lords, the first one is, my lords, Ramesh Chand versus Suresh Chand, if your lordships get that. Lords, the settled positions, my lords, we are showing. But in that, please come to running page 8, my lords.
Yes.
Para 12 onwards, their lordships have considered what is agreement of sale. Whether it amounts to, my lords, creating an interest on the property and transfer of, whether it amounts to a transfer of property.
Yes.
Now please see para 15 at running page 9. It starts with there is a difference. There is a difference between a sale deed and an agreement for sale or a contract for sale. A contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. While a sale is a transfer of ownership, a contract for sale is merely a document creating a right to obtain another document, namely a registered sale deed to complete the transaction of sale of an immovable property. Section 54 in its definition of sale does not include an agreement of sale and neither confers any proprietary rights in favor of the transferee, nor by itself creates any interest or charge in the property.
Yes.
If after entering into a contract for sale of property, seller without any reasonable excuse avoids executing a sale deed, buyer can proceed to file a suit for specific. For that proposition, of course, Suraj Lamps is followed, my lords. We did not produce Suraj Lamps. Then, my lords, please come. So far as, my lord, the third judgment is concerned, then I'll come back to the second one, my lords, which your lordships would get at page 34.
Yes.
Unconfused ಮಾಡ್ತಿದ್ಯಾ ಇಲ್ಲ ನಿಮ್ಮ ಕಾಪಿ ಇದಾಯ್ತು ನನ್ನ ಕಾಪಿನ at running page 34, my lords.
Yes.
In that, lords, the para numbers 34 to 37. This is 2005-11 SEC 520.
Yes.
Para 11, my lord, sorry. Para 11 page. This was
Yes.
under the mortgage conditions, what amounts to a mortgage and the bank's thing, my lords. The lordship sees para 11.
Yes, I've seen that.
54 does not apply. Then the second judgment also, my lords.
So I've seen paragraph number 27 or 24. 27.
Yes. Now, my lords, of course, the other thing is why I have come here instead of going. Now, my lords, if I have to go to DRT, it is a question that I have raised is a fundamental issue. And if your lordship sees, my lords, the security definition of a security interest at section 2 ZF, my lords.
If it is issued.
This was amended.
Amended in 2016. Mortgage is prior to 2016. So amended.
Yes.
Now, my lords, this, please note that this security interest was amended, my lords, in 2016 from 1/4/2016. Prior to 1/4/2016, because this mortgage, so-called mortgage and loan agreement was prior to that date, my lords. Now, my lords, please see what it says.
Yes.
My lords, I'll first read the prior amendment. My lords, security interest means right, title and interest of any kind whatsoever upon property created in favor of any secured creditor and includes any mortgage, charge, hypothecation, assignment other than those specified in 31. This was further expanded only, my lords, on 1/9/2016.
So, my lords, if your lordships is security interest means what they have mentioned, here nothing will come. If, my lords, a registered agreement of sale, whether it's registered or an unregistered agreement of sale, if it does not create an interest, but the question of, my lords, being treated as a security interest will not arise, is my sir. If this is a fundamental question, my lords, alternate remedy, yes, but, my lords, the judgments also say, even in, my lord, Satyavati Tandon, that in exceptional cases, the courts can interfere. Here, I have made out a case that once I have received certain amounts from the bank, yes. They have themselves produced about 10 lakhs they have paid through DD through the bank. If that is the case, my lords, my NOC was only to the extent that whatever money I have received from the bank, towards this, I am entitled to refund. But now, my lords,
You have received some amounts from the bank.
yes.
How much you have received?
9.8 crores is
Lords,
what was
according-
received by them. Not
Please
10
see, my
lakhs.
lords, I can if my learned friend is, we'll see their OA, my lords, for a moment. OA contents.
No. How much amount you
Lords,
have received from the bank?
We, from ICICI, with my instructions are in their OA, they themselves have produced that they have received, they have paid 10 lakhs.
But he says 9.
That is paid to the borrower.
No.
My lords, please come to the OA, my lords. Let's see the OA before all these things, my lords. I will only take your lordships to the OA contents. It starts from annexure, page 110. Please come to para 4, my lords, at page 115. My lords, para 4, my lords. It is at 115. It is submitted upon request of the borrower's applicant bank had sanctioned consolidated home loan amount of 9 crore 80 lakhs for purchase of residential flats bearing number so and so constructed on Schedule A property of respective agreement of sale without possession. Out of the above sanctioned amount, the applicant bank at the instant of borrowers had dispersed a consolidated amount of rupees 9 crore 50 lakhs so and so through the loan account of 1 and rupees 4 crore 75 lakhs 41 through the loan account 2. The copy of the sanction letters is produced. Since the borrowers were buying the scheduled property from the third defendant, they had authorized the applicant bank to disperse the loan amount directly to the builder above named. The copy of the dispersal memo is produced A5 and A6.
That means the entire amount is dispersed to you.
My lords, then they should produce the account. My instructions are nothing has been done except 10 lakhs. We are very sure. That's my instruction, my lords. And the DD which shows
Producers entire 9.
in the objection also, they don't say that they have
said it
dispersed.
very specifically, but my learned senior friend says that we should produce account. No difficulty, we'll produce the entire accounts. Not even a single rupee is dispersed to the borrower. This was for the purpose of enabling the purchase and construction. Every single rupee has gone only to them. And it's an admitted fact, my lords, that this was a mortgage property. But nonetheless, if your lordships may have this matter tomorrow itself, I'll furnish him the accounts because they should not deny.
No. Assuming that the amount is transferred to him, why the bank is very liberal in doing this transaction? He is not, the agreement holder cannot be the owner of the property. When there is no right and title to him, how can he pass on
That's
to
essentially,
you?
my lords, what I want to point out. The contention is that there is no consent given by him for the purpose of creation of a mortgage, and a mortgage created by the agreement holder cannot give a right for me to exercise powers under Securitization Act. That's the substance of their submission. I will point out, your lordships, mortgaging was with the consent of this petitioner before your lordships. He gave a specific consent. This was a property which was mortgaged earlier to Karnataka Bank, to different buyers. They did not pursue this. Then they came forward and said that this loan is to be taken over by the present bank, that is the ICICI Bank, for which they gave the consent. Yes, we are permitting you to take it over. That is how the account was taken over.
Consent will confer title.
Lord, so far as consent is concerned, that's the reason why I wanted to deal with what is meant by a security agreement, my lords. Security agreement, security interest and secured assets, if these three are conjointly read, it will clearly give an indication whatever is subject matter of the document offering anything as security becomes a secured asset. That is how wide, my lords, the definition comes about. Even the agreement, my lord, there is no necessity Mortgage is one of the forms of the agreement. So far as security interest or the security agreement is concerned, it is very, very vastly worded. Any form. Now the only question is whether he was aware of it or not, that there was a mortgage of this very property. That's what I am required to submit to your lordships. There was an earlier mortgage in the agreement of sale which he executed in favor of the borrower. He specifically mentioned that this is a property which is subject matter of the mortgage to Karnataka Bank. We are permitting you to get this taken over. He gives a letter to the ICICI Bank and the borrower saying that you are permitted to do this. We extend the loan on the basis of this documentation. I will place all those things before your lordships. Not that we have completely taken diligence to ensure that, because we have lent the loan. Not what he wants to.
There appears to be no diligence in this.
Not we have completely done the diligence because this is not a property which is mortgaged for the first time to the bank.
It is not about his consent will not confer any right on the bank. There has to be, he is the owner of the property as on that day. He has to mortgage the property by way of a registered document.
So far as that opinion which your lordships expressed, would have been right only in the context of a mortgage under the Transfer of Property Act. But here what is required is a security agreement. Security agreement, one of the forms of the security agreement is a mortgage. Mortgage itself is not the security agreement. If your lordships were to see the definition of the security agreement, it is very widely worded as to what all comes within the purview. Anything which they say is given in lieu of or in due deference for the purpose of offering the security or to assure the payment itself is a security agreement. Lords, now sequence of events, I'll bring it to your lordships notice only to indicate they were aware from day one that this property was already mortgaged to one of the banks. Then the borrowers who took the money, they were not cooperating. So therefore, there were 4 new buyers. The mortgage which was already created in favor of one bank was transferred in favor of the second bank. In their documentation with their home buyers, they have admitted to the fact that these properties are mortgaged. After having registered the document saying that the properties are already mortgaged, now they want to come and take a stand that whether an agreement of sale creates a right to purchase, that I will satisfy your lordships.
Where those documents are placed before the court?
With everything is placed before the court.
Where is that, the registered document?
Lords, if your lordships were to see the agreement of sale, lords.
The agreement of sale I have seen.
No, the recitals in the agreement of sale, which is produced by them at page number 34.
Yes. Sale agreement without possession.
Lords, this, if your lordships were to see at page
43.
At page 43. At page 43, the 4th unnumbered paragraph. Purchaser hereby explicitly stated that Schedule A property is mortgaged to Karnataka Bank, Malleshwaram Bank, and hence sales proceeds shall be routed through Karnataka Bank, Malleshwaram. This is essentially what we have taken over.
Where is that?
Schedule A property in notice of
44.
43.
Schedule A
4th
property
unnumbered
in-
paragraph.
Schedule A property. Schedule A property ಯಾವುದು?
I'll point out.
The purchaser hereby expressly stated that the Schedule A property is mortgaged to Karnataka Bank Limited, hence all sale proceeds shall be routed through the said Karnataka Bank.
In this, I will produce documents to show you, of course, we have produced to show that this is the undivided share of this is what is given to us by means of the NOC given by the Karnataka Bank and the borrower. We have got the NOC saying that yes, this undivided share.
So file formal of your objections.
We have filed our objections. A synopsis is also filed, but this.
Where are the objections dated?
Objections are filed on 5/9/2024. In that we have produced these documents. We have produced the documents to show that page 84, my lords, if your lordships were to see.
Instructions are you have not received the money.
Lords, they themselves, please come to.
Not themselves.
ಒಂದ್ ನಿಮಿಷ ತಡೀರಿ ನೀವೇನ್ ಹೇಳಿ lords, please come to page 83 in their statement of objections. 83, my lords. In their statement of objections, 83A and 83B is what they have numbered, my lords, subject to correction. They themselves say 10 lakhs DD is given to us. They have produced it. 5 and 5. That is what we have received. Lords, and in their statement of objections.
We'll take up this matter like with that whatever amount that is transferred to you, 9 crores and odd. And
I wanted to say this, Minards, when a petitioner approaches, all right, they may or may not have a case on merits, no difficulty. But at least the facts which are to their knowledge, if they want to say that I have received only 10 lakhs, not 9 crore 50 lakhs, itself is sufficient for this honorable court to disable them from getting any relief.
Basing on what
That's the reason why I said, now that statement is made. Basing on the statement which is they have made, I'll be in a position to tell your lordships that what statement they made today is not correct. I'll place it before the court. Any day, tomorrow, please. Grateful, Milords.
Yes.
Sale number 30, 39.
Plus 39, plus 39, I have received the copy. I am for the respondent. I have received the copy only day before yesterday. And since I'm engaged in a Supreme Court matter today, I have the inconvenience. Milords, also the copy that is furnished to me is not legible, as in the font is in a running format. I don't even know how that is accepted. It would be quite difficult for me to.
Milords, may I say this, Milords?
No,
Milords,
this is a matter already adjudicated by
may
your
I-
lordship.
Milords, may I say this? If my learned friend will just bear with me, Milords, 2 minutes, I'll tell the whole case. This is regarding the most sensitive jurisdiction that my lady has of child custody visitation rights. 1 year back, lordship, the petitioner before my lords is the husband, the father, 2 kids involved, 6 years son and 3-year-old daughter. Ladyship 1 year back in July 2024 passed a custody order, giving a sight of an internal arrangement between the visitation rights, that is Saturday morning 10 o'clock and bring back the kids by Sunday. And I had to pay 1,25,000 maintenance every month. I have paid more than 59 lakhs as part of my duty to discharge my obligation. Everything I've taken care and continue to do so. My learned friend's client, in the period of October 2024 till February 2025, commits 45 willful defaults of my lord's order.
No, 1 minute.
So I'm.
This matter, 1 minute.
Yes.
This matter, it's not that I heard this matter.
Yes.
For or a span of so many months.
Yes.
After that, I passed an order.
Yes.
And I think now you're the 6th or 7th counsel
Absolutely,
appearing, senior counsel
No, I'm
appearing
not,
for
sir.
this party. No.
Yes.
They have, no, this petitioner, he comes up with applications one after the other. At least half a dozen
Milords, I'll
applications
tell
must have been filed.
Milords, I'm
I
sorry
Why
to
should we-
interrupt.
1 minute, 1 minute.
I'm sorry,
Milords,
Milords.
I'll
Why
read.
should
I'm sorry.
we, why should we recall this order? Why
No,
should we
nobody is
review
asking
this?
for recalling. Milords, I gauge the sentiments of this court. This father is not an ordinary man. He is a cancer survivor in remission.
That we know.
So,
when
Milord, the
order
children's
is
presence,
passed
Milord,
on
may I say
July
this?
2024.
I follow, Milord. Anybody coming repeatedly will irritate my lordships. What I say is, the medical advice seems to be the presence of the kids may aid in the recovery of the father. The father has just come out, and the more the presence of the kids will help the mother. All we say is the winter vacations are coming. Even in Diwali vacations, despite assurances to this court, my learned friend's client defaulted. We had to go to the court to correct it. The orders of the court are meant to be implemented. I have implemented my part of the bargain. They are on every second time they are willfully disobeying. What I say is the winter vacations are coming on 20th of February. All I ask is 50% of the vacation time with me. And Milord, the houses are hardly 3 rows apart. They're all in the same street of Koramangala. It is not a very distant part. And Milord, Lordship will see the day-to-day interest that I'm taking, despite the kids being with the mother. I have moved applications to get the kids to the best schools in Bangalore. IB education, it has been accepted by this court. I am acting in the paramount interest of the children. Milord, this case is highlighted by parental alienation and unfiltered counseling. The son is being taken to St. John's Hospital and all kinds of counseling has been done. The parent has no clue. The school records, the father's name is being eliminated. My learned friend's father's name is being put into the account. So, my lord, this is a case where in parent patriarch's jurisdiction, this court is the guardian of these innocent minor kids. They do not have any voice. They speak through this court. The only prayer the kids are making, and Lordship may even interview the kids. They are so happy. You have already done that. Lord. So all I say is,
find any reasons to go back because you have a remedy. Go before the family court.
Below the family court, my lords, it is, the January applications are not even being taken.
Then if they are
This is
not
the court. Red court, my lord, comes.
that which we will entertain.
Red court will come through, cut through the remedy, my lords.
No,
This is a
this
glaring
is not a
case.
where I'll interfere.
A winter vacation, at least, my lord, some that liberty is given, my lord. The winter vacation.
No. Let's go to the family court and seek whatever relief you want from the family.
She is in contempt all over the place, my lord. These small family courts may not be really empowered to do this, my lord. Ladyship will have to take that
I know
jurisdiction.
that this client is not so innocent that he's only looking at the courts too. He has, when the matters are pending before the court, when the lady is before the court, I've seen that where he has given a complaint saying that he wants a compromise and a custody and give a complaint. And what kind of applications I've seen in this? And he
That is
doesn't
true.
require any indulgence from this court.
Let's
Let the family court decide. Whatever they want, let them approach. And I do not find any reasons to revisit this order dated 12 July 2024. After several applications have come before this court, I have entertained that, and I have passed an order also that if the last occasion, what is that, Pratima, that I said the IA that is pending before the court has to be
Milords, if
previously
the,
heard.
if my
Even
learned friend's
mediation, he
client will
declared
violate,
saying that
Milords,
the
if
court
he
cannot
violates,
pressurize me for mediation and produces a lengthy judgment of the apex court just because the court suggested that he go for mediation. Time and again, Milords, he has not presented himself before the court at all. And similar reliefs are already pending before the family court. I do not know why they are doing forum shopping.
When the entire mediation, I think if you look at this.
Lordship, can we approach it through a fresh hand?
I'm not
Lordship,
interested. At this juncture, I'm not interested to go into all that. The application is, please come. I number 1 of 25 is filed, seeking modification of the order dated 12/7/2024. Senior counsel appearing for the petitioner submits that the mother is violating the orders of the court, and the father is doing his best by supporting the supporting the kids monetarily and also taking care of their needs. But the mother has been violating the orders of the court, and it's a case where there is a complete parental alienation.
That's it.
It is submitted that as he's a cancer, cancer survivor. He's a cancer survivor, and the presence of the children will help him to
recover,
to heal, and it's and considering and exercising the parent patriot jurisdiction, the court has to look at the ultimate well-being of the children. It is submitted that this court may consider the ensuing winter vacation 50% with the father and 50% with the mother. Next, learn counsel appearing for the respondent mother submits that it is submitted that the papers that are served on her are not this. The papers are served on her day before yesterday, and the font and the papers are not visible, and she seeks time. Next, the reasons that are stated, that are the argument of the senior counsel, and the reasons that are stated that an order dated 12th July 2024 has to be revisited by this court by granting the winter vacation. In the said submission, this court finds no force. In fact, when an order dated 12th July 2024 is passed, court considering the fact that, and at that point of time, when this court has taken the initiative and had interacted with the parties and made them to facilitated the father to have the visitation, and that has been monitored by the court for some time. Then, after considering the respective cases of the parties, this order dated 12th July 2024 is passed for the court. Thereafter, a review is filed in this petition, and also several other orders, IAs, are filed before the trial court. And this court has also passed orders and past orders. Now, if the petitioner wants any visitation for the winter vacation, he would have approached the family court, but he cannot come before this court seeking the modification of an order dated 12th July 2024. This court do not find any reasons to modify the order. If the petitioner wants any order for the winter vacation, he is at liberty to approach the family court. Once if the application is filed, the family court shall consider the same expeditiously and in accordance with law.
Cell number.
Yes.
Cell number 40.
In this case, my lord,
This is in the earlier petition.
In this case, sufficient opportunities was given.
Yes.
Property is also auctioned now. In this, in fact, the lordship passed 2-3 orders which was not complied.
Let's see.
5 lakhs, 2 lakhs, nothing was paid. Now property is auctioned.
They are
They have approached DRT, my lords.
now
One
they are
minute.
ready to deposit 10 lakhs, my lord.
No, no, what is this ready to deposit? An order was passed on 4/11.
30-10 also an order was there, my
Then
lords.
what
And
has happened to that? You have not complied with the order.
4/11 also
Why should
opportunity
we-
was
Why should we interfere? And why should we grant time? And as you know, in DRT, I mean, in all these surface proceedings that are initiated by the bank, your remedy is to go to the DRT. Courts are entertaining, considering a few cases where.
Let them furnish what the details they have put it into auction. We will challenge before the DRT.
Yes.
And the period spent here.
That in
maybe-
your section 14, you are entitled to the limitation act. Please come.
But they have to furnish, my lord. They are not furnishing
If
any.
there be an order, my lords, I'll furnish.
Well,
If there be
I'll
an
say
order.
that within 2 days they should furnish.
Yes.
The petition is filed. Seeking the following order, extract the order. The facts of the case were that the petitioner, in order to purchase the house, had availed a loan of rupees 44,50,998 from the respondent bank on 24/8/2023 by depositing the title deeds of the scheduled property as security, and also executed a registered memorandum of title deeds in favor of the respondent's financial institution. It is the case that the petitioner has paid a sum of rupees 9,64,185 as on 9/5/2025. The date of treating the account of the petitioners as NPA. The petition was due of an amount of rupees 1 lakh on 28/8/2025, and the respondent bank had treated the petitioner's account as NPA just because he has failed to pay 2 installments, that is 1 lakh. It is stated that the petitioners have requested the bank authorities not to treat the account as NPA, denying the default and collecting excess interest contrary to the terms and conditions of the terms of the loan agreement. And they have also stated that they are ready and willing to close the account, but there was no cooperation from the respondent bank. Later, the petitioner had paid the due amount due of 1 lakh on 22/8/2025. It is stated that without considering the request of the petitioner, the bank have issued a notice under section 13(2) of the Surface Act on 9/5/2025. It is a case of the petitioner that declaring the account of the petitioner as NPA is bad. And the interest that is levied by the petitioner is contrary to the terms of the loan agreement. It is also stated that the bank has filed a petition under section 14 of the Surface Act, that is the criminal miscellaneous number 1235 of 2025, before the CJM Rural Court, Bangalore. In the said petition, the bank officials have led evidence and got ex parte order on 6/9/2025. Hence, the petition is before this court, questioning the order passed in criminal miscellaneous 1235 of 2025. On 30th and 2025, This court has passed an order observing that when senior counsel appearing for the petitioner submits that the petition is ready to settle the amount and pay the due amount within 3 months, and remaining amount will be paid within 2 weeks from today. And in that regard, he will file an undertaking affidavit before the court. By 3/11/2025, affidavit shall be served on the counsel for the respondent bank. Then on 4/11/2025, an undertaking affidavit is filed before this court that the petitions are ready to pay an amount of rupees 2 lakh within 15 days and outstanding amount of rupees 46,36,049 within an outer limit of 3 months from today. This court has also observed the submission of the land counsel for appearing for the respondent bank that the position is taken, and to regularize the account, the petitioners need to pay an amount of rupees 5 lakh. If they pay an amount of rupees 5 lakhs and clear the remaining outstanding amount within 3 months, the bank has no objection. Then this court has directed the petitioner to pay an amount of rupees 5 lakh immediately, and after the communication received from the bank, they shall pay the remaining outstanding amount within 3 months. And in that regard, an affidavit shall be filed, and directed the matter to be listed to list on 11/11/2025. Today, when the matter came up, land counsel for the respondent bank submits that he has not paid the amount. Auction, what did you say? Auction was?
Auction took place, my lords. Auction took place.
When auction was conducted?
Auction took place on 17/11.
On 17/11. Land counsel appearing for the petitioner submits that if the details are furnished to the petitioner, the details pertaining to the auction, they will take recourse and before the DRT. It is submitted that the time that is spent before this court shall be excluded from the limitation, as it is only 45 days is the limitation to approach the DRT. Next paragraph. Having heard the counsels on either side, there is a material on record. The petitioner is agreed by the possession, the order that is passed under section 14 of the Act, and he has approached this court. Now the auction is conducted, and the petitioner wants to question the same before the DRT. The petitioner is at liberty to avail the remedy available before the DRT, subject to the law of limitation. However, the time that is spent before this court shall be excluded.
And they
41.
let them furnish the details.
Number 3, the respondent bank shall furnish the details pertaining to the auction within 2 days from today.
41, V. Mohan.
That in this case, my lord,
I
am the auction
on behalf
purchaser.
of the bank, my lord.
I am the auction purchaser. I have not been impleaded. Without impleading, this writ petition is filed, my lord. That's what I
The
want to
petition is filed questioning the
My lords, in our miscellaneous, when the writ petition was pending before this honorable court, my lords, what happened was our original essay was dismissed. Despite the writ petition being there, wherein an order was passed by this honorable court, coordinate bench of this honorable court to hand over possession. That was not, we had to deposit 25 lakhs and they had to restore the possession. That did not happen. In the meanwhile, when the writ petition was pending here, my lords, the original writ petition, original essay itself was dismissed. As against that, I filed an MA, my lords, miscellaneous appeal. Then what happened, my lords, when the miscellaneous appeal was pending, my lords, they issued a notice to remove the movables and vacate. That's where we are before your lordship, my lords. That list to that extent was pending between me and the bank. That's why we did not make the auction purchase.
This is the order passed in MA.
Order.
No, the remedy is what after the when that MA is dismissed.
MA is not dismissed,
my lord.
MA is not
May I
dismissed.
submit, my lord?
It says that the ad interim stay of the order dated 31/10/2025 passed in IA number in MA number so and so. What is that order?
May I just give this this synopsis, my lords? Just quickly, I will take your lordship to 3 within 2 to 3 minutes. I will just take your lordship. That's originally SA 269 of 2014 24 minutes. That's what is sought to be now recalled by way of miscellaneous application. This was filed section 14 Mellors. Then Mellors, what happened was there was an interim stay directing deposit of 23 lakhs. We could not deposit it. Then we filed an application seeking for extension of the time Mellors. Then we filed, that was rejected Mellors. As against that on 6/3/25, we filed this WP, which is important Mellors, 7045. Then Mellors, there was an order passed by this honorable court stating that we have to deposit and they have to restore possession. 10th was the order passed and 11th itself we deposited Mellors. And then we requested the authorities to hand over the possession, that was not given Mellors. And in the WP Mellors, an order of status quo was also passed when the bank informed the court that there is already an auction has taken place. The court said you have to maintain status quo. This is what the court had passed an order on 18/3/25 Mellors. During the pendency of this writ Mellors, the SA that was originally filed by us was dismissed Mellors. That's where Mellors, this writ petition was disposed on 12/6/25. If your lordships were to see, the date of dismissal is 2/6/25. The date of disposal of the writ petition is 26/25, wherein the court clearly said, I am relegating the matter back to the court. Then we applied for certified copies and we filed SA against the auction purchaser. Now, Mellors, the court is not giving us diary number. That's one case. And because it is dismissed, Mellors, we sincerely filed a MA also, which your lordship will get it in 3rd page. That we filed a miscellaneous application because that has been dismissed. We brought in all these things. Look, the matter was pending here. Status quo was ordered. Possession, redelivery of possession was ordered. All these things happened before this court. So you could not have dismissed that. Kindly recall it. Then Mellors, in that application, we have also filed a contempt petition because they did not restore the possession to us. That's also pending. That's one set of facts. Now, Mellors, in this miscellaneous application, Mellors, when we have filed it.
Let's see that order.
That order, Mellors.
Yes.
Page 26 is the order, Mellors.
What? Yes.
31/2025. IA 20 is an application filed by applicant to advance the case from dash to this date. As the applicant wants to move an IA with a prayer to grant interim stay, restraining the respondent bank from shifting movables from the scheduled property until the disposal of the miscellaneous application. Since there is no restraining order from the Honorable High Court of Karnataka, restraining the respondent bank from proceeding further, this tribunal is of the view that prayer sought for in IA dash cannot be considered at this point. It is to be noted that actual physical possession of property had already been taken by the respondent bank. There is no reason made out to advance the case. Now, Mellors, WP order may kindly be seen for a while, Mellors. Just for a minute, Mellors. Interim order is at page 35, Mellors. In page 35, Mellors. Mellors, the 18/3/25 is the date. 18/3/25 is the date, Mellors. There your lordship may kindly see, last but one, status quo of the property shall be maintained till the next date of hearing because they had said that it is already auction has taken place. It is on 18/3. Kindly come to 10/3/25, Mellors. 10/3/25 there was an order, Mellors. Restore the possession immediately. That is the order, Mellors. 10/3 they had ordered to restore the possession. Despite
Did you pay, when did you pay 25 lakh rupees?
On 10/3. 11/3. 11/3 I paid. I paid 11/3. I moved the authorities on 13/3. And now, Mellors,
suppressing the fact.
Even this writ petition final order may also be seen, Mellors.
Suppressing the fact.
One minute.
I'm
When
coming,
this
Mellors.
order.
No. I'm seeing the order of
Order was
10/3.
passed, and
and-
this order was passed on 10/3/2025. Was there a representation from the bank?
No. 10/3 there was no representation. 14/3 there was no representation.
Why you were not served in the
I
day?
not been served. When notice came, I appeared, advanced the matter on 18, informed the court that sale has taken place, possession is taken. In fact, what they did was the borrower made the authorized officer to come to police station. Morning I moved, the matter was taken up at 6 o'clock. In 6 o'clock, the order was made to maintain status quo as on that day. That was 18/3/25. By that time, we had taken the possession. suppressing the fact that possession is taken, sale has taken place, they took this order. And this, having taken the possession, that is under challenge before DRT, they did not appear. What this file MA is that the SA was dismissed for default. It is not on merits. And after dismissal, I mean, when this was redelegated to DRT, then they wanted to reopen this SA which was dismissed for default.
Yes.
And possession is taken. Action per sale certificate is issued. And then when last date of hearing,
As on the day the writ petition was disposed of, it was not brought to the notice of the court that the application is pending before the DRT?
which one? Mala? No, but that was disposed. But that was dismissed.
Where is that? No. Where is that order, final order?
Annexure F, page 40, my lords.
Annexure F there.
Page 40. Petitioner have called in question, 42 is the portion, my lords, first 4 lines. Petitioner have called in question validity of order dated, which is the order passed in essay rejecting the request for the to put the applicants back into possession. There we had made an application. This was rejected. Kindly come to petitioner have also sought for a direction for enlarging the time to comply conditions imposed by the debt recovery as per the order dated annexure D 4/12/24, where I had to deposit money. Last for 46, page 46, para 8 may kindly be seen. Kindly see, Millers. In light of disposal of writ petition, it would, could your lordship lay hand, para 8. In the light of disposal of writ petition, it would meet the ends of justice by directing the respondent bank not to take any precipitative steps for a period of 4 weeks from today. On the lapse of such time, protection granted by this court stands discharged. The interim protection granted under this order is only to enable the petitioner avail of substantive remedy and must not be considered to be an order passed on the basis of adjudication on merits. Upon the lapse of time stipulated, protection granted would cease to operate, and the authorities before whom petitioners may approach are to look at the matter afresh, uninfluenced by the observations made herein. Immediately I go before the court, Millers. By the time I go there, the essay had already been dismissed.
If the pending essay, if you don't appear, it will be dismissed.
Yeah.
They are not concerned with this pending writ petition.
They are the parties here, Millers.
No, that is true, because no stay is granted for the essay proceedings. You have to independently pursue it.
Yes.
And they have
That's
filed
where
fresh
Millers-
essay.
that's
And
where
they are
Millers-
reopening this also.
Now, Millers,
Already they have filed fresh essay. That is pending adjudication.
You have filed fresh essay.
Yes, that is also fresh. And again on this
That
essay
also-
which is dismissed, where MA is filed, they are reopening here.
that essay is independently filed. That's a different essay, Millers. That's
Questioning what?
that's sale notice.
This is questioning?
Section 14. This was under section 14. Now we had sought for time limit to pay the amount. Because that was not granted, all these things came. And kindly see, Millers, annexure J may kindly be seen, Millers, which is sought to be challenged before this honorable court. Annexure J is one of the things that we have
No,
challenged.
it appears that the petitioner only, it's all,
My lord,
Annexure J
interim
may-
order, they have filed contempt, last date of hearing.
lecture complete. Yes.
Annexure J may kindly be seen, Millers. Shift your last 2 paragraphs, Millers. You are hereby requested to shift your goods and belongings within 7 days, failing which will be constrained to shift your household goods to its preferred storage place at your cost and response. Bank will not be held liable to take any. This is what they have given now. Now, Millers, I am ready to pay the entire amount. Whatever the auction purchaser has given, for that also, whatever is the interest, Millers, I am ready to pay
As
maximum.
you know, such an order
That's-
we cannot pass.
no, I'm bringing
Because
it.
we can't, no auction is conducted. He has paid the entire amount.
Entire money sale certificate is issued, my lord. Because of not
Registered, not yet registered.
Sale certificate need not be registered.
The notification itself is sufficient.
Kindly see, Millers, my only grievance here is on 2 counts. One is, Millers, this clearly said, Millers, this case was there on 12/6/2025. Before, they were also parties before the court. On 12/6/2025, it was that they had not informed anything, and the court has passed, look afresh, and that has given. That order has to be respected, is what I
Not
said.
correct, my lord.
Kindly see here,
Sale
Millers.
certificate is produced in that petitions.
Along with the petition,
Correct.
sale certificate, intimation, everything is produced.
Correct.
If your lordship can connect the files, no, entire set,
No, I'm not
include
blaming.
everything is
I
permitted.
totally agree. Whatever he has done, they will be knowing it. My respectful submission is 12.6.25 says the DRT has to consider this matter, look at the matter afresh, uninfluenced by the observations made here.
That is already there, it is pending.
Unfortunately, that was not brought to the notice of the learned judge, that already one application is pending before the DRT.
Which application was? This was.
Which is questioned under section 14, which you want to revive now.
That is the question. That is the case, my lords. That's it. All
You
revolves
filed
around
a
that
fresh
only.
petition after the order of Justice Sunil Dutt Yadav.
That is separate, my lords. That is with regard to sale notice, my lords.
This order also, he only gave you liberty with an impression that no, so far you have not approached DRT.
I had not approached DRT because I was there. And my case was pending there. Now I come to know after this is 12.6.25.
So at this point of time,
12.6.25.
there should be some basis for this court to say that, the communication that you have received from the bank has to be interfered with by this court.
May I just take this honorable court? 11.3 is the order. 10.3 is the
Was
order.
the respondent counsel served?
10.3.25 is the order, my lords. Kindly see annexure
So that's
D,
what
my
I'm
lords.
asking. Was the respondent bank served? It's an
He was
ex parte
served.
order.
Huh? They didn't appear.
No.
Is
It's not
what he
correct.
says, my lord.
Not
Fine.
correct.
I will stand corrected, my lords. I will stand corrected.
There was no
because-
caveat when the authorized officer was sitting in police station. On Thursday, there was a call. Friday, I came and moved the matter by filing wakalat. And this is the order on 18.3.
Kindly see, my lords.
Page 35,
Annexure
page
D, my
35,
lords.
my lord. Page 35, order of 18.3. I will read, my lord.
Annexure D, my
Sri
kindly
Mohammed
see, my lords.
Ibrahim, learned council representative respondent,
They have
Bank of
endorsed
India,
on 11.3
shall
that I have
place on
deposited.
record the notice issued to the petitioner seeking to sell the property as necessary document, as allegation is there that no notice is issued to the petitioner prior to the sale.
Annexure-
Learned, no, my lord, 14.3, my lord, order of 14.3. The matter is moved on the score that the police have issued notice when the bank has refused to deliver the possession in terms of the order passed by this court. There is no warrant to consider the allegation that the police have simply interfered with the operation of the bank when there is no order passed by this court.
Is an
However, the police shall not insist appearance of these
But when the matter
respondents.
comes up on 18.3.2025, the court observes that status quo, the property shall be maintained, having aware of the fact that already there was a direction to redeliver the position to you. It was not done. But still the court affirms the same and saying that there should be a status quo.
As of that
means
day.
The property which is in possession of the bank is affirmed by the court.
Yes.
By this
May I
order.
just take your lordship, my lords? Your lordship asked me one question, whether they were aware of this or not. Kindly come to annexure D. Next page, my lords, 36. Page 36. I address a letter to the chief manager, order dated so and so, passed by the WP number so and so. Kindly see, my lords, next page, your lordship may kindly see. They make an endorsement. I bring it to their notice. This is what it is. They have asked this. They have given
But
this.
I'm saying
They have received this.
Because the order of 10.3.2020, after the order of 10.3.2025, when you are brought to the notice of the learned judge on 18.3.2025, he says that only status quo to be maintained. There he has not reiterated that the
Yes,
position
my
should
lord,
be
that's what I'm telling.
Maybe just take this. We are interpreting the order passed by this honorable court. Let us assume that the same bench has passed this order. 10.3 is the first order where I was asked to be returned with the possession. That's one thing, Manners. That had not happened. 14.3 is the next date when I went to the police station stating that the court order is there. They are not giving me possession. The court said he need not have to be brought before the court. The bank authorities need not be brought before the court. 18.3, your lordship may kindly see, they say that there is already an auction has taken place. Possession will not be given, Manners. Only auction has taken. Kindly see this, Manners. Shri CM Nagbhushan Learned Counsel would further contend that if a sale has taken place, neither before the land tribunal nor before the magistrate in a proceeding under the bank has whispered even about the sale that had already taken place. He would allege fraud played by the bank in the sale. Therefore, the respondent bank shall steer clear the said allegation by filing statement of objection or produce documents. Status quo, the property shall be maintained. So as on that day, they had not even to this day, they had not handed over possession.
No, but the status quo
Yes,
for property means that is in their possession, possession of the bank.
correct.
There, the judge has not reiterated this order of 10/3/2025.
No, the
He
status,
says it shall be with the bank only.
status quo, the property shall be maintained till the next date of hearing.
And it is an admitted fact that they have not given portion to you.
That they had not given portion to me. That's
So
where
in
my
spite
lords-
of passing an order on 10/3, when hearing the bank counsel on 18/3, the order is passed at status quo. Whatever is the position, it shall be maintained.
Now, my lords, I'm going one step forward. Let us read that, interpret it that way only. The fact remains that they had not, obeyed the order dated 10/3/25 is there, because despite they only making an endorsement that I have received this TD, etc., etc., that is there. That means they have the knowledge, they have not. Let us go to this extent. Now, this court says, whatever it is, status quo has to be maintained is the order passed by this court. Now, finally, the court said the matter is relegated to DRT. They have to see everything afresh, because on the first day when I sought for extension of time and other things, the court had not given. So the court said you have to reconsider everything afresh is what the final order of this court says. Now, when I am before the court, the possession may be with them. That's where they have issued Annexure J. Annexure J says, all that Annexure J says is, you take away the movables, otherwise I am not going to be responsible. In fact, there is one thing, my lords, which I would like to draw your lordship's kind attention. Security Interest Enforcement Rules 3 says that they are responsible for the goods. They have to safeguard it. Everything is on them. Annexure J is also issued. Now the question is, this regular sale has
No, the
not
sale
happened.
is conducted, that is not stayed. No, the position has to be given to the
Auction
to the auction purchaser. So is it that they, along with the goods, they will give position to the auction purchaser?
They need not give. They need not give. Now that the matter has been relegated before the court, now my MA is there. MA I have filed. That MA, if I go before the miscellaneous application is there, I have sought for, restoring the original
No,
application.
apart from that section, the new essay you have filed after the orders passed by this court, in that essay where you have assigned the sale notice and all, in that you can say that the bank shall not, the position should, they shouldn't, that articles and all you can ask in that.
No, Millers, there one more problem. That's why I have been very transparent before this honorable court. There they say the court has not asked us to condone the delay. So I'm not going to condone the delay. That also I have placed before your lordship. Yesterday I moved the court. 269, another essay I have filed before the court. That is a DRT. There they say, kindly see, Millers, that order also is enclosed. Where is it?
This is the whole difficulty where the party, instead of going to the forum where you will get the redressal, going around the high court, in the meantime, he will lose the limitation.
Millers, the question here is, Millers, two folds I request, Millers. One is that when there was a clear instruction and the status quo, let us forget about other orders, Millers. 18.3 clearly gave an indication as to maintaining of the status quo. Now status quo is there. That is, auction has taken place.
It is merged with the final order.
The petition itself is disposed of.
Merged with the final order. I know how the
As on 18.3, I am telling. As on 18.3, I am telling. I completely bow down to you, sir. That proposition in the writ petition, what is the final order? Relegate it. They could have said, the relegate it is what the court has said.
Court has granted you 4 weeks time.
Yes.
4 weeks
Further,
time
they took
to
extension.
approach the tribunal, the DRT.
There
You have to have an order from the DRT. But
we
not from
approached it,
this
my lords. We approached. The position was that my essay itself was dismissed. That is the thing, my lords.
This is wrong submissions
Kindly see
making.
here.
The 14 application was dismissed when writ petition was pending. Now they have filed MA. After redelegation of this matter, they have filed SA. In last date of hearing, learned counsel appearing for the petitioner submitted, contempt petition is pending, date may be given. After taking that, now he files and this fresh writ petition here.
Without condoning the delay, they will not pass any orders, my lords. Kindly see the order passed.
How are you?
One submission, you can have a look up the, they are making allegation against the bank.
Please wait. Third party rights have accrued now. Why should we do it? There should be some legal ground for doing it.
my lords, all that I said was, I wanted extension of time, that was rejected. That is the origin. I wanted little extension of the time.
No, much water has flown from that day. Now your right to redemption has gone. Unless and until you show what is a fraud played by the bank in doing anything, you are not, that sale cannot be set aside. And once the auction notification is issued, you can't ask for redemption. Once you can't ask for redemption, then what has to follow?
My lords, why that has been done means, my lords, I have explained all these things I need to explain before the court. Now, whatever I do, my lords, even now, I can't be thrown out now. My respectful submission to your lordship is, everything will be result of this writ petition.
No, not this writ
No,
petition.
no, no.
I'll not keep this writ petition pending. You have to have your remedies before the DRT, whatever it is.
Then, my
Because
lords, what
this-
happens is,
you can't
delay is
entertain
there,
the
my lords.
scope of
Delay is there, my lords.
delay we cannot condone because it is a statutory.
Yes.
Matter was pending here, my lords, I couldn't go there.
No, if the matter is pending here, whatever the time you are before the court, you have to argue that under section 14
That's
of the
where, my lords,
Limitation
I'm
Act,
bringing
you are
to your
entitled
lordship
for
that
the.
I'll just bring that, my lords. I'm complete with your lordship as far as that aspect is concerned. We filed an application and the court said there is no specific order to condone the delay.
No, court will never go pass an order.
There is
to
no
condone the
provision
delay.
in the act itself is what the court
Correct.
has said.
What he says is correct. But it's the time which you have spent before the court that you are entitled.
No, that is a different proceedings altogether.
Altogether, that is a
This
different
whatever
proceedings
challenge in the
altogether.
earlier essay was order
It's not
passed.
with regard to the other essay.
Sale
Other essay,
certificate,
there been-
knowingly well, the sale notice was never challenged, my lord. So the division bench of this court has taken the view, my lord, that if you don't challenge within the time stipulated, it's barred by law of limitation.
I did not challenge that at that point of time for the simple reason that all that I was asking was the DRT said you have to deposit X amount of money. I was looking at arranging the money, paying them the amount. Now
No,
the
we do-
purchaser
we
is
do-
also ready, my
We
lords.
do understand the difficulties of the parties, but when we work within a framework,
We understand,
cannot,
my lords. I understand.
I'll pass orders. I'll dismiss the writ petition in that.
My lord, I
My
filed
absence
wakalat.
may kindly be excused,
Yes,
my lord. Colleagues.
I filed wakalat, my name will be there for the bank.
The afternoon I'll pass that you can tell the.
One more writ petition was argued before your lordship regarding custody matter, my lords. That was
Yes, that.
my client.
Yes, yes.
And that's serial number 71. my lord. I wish
No mention.
Yes.
Sir.
ನಮ್ಮ ಕ್ಲೈಂಟ್ ಔಟ್ ಸೈಡ್ ಇದ್ದಾನೆ ಅದೇ ಅವನು ಏನ್ ಮಾಡಿದೀವಿ ಮಾಡಿಲ್ಲ ಅಂತ ಅದು ಆಕ್ಚುಲಿ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ 49 ಅಡ್ಜನ್ ಆಗಿದೆಯಾ ಇದೆಯಾ ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಇದು ನಿಮ್ಮ ಕ್ಲೈಂಟ್ 49 ಅಡ್ಜನ್ ಆಗಿದೆಯಾ ಇದೆಯಾ ನೋಡಿ ಸರ್ ದಯವಿಟ್ಟು ಅಫಿಡವಿಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ ಇದೆಯಲ್ವಾ ನೀವು ನೆಕ್ಸ್ಟ್ ಪೇ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದೀರಾ ಅಂಡರ್ಟೇಕ್ ಮಾಡಿದ್ದೀರಾ ಲಾಸ್ಟ್ ಆರ್ಡರ್ ನಲ್ಲಿ ಇದೆ ನೋಡಿ
Serial number 25. Serial number 25.
ಡೇ ಬಿಫೋರ್
ಅದು ಮಧ್ಯಾಹ್ನ
ನೋಡಿದ್ದೀರಾ
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಏನ್ ಮಾಡಿ ಅಲ್ಲ ಅರ್ಜೆಂಟ್ ಆಯ್ತಾ 2:30 ಮಾಡ್ಬೋದಾ ಓಕೆ ಅರ್ಜೆನ್ಸಿ ಅಲ್ಲ
ಹಲೋ ಸರ್, ಇಲ್ಲಿ ನಿಮ್ಮ ಯಾರು ಇವರು ಕ್ಲೈಂಟ್ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅವ್ರು ಯಾರು ಕಾಣಲಿಲ್ಲ. ಒಂದು ಎರಡನೇದಾಗಿ ಅವರು ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಈಗ ಇನ್ನ ಮ್ಯಾಟರ್ ತಗೊಂಡಿಲ್ಲ, ಕಾಪಿ ಸೋಲ್ ಮಾಡಿದ್ದಾರೆ, ನಿಮ್ಗೆ ಫಾರ್ವರ್ಡ್ ಮಾಡ್ತೀನಿ ಅದನ್ನ. ಇಲ್ಲಿ ಕೋರ್ಟಲ್ ಒಳಗ್ ಈಗ ನಾನು ಕೋರ್ಟಲ್ ಒಳಗಡೆ
ಸರ್
71 ನಮ್ಗೆ
ಹೇಳಮ್ಮ. ಅದೇನ ಕ್ಲಬ್ ಆಗುತ್ತೆ ಅದ್ರ ಜೊತೆ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ಇದ್ರೆ ಕ್ಲಬ್ ಮಾಡ್ಬಿಡಿ, ಸಪರೇಟ್ ಆಗಿ ಪೋಸ್ಟ್ ಮಾಡಿ ಅಷ್ಟೇ. ಎರಡು ಬ್ಯಾಚ್ ಎರಡು ಸಪರೇಟ್ ಆಗಿ ಪೋಸ್ಟ್ ಮಾಡಿ. ಅದು ಕ್ಲಬ್ ಆಗುತ್ತೆ ಅದ್ರ ಜೊತೆ ಅಂತ ಹೇಳ್ತಾವ್ರೆ. ಇನ್ನು ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ಆಗಿಲ್ಲ ಕ್ಲಬ್ ಮಾಡ್ಲಿಕ್ಕೆ. ಕೋರ್ಟ್ ಆರ್ಡರ್ ಆಗುತ್ತಲ್ಲ ಕ್ಲಬ್ ಮಾಡಕ್ಕೆ, ಎರಡು ಬ್ಯಾಚ್ಗೆ ಸಪರೇಟ್ ಇರ್ಬೇಕು. ಅದು ಮೇಡಮ್ ಜೊತೆ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಡಿ, ಅದು ಜೊತೆ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ. ಒಟ್ನಲ್ಲಿ ಸಪರೇಟ್ ಎರಡು ಬ್ಯಾಚ್ ಕೇಸ್ ಇದ್ರು ಎರಡು ಬ್ಯಾಚ್ ಸಪರೇಟ್ ಪೋಸ್ಟ್ ಮಾಡಿ ಆಮೇಲೆ ಇಲ್ಲಿ ಬೇಕಾದ್ರೆ ಕ್ಲಬ್ ಮಾಡ್ತಾರೆ. ಮೇಡಮ್ ಬಂದಿದೆ
ಕೊಡಿ ಮೇಡಮ್ ಕೊಡಿ.
ಎರಡು ಬ್ಯಾಚ್
ಕೇಸ್ ಅಂದ್ರೆ ಅದನ್ನ ಅದು ಇದು
ಸಪರೇಟ್ ಮಾಡಿ
ಬ್ಯಾಚ್ ಆಫ್ ಕೇಸ್ ಬೇರೆ ಬೇರೆ ಇದೆಯಾ
ಇದೆಯಲ್ಲ ಜೊತೆ ಇಟ್ಕೋತೀನಿ, ಪೋಸ್ಟ್ ಆಗಲ್ಲ ಮೊದಲೇ ಹೇಳ್ಬಿಡ್ತೀನಿ
ಸರ್.
ಅದು ಅದು ಇದ್ರ ಜೊತೆ ಕನೆಕ್ಟ್ ಆಗಿಲ್ವಾ? ಆ ಬ್ಯಾಚ್ ಆಫ್ ಕೇಸ್ 60
ಅಲ್ಲಿ ಬ್ರಾಂಚ್ ಇದೆ.
ಆಯ್ತಾಯ್ತು. ಇವಾಗ ಯಾವ ಬ್ಯಾಚ್ ಇವತ್ತೆರಡು ಕೊಟ್ಟಿದ್ದೀನಿ, ಮೊನ್ನೆ ಒಂದು ಕೊಟ್ಟಿದ್ದೀನಿ. ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರಿಗೆ ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರಿಗೆನೆ ಅವನು ಇವತ್ತೆರಡು ಮೆಮೊ ಮಾಡಿದ್ದಾರೆ. ಕೇಳಿ ಅವ್ರಿಗೆ. ಅದೊಂದ್ರ ಜೊತೆ ಇನ್ನು 30 ಮೆಮೊ ಕನೆಕ್ಟ್ ಆಗಿದೆಯಲ್ಲ, ಆ ಬ್ಯಾಚ್ ಒಟ್ಟಿಗೆ ಬರ್ಬೇಕು. ಮೆಮೊ ಇಲ್ಲದೆ ಬ್ಯಾಚ್ ಆಫ್ ಕೇಸ್ ಈಗ ಕನೆಕ್ಟ್ ಆಗಿ ಲಿಸ್ಟ್ ಆಗಿಲ್ವಾ ಯಾವತ್ತೂ? ಈಗ ಬ್ಯಾಚ್ ಆಫ್ ಕೇಸ್ 60 ಜೊತೆ ಇಲ್ವಾ ಇದು? ಅಲ್ಲ ನಾನು ಹೇಳೋದು, ಆ ಬ್ರಾಂಚ್ ಕೇಸ್ ಇದಾರಲ್ಲ ಅವ್ರನ್ನ ಕರೆದ್ಬಿಟ್ಟು ಕೇಳಿ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 86 ಇದೆ ಅಲ್ವಾ? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 86. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಒಂದ್ ನಿಮಿಷ ಸರ್,
ಹೌದೌದು.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಮೇಡಮ್ ಸ್ವಲ್ಪ ಬಿಸಿ ಇದ್ದಾರೆ, ಹೇಳ್ತಾರೆ ಮಾತಾಡ್ತಾರೆ ಸರ್.
ನಂಬರ್ ನಾಳೆ 2:30 ಬ್ಯಾಚ್ ಮೆಸೇಜ್ ಕೊಟ್ಟರಲ್ಲ, ಅದು ನಂಬರ್ ಅಂತ ಇಲ್ಲ ಅಲ್ಕೊಂಡ್ ಹೇಳ.
ಪ್ರಾವಿಷನ್ ಯಾವ್ದಿಲ್ಲ, ಪ್ರಾವಿಷನ್ ಅಂತ ಫೇಸ್ ಯಾವ್ದು ಕೊಟ್ಟಿಲ್ಲ ನಮ್ಗೆ. ಅಡಿಗೆ ಸರ್
25 ಅಲ್ಲ 30 ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಮೆಮ್ಮ ಅಲ್ಲೇ ಕೇಳ್ಕೊಂಡು ಮತ್ತೆ ಬರಬೇಡಿ ನಮ್ಮ ಮೆಮ್ಮ ಯಾವುದು ತಗೊಳ್ಳೋದಿಲ್ಲ ಅಲ್ಲಿ ಕೊಟ್ಟದ್ದು ಅಲ್ಲಿ ಇಲ್ಲಿ ಬೇಕಾದ್ರೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಬೆಳಿಗ್ಗೆ ಬಂದು ಡೀಟೇಲ್ ಮೆನ್ಷನ್ ಮಾಡಿ ಬಂದಿರಬೇಕು ಫಸ್ಟ್ ನೋಡ್ಕೊಳ್ಳಿ ಏನಾಗುತ್ತೆ ಬೆಳಿಗ್ಗೆ ಟೈಮ್ ಅಷ್ಟೇ ತಗೊಳ್ಳೋದು 40% ಬೆಳಿಗ್ಗೆ ಬಂದು ಮಾಡಿ ಈಗ ತಗೊಳ್ಳೋದು ದೊಡ್ಡ ಆಗ್ತಾ ಇಲ್ಲ ಯಾವುದು ಮುಂದೆ ವಾರ ಇರೋದು ಜನ ತಗೊಳ್ಳೋದಿಲ್ಲ ಮೇಡಮ್ ಮಾರ್ನಿಂಗ್ ಅಷ್ಟೇ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ ಅದು ಮಾರ್ಕ್ಸ್ ಅಂದ್ಕೊಳ್ಳಂಗೆ ನಮ್ಮಿಷ್ಟು ಬಂದಿರೋ
ನೀವು ಊಟ ಮಾಡ್ಕೊಳ್ಳಿ ಫಸ್ಟ್ ನೀವು ಊಟ ಮಾಡ್ಕೊಳ್ಳಿ
ಟೋಟಲ್ ಫೈಲ್ಸ್ ಎಷ್ಟು 29 ಫೈಲ್ಸ್
ಅಲ್ಲ ಮೆಮೊ ಈಸ್ಕೊಂಡ್ರೆ ಏನಂದ್ರು
ಏನಂತಾರೆ
ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಇದೆ ಅಂತಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಅದ್ರದ್ದು ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರ್ ಅಂತಾರೆ ಇವರು ಒಂದು ಮೆಮೊ ಜೊತೆ 30 ಮ್ಯಾಟ್ರ್ ಇದೆ ಅಂತದ್ದು ಅದು 30 ಮ್ಯಾಟ್ರ್
ಮೆಮೊ ತಗೋತಾ ಇಲ್ಲ ಬೆಳಿಗ್ಗೆ ಯೂಸ್ ಮಾಡಿ ಟ್ರೈ ಮಾಡಿ ಅಂತಲ್ಲ ತುಂಬಾ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ ಇರುತ್ತೆ ತಗೊಂತಾರೆ ನೀನ್ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆಯಾ ವಕೀಲರನ್ನೇ ಹಾಕಿಲ್ವಾ ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಾಗಿದೆಯಾ
ಅಡ್ವೊಕೇಟ್ ಯಾರಿದ್ದಾರೆ ನೋಡಿ ಸರ್ ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರ್ ಮೆಮೊ ಕೊಟ್ಟಿರೋ ಅಡ್ವೊಕೇಟ್ ಯಾರು ಮಾತಾಡ್ತೀವಿ ಅವ್ರು ಒಂಚೂರು ಅವ್ರು ಫೈಲಲ್ಲಿ ಇರುತ್ತೀರಿ ನಾನು ಹೇಳ್ತೀನಿ ಅದು ಇವಾಗ 230ಗೆ 3 ಮೆಮೊ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅದ್ರದ್ದು ಬ್ಯಾಚ್ ಕೇಸ್ ಇದೆಯಂತೆ ನೋಡಿ ಯಾವ ಬ್ಯಾಚ್ ಅದು ಕನೆಕ್ಟ್ ಮಾಡಿ ಎಲ್ಲಾ ಫೈಲ್ಸ್ ಕಳಿಸಿ ಅದು ಕನೆಕ್ಟ್ ಆಗಿರೋ ಫೈಲ್ಸ್ ಎಲ್ಲನೂ ಎಷ್ಟು ಫೈಲ್ಸ್ ಇದೆ ಅದು 30 ಒಂದ್ ನಿಮಿಷ ಹೇಳೋದು ಅದು ಅದಕ್ಕೆ ಕನೆಕ್ಟೆಡ್ ಅಂತಲ್ಲ ಆ ಬ್ಯಾಚ್ ಮ್ಯಾಟ್ರ್ ಜೊತೆಲೆ ಅಲ್ಲ ಶಿವಮೊಗ್ಗಪ್ಪನೇ ಇವಾಗ ಏನ್ ಗೊತ್ತಾ ಅವರು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದಾರಲ್ಲಪ್ಪ ಅದು ಕನೆಕ್ಟೆಡ್ ಯಾವ್ಯಾವ ಫೈಲ್ಸ್ ಇದೆ ಎಲ್ಲಾ ಫೈಲ್ಸ್ ಕಳಿಸ್ಬಿಡಿ ಈಗ ಅದಕ್ಕೆ ರಿಲೇಟೆಡ್ ಫೈಲ್ಸ್ ಇವಾಗ ಅದು ಕನೆಕ್ಟೆಡ್ ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ಸ್ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅದೆಲ್ಲ ಒಂದೇ ಕ್ವಶನ್ ಹಾಕಲ್ಲ ಒಂದೇ ಇದೆಯಲ್ಲ ಅದು ಗೊತ್ತಲ್ಲ ನಿಮ್ಗೆ ಆ ಫೈಲ್ಸ್ ಎಲ್ಲನೂ ಒಟ್ಟಿಗೆ ಕ್ಲಬ್ ಮಾಡಿ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಕೊಟ್ಬಿಡಿ ಅದು ಯಾವ್ದು ಅಂತ ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗೆ 230ಗೆ ಅದು ಡೈರೆಕ್ಷನ್ಸ್ ಇದೆ ಮೇಡಮ್ ನಾಳೆ 2:30ಗೆ ಲಿಸ್ಟ್ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಇದೆ ನೀವು ಅದು ಯಾವ ಮ್ಯಾಟ್ರು ಅಂತ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಟ್ರಾಯ್ತು ಈ 230ಗೆ ಅಂತ ಮೂವ್ ಮಾಡಿರೋ ಮೆಮೋಸ್ ಅಲ್ಲಿ ಯಾವ್ಯಾವ ಬ್ಯಾಚ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆ ಅದು ಎಲ್ಲಾನು ಪೋಸ್ಟ್ ಆಗ್ಬೇಕು ಅದನ್ನ 230ಗೆ ಒಂದ್ ಕಡೆ ಸೆಪರೇಟ್ ಆಗಿ ಮಾಡ್ತಾರೆ ಅವರು ಸೆಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ ಅದನ್ನ ಅದೆಲ್ಲ ಫೈಲ್ಸ್ ಕಳಿಸ್ಬೇಕು ನೀವು ಅದಕ್ಕೆ ರಿಲೇಟೆಡ್ ಇರೋದು ಯಾವ್ಯಾವ್ದಿದೆ ಕನೆಕ್ಟೆಡ್ ಅದು ಕನೆಕ್ಟ್ ಆಗ್ಲಿ ಆಗ್ದಲ್ಲೇ ಇರ್ಲಿ ಅದ್ರದ್ದು ಅದಕ್ಕೆ ರಿಲೇಟೆಡ್ ಇದೆ ಅಂದ್ರೆ ಎಲ್ಲ ಕಳಿಸ್ಬಿಡಿ ಒಟ್ಟಿಗೆ ಓಕೆ ಓಕೆ
Madam, court officer, madam. Madam,
ಹೇಳಿ ಸರ್.
madam, pass over matters ತುಂಬಾ ಇದೆ madam.
ಪಾಸ್ ಓವರ್ ಒಂದೇ ಇರೋದು.
ಒಂದೇ, okay madam, ಸರಿ madam, ನಾನು ಬರ್ತೀನಿ. Thank you madam.
ಊಟ ಆಯ್ತಾ? ಮಾಡಿದ್ರು ಒಂಥರ ಕೇಳ್ಬೋದು, ಮಾಡೋದಿಲ್ಲ.
ಸರ್
You also same, sir. I don't know whether she will score or something.
ಅಷ್ಟೊಂದೇನಾ? I will not allow. What do you think? Wasted 1 hour, now you want to withdraw.
Another 1 hour.
See, ಬಿಡ್ತಾರ ಮೇಡಮ್ ಈಗ 1 ಗಂಟೆ ಆದ್ಮೇಲೆ? ಹಾಕಿದ್ದೀನಿ ಸರ್. ನನ್ನನ್ನೇ ಹಾಕ್ಬಿಟ್ಟಪ್ಪ. ಅವ್ರು ಹಾಕಿಲ್ಲ ಸರ್, ಅವ್ರು ನೋಡ್ಕೊಂಡು ಬಂದ್ಬಿಟ್ರು. ಈಗ ಮೋಹನ್ ನೋಡ್ಕೊಂಡು ಓಡ್ ಬಂದ್ರು. ಸೀನಿಯರ್ ಸರ್. ಎಸ್ ಸುಶೀಲಾ ಅಂತ. ಎಸ್ ಸುಶೀಲಾ. ನನ್ನ ವಕಾಲತ್ ಹಾಕಿದ್ದೀನಿ ಸರ್. ಇಲ್ಲ, ತಗೊಂಡ್ಬಿಟ್ರು. ಅವ್ರೆಲ್ಲರೂ ನನ್ ಬೇಕು ಅಂತಾರಲ್ಲ. ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ. ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಜಮ್ಮು ಕಾಶ್ಮೀರ. ಬ್ಯಾಂಕ್ ಆಫ್ ಇಂಡಿಯಾ ಜಮ್ಮು ಕಾಶ್ಮೀರ. ಸುಮಾರು ಕೇಸಸ್ ಇದೆಲ್ಲ
ರಿಸರ್ವ್ ಆಗಿರೋ ಮ್ಯಾಟರ್ ಅಲ್ಲ. ಅವ್ರ ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲಿ ಬಂದಿಲ್ಲಪ್ಪ. ಬಂದ್ರೆ ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿ ಅವ್ರ ಬಂದ್ರೆ ಕೇಳ್ತಾರೆ.
9ನೇ ಮ್ಯಾಟ್ 2ನೇ ಲಿಸ್ಟಲ್ಲಿ ತೆಗ್ಗಿಟ್ಕೊಂಡ್ಬಿಟ್ಟು
ಇದು ಫೈಲ್ ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋದು ಆಟೋ ಶೀಟ್ ಸೈನ್ ಮಾಡಿಸ್ಕೊಟ್ಟಿದ್ದು ಕನೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ರಾ ಹೇಳಿ ಸರ್.
ಸೆಲ್ ನಂಬರ್ 61 ಅಲ್ಲಿ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಅಂತ ಬಂದಿದೆ. ಅದು ಓಪನ್ ಆಗಿದೆಯಾ ಇಲ್ಲ ಸಾಬ್ರ ಓಪನ್ ಮಾಡ್ತಾರೆ?
ಯಾವುದು?
61 ಸೀರಿಯಲ್ ನಂಬರ್.
ಶೀಟ್ ಕವರ್ ಅಲ್ಲಿ ಇರುತ್ತೆ.
Where is the memo? Where is the case? 41.
41.
Spending half an hour, my lord, now they are in front.
It's okay, it is not, it shouldn't be a problem to you. Memo is fine. Seeking
Cell number 41.
to withdraw this petition with the liberty to file appeal before the Redelivery Tribunal.
Already there is appeal, madam. Where is it?
Accordingly, a petition is disposed of, giving liberty to the petitioner to avail the appropriate remedies available to him in accordance with law.
Time spent before this. No. One excluded.
How can you, how many appeals you can file?
DRAT 30 days time is there.
Huh?
If within 30 days, we have to go for appeal. So we are filed the application more than 3 weeks.
When was this petition filed before the court? Give the file.
Filed on 5th November.
Hmm?
5/11. 5/11.
The
Section 18, my lord, they condone the delay. There not be a specific order with that regard. Any order passed by DRT, 30 days time. My lord, there is.
I understood that the appellate court has got the
power.
You know, the matter was pending here. What is the difficulty for the bank?
Let there be specification like DRAT. Again, he should not come to DRT and tell that there is a
DRAT
only. I'm filing before DRAT. Let there be.
It is that he wants to approach the DRAT questioning an order passed. That order is dismissed.
It's not dismissal.
Miscellaneous non-considering of the application, miscellaneous application filed by the
IA, not IA, miscellaneous.
IA in the miscellaneous application by the DRT. The petitioner wants to approach the DRAT. The time that is spent before the court shall be excluded.
Two, Your Worship. That serial number 9, stay has to be granted, Your Worship. Serial number 9 in 2, second list, stay has to be granted because our order stay is pending, that's why, Lordship. That is barred by limitation. There is the, Your Lordship,
Why
already.
is it pending for, a stay petition is pending? When did you file this?
Along with the appeal only, but they are not this one. That's why we are already this one. Barred by limitation.
Let's see, what is that? When is the, is,
Lordship,
14%.
you can't come and move whenever you want to.
Posting. She wants to get the maintenance of it. They already deposited before the registry.
That we will not consider. Yes.
Lordship, 2824. Action date.
When was the complaint filed?
2823. Action date.
When is the amendment?
That is 1422. 14.
22.
Yeah.
With how much delay this filed?
600, 1.5 months.
100 and
It's a case of death or injury.
Injury, madam.
It is submitted that the IA number 2 of 25, it is submitted that the complaint is, the claim petition is barred by limitation and these aspects were not considered by the tribunal. Considering the same, there shall be stay of all further proceeding, 50%, 4 weeks, notice to the respondent.
list number 2 in the month
All
of
matters.
January. In the month of January.
Yes.
Passed over matter in 1 month.
Hmm.
List number 1, passed over matter. Cell number 25.
Yes. What is the amount?
Admitted amount.
Now, what is the total compensation?
Total compensation is 10 lakh.
Hmm. According to what is the admitted amounts by you?
7 lakh 48,000.
Is admitted.
We are ready to pay that much.
It is submitted that the court on all the counts has granted the compensation which is on the higher side. Considering the submission of the done counts for the applicant, they shall be stay of all further proceedings on the condition that they shall deposit 7 lakhs within a period of 4 weeks. On such deposit, the respondent is claimants are at liberty to withdraw. Next.
Cell number 42.
Yes.
List number 1, serial number 42.
I appear for the petition.
Need to appear for the respondent.
Was rupees 9,60,425. The notice dated 5/9/2020. That annexure A, my lord, page number 30.
No, what you have questioned before this court?
The auction notice, my lord, that annexure J.
Yes. What is outstanding?
Yes, madam. Actually, in the demand notice, the accrued interest is not mentioned, madam.
Hmm.
In fact, totally it is about 14 lakhs. And they have paid 9 lakhs, which we have incorporated in the statement of accounts. So also served a copy in there, madam. And now the outstanding is 6 lakhs as per the sale notice. So we have incorporated whatever payment they have made.
My lord,
And I have served a
we
copy
have,
of the.
we have addressed multiple representations to the bank to issue the loan statement, my lord. They have not reverted it back there.
That is not a ground to, stall the sale.
My lord,
If they are not doing it before that, there was 13-4 notice. Before that, there is 13-2. We should have gone before the DRT.
as per annexure A, the outstanding loan was 9,60,425 my lords, admitted by the bank itself. It is at annexure A, my lord. Thereafter, within 60 days, we have paid 8,75,000. The balance was rupees 95,000, my lords.
Not the outstanding amount plus interest, my lord. It's the principal, the accrued interest was not included in the demand notice.
Why you will not include? You will include the interest also.
Include the interest in this case.
Demand is along with the interest.
Yes, my lord. As on date of the NPA, normally what happens is, my lord, the interest upon classification to NPA, the entire interest gets reversed. And so therefore, sometimes it is not reflected in the live server. So ledger balance, whatever amount, but they have mentioned plus accrued interest. So whatever amount has been taken, has been paid by them subsequently, has been taken into account. And very clearly it is reflecting in the statement. I produced that.
But they are not informed us about that. They served the copy now. We have to take instruction from the client, my lords. But
This is a matter on Monday.
my lords, tomorrow is the auction, my lords.
No, tomorrow that out of the 6 lakhs, how much you are ready to pay?
My lord, the outstanding is only 95,000, my lords.
Outstanding is not what you say. That we cannot consider also. Whether their calculation is right, your calculation is right. How can we consider?
My lords, as of now, we are ready to pay 95,000, my lords, whatever the amount is pending as per their notice.
Lord, if they are actually
Interim
willing to
order may
pay
be
some,
granted, my lord.
clear the entire dues because it's about 6 lakhs.
But the whole dispute is that according to them, it is
Then
95,000.
they have to approach the DRT. But in case of dispute.
My lord, she is a senior citizen, my lord.
Let him pay that 95,000 by tomorrow. Get your
sir,
complete
we've signed-
statement of accounts.
It's here, my lord. I'm producing it.
Look
Okay,
at
but
it.
I've also, yes, I've produced the loan statement account. I've given them a copy. It's clearly mentioned, my lord, 6 lakhs 20.
Let the auction go on, let it not be finalized.
My lord,
Let the auction go on, let it not be finalized. In the meantime, we can see, if you're not coming forward, if that is 6
my lord,
lakhs
sir,
and if
we'll
you're not
sign
coming
may be granted,
forward,
my
then
lord.
they will.
We'll pay the 95,000, my lord. Interim stay may be granted. And let us, let the bank.
That's what I'm
issue
saying.
notice.
We'll say not to finalize. Not to finalize, auction will go on.
My lord, sir, she's the only.
So what
brother.
will happen? The land council with the petitioner submits the outstanding amount is 95,000. According to the land council appearing with the bank, after adjusting the amounts that are already paid by the petitioner, the outstanding as on today is 6 lakhs.
Yes, ma'am. 6 lakhs 23,000 as on whatever. is
6 lakhs 23,000 and accordingly they have issued the auction notification and the auction is scheduled to be held tomorrow.
Tomorrow, yes.
Tomorrow. The land council submits that he's ready to pay 95,000 by tomorrow.
My lord, sir, within a week, my lord. She's a senior citizen, my lord. She's the only bread earner. She's running a small shop, my lord. Seafood shop. She's not able to pay by tomorrow, my lord. However, within the 60 days of notice, she has paid the 90% of the amount as per the notice, my lord.
It is submitted that they are ready to pay an amount of rupees 95,000. The auction shall go on, but however, the respondent bank shall not finalize. The petitioner shall pay an amount of rupees 95,000 to the bank by 18th of December.
The date may be given, my lord. This is the auction.
Let's just matter on 19th. If you don't pay on that day, I'll vacate this one.
Cell number 43. Ranjan Kumar, K for petitioner.
Mandamus for direction. Mandamus for direction to consider the letter submitted by the petitioner to the bank. So happened, my lord, there were 2 loans. Out of this, my lord, they gave an option for us to settle it for one-time settlement, and they asked us 5 crores. Now 370.
Till now, notice is not served on the issued to the respondent bank.
No, it is not. I have issued a letter to them, my lord, asking them to settle.
Karnataka bank, who appears?
Divya Purandar.
So and so is directed to take notice, serve the papers on her. This is the matter next week someday. Is 44.
Yes. Cell number 42.
44.
44.
For the petitioner, my lord,
V Mohan.
already challenging the sale, my lord, already sale is concluded. They issued the sale and challenging the sale, my lord. It's a totally collusive fraudulent sale. Maybe it takes summons to.
So why should you come here? Why don't you go to the DRT? Now the sale is also
Total
concluded.
fraudulent case. If no notice has been served. Even they didn't publish the sale notice. Without publication of sale notice, they conduct the auction. No notice is served.
Union Bank of India,
Union Bank.
erstwhile Corporation Bank.
Vignesh Shetty, Union
Could
Bank of
you
India.
appear? So and so. Serve the papers on her.
Divya
Next week.
Purandar.
Is 45?
Cell number 45.
Lord, I appear for the petitioners. Lord, the petitioner is approached under section 14 order before the DRT. Lord, DRT has come to be dismissed on the ground that, my lord, in view of the order passed by the division bench of this honorable court, the application came to be dismissed, my lord. Your lordship kindly see the impugned order of page 63.
Limitation.
Lord,
Limitation.
limitation.
Divya.
When was the order passed by
Lord,
the
order
magistrate?
was passed under 6/6/2022.
Huh?
6/6/2022.
When was it affixed? According to you, when is the date of knowledge?
Lord, date of knowledge, my lord, I have received the certified copy, my lord, and
Not certified copy. When was it affixed on your, on
no
on the
effects, no
premises?
communication, no
The
effects.
premises,
They have not affects, my lord. They have not filed a statement of objections, my
then we
lord.
will issue notice.
Lord, one submission, my lord. There is a due as on the date of 14 order,
Whatever
my
it
lord.
is, after the
My lord,
respondent enters appearance, then only we will hear all
1
this.
crores 3,50,934. Out of it, my lord, DRT is granted stay. subject to deposit 25%. My lord, 25 lakhs, 88,000 was
Can you
deposited.
hand summons on on the respondent?
Lord, they are
Once-
taking, dispossessing, my lord. I am ready to pay
Memo is-
20% within 4
Then
weeks,
I
my
will
lord.
not grant that kind of orders. The hand summons to the respondent. Once the memo is filed, list the matter.
Number
Lord,
46.
one submission, this honorable court in similar situation
I
annexure
am not
G.
granting those kind of orders, 10%, 20%, I will not grant.
Not my lord, the learned single judge of coordinate bench of this honorable court condone the delay in section 5 is applicable to
But
them.
without notice to the respondents, that also will not. do.
Date may be fixed, my lord.
If you file the memo, it will come by serving the hand summons on the respondent.
Lord, the date, otherwise the date will, Lord, I will file memo on day after tomorrow, my lord.
It will come. If it is not, you please mention, we will list the matter. Yes, next.
Cell number 46, Vinay Swami C.
My lord, the petitioner is residing in Dubai. He is earning around 30,000 dirhams per month. That would come to around 6 lakhs
For
per
a minute,
month.
I thought it is a DRT matter.
No, my lord, this is a family.
What is the amount that is granted?
25,000 is what is awarded.
Mm.
My lord, I am earning 6 lakh rupees.
Mm.
It is not about not maintaining my wife.
Mm.
There's something more that meets the eyes. What has happened in this case is, my lord, that the respondent is staying in my house here in Bangalore. She is admitted she is receiving 20,000 per month.
Hmm?
20,000 per month, she is admitted she is receiving.
Receiving from you.
She is having income of 20,000 rupees per month. The issue is we have a joint account between me and her. 16 lakhs was in the joint account. 10 lakhs has been taken by the father-in-law. My father-in-law is no more now. My mother-in-law is also staying with my wife in my house. They have rented that property also. Apart from the 16 lakhs that they have taken, there are
When
about
they have taken 16 lakhs?
she has withdrawn that money.
When?
They themselves say in if your lordships goes to page number 18, they themselves say in paragraph 13, the respondent has produced documents as Kata certificate of property bearing so and so, her Canara Bank account statement in SB account number so and so, from 27/1/2021 to 11/2/2022.
Long back,
Pardon, my lord?
long back.
2022, my lord.
You're in
But-
2025.
But 16 lakhs is not only that amount, my lord. Apart from that, another 8 lakhs was transferred to her account, which was a mutual fund or something which has come to her. She has received about 30 lakhs. We are not, the issue is she is actually not in a capacity to manage herself. And her mother-in-law is one who's taking care of her. What I am trying to say is, my lord, let them explain 30 lakhs for these 2 years, what they have done.
For that, they have to come.
Yes, my lord. Until that, I'm only saying I have 25,000. I have 2 daughters.
That is what exactly I told your colleague yesterday. 25,000 is not an amount.
Yes, my
Let the
lord.
respondent come, we'll hear the
The
matter.
only thing that I would like to say is, my lord, why I'm seeking for a stay is I got 2 daughters. One daughter, both the daughters are with me. I'm educating both of them in Dubai. One is now
Both are staying with you.
staying with me, my lord. I am taking care of their education. I am staying in a rented house there. I've put in the expenses that I'm incurring. One of my daughter now is 18. She is now studying in London. There's huge expenses that I'm incurring.
And counsel for the petitioner submits that the court has granted 25,000 per month as maintenance to the wife. The petition is staying in Dubai along with his 2 daughters and he's taking care of the 2 daughters. It is the submission that the wife had withdrawn an amount of rupees
14 lakhs, if I'm.
14 lakhs
And she's got 8 lakhs and 1 lakh. 14 lakhs is
oh,
what.
you said something like mutual funds.
There were mutual funds is there, but she has out of the 18 lakhs which is there, entire 18 lakhs is withdrawn.
18 lakhs amount is withdrawn by the wife from the joint account. Petitioner is spending substantial amount towards education of the children and the court without the daughters, the court without considering all this has granted an amount of rupees 25,000 as maintenance. Considering the submission of the land council, there shall be stay of all further proceedings. Pursuant to the order dated so and so, the petitioner shall take out hand summons on the council appearing for the respondent and file a memo to that effect. January give some date. if by the time the memo is not filed, on the stay granted by this court's transvacated.
Permit me to serve on the advocate appearing.
Advocate,
Yes, sir, and summons.
yes,
Still number 47. Summons.
Petitioner husband.
yes.
The criminal miscellaneous 531 of 24, the matter was referred to mediation. Matter was settled before the mediation, wherein I agreed to pay 45 lakhs rupees. Matter comes before the court. I pay first installment of 15 lakhs, she takes that 15 lakhs, and some of the jewelry is also I give. Next date, when I was supposed to pay second installment, she remains absent. Third is installment, when I have to pay the last installment, I'm ready with both the checks. She comes and says that there are some more items to be received. Therefore, she doesn't want to accept the report. Having taken first installment as per the MOU,
How much is the first installment?
15 lakhs. Another two installments,
What is impugned order?
impugned order that the court says that since she may kindly page number 29. Sorry, Mila, page number 33. Respondent has brought to,
MC was sent for mediation or criminal miscellaneous?
what had happened is HRRP came to be dismissed, my HRRP, against which SLP, I have preferred an appeal pending before the Honorable Supreme. In the meantime, they filed this miscellaneous to recover that amount, the arrears of maintenance. In that proceedings, matter get refers to mediation. There it was settled finally for 45 lakhs. Now, first installment she takes up and accepts it. Once she accepted the first installment, there's nothing remains to accept the report.
Petitioner submits that before the mediation, respondent orally agreed for returning her saris.
No, that is not part of your lordship, man. I have reproduced.
And if he returns the same, she is ready to accept the settlement.
In fact, I filed a memo to that effect, that, whatever I have sent the photographs of those saris, also Almara was open.
Submits that nothing remains to be there, returned to the petitioner.
Yes,
Hence, it is taken that petitioner has not accepted.
No, Milan. After that, I have filed next date hearing, I filed a memo also saying that I'll produce it. But again, they started demanding who will use those used items. And my lord, it is not my items. See, just to harass me, lord. Just for that. If your lordship can see the pay.
No, miscellaneous is filed for recovery of the maintenance amount.
Please, ma'am.
Now what will happen?
I'll proceed with.
That's what. Whatever amount you have paid, 15 lakhs, apart from other thing, any recovery, any amount has to be paid, you will pay. So now by coming before this court, what is that you are expecting?
My submission to your lordship is, by accepting the first installment, the mediation report has been accepted. Only obligation left was whether I will make the payment on the time schedule or not has remained. Now the court says that report is not accepted in view of the objection, the contention of the respondent. Report has been accepted by receiving an installment. There nothing remains to
Both
accept.
of you have signed on any agreement?
Yes, Mila. No, agreement is signed. That agreement is not produced because that has been not accepted by the court. They are not issuing a certified copy. Now, if your lordship sees, I have reproduced the entire agreement in page number 7.
Notice to respond.
I may be permitted to take notice on the council appearing in the family court, and in the meantime stay there.
Why stay?
Because they may initiate for recovery of amount. This is
The amount, what is outstanding amount?
And
EP amount?
EP amount according to them was 20 lakhs.
You already paid 15 lakhs.
15 lakhs paid and jewelry is paid.
Counsel for the petitioner submits that. When the miscellaneous is filed for recovery of the maintenance amount, the same is referred to mediation. In the mediation, the petitioner has accepted to pay 45 lakhs.
Yes,
as a full and final settlement. Initial 15 lakhs he has paid, she has accepted. And for the next 2 installments, when he is ready with the amount, she has not turned up. And the court records that there is no such settlement.
Acceptance.
Such acceptance. It is submitted that when once the mediation report is accepted, the settlement is accepted by her, and she has accepted the first installment. No, she cannot turn around. And the court ought to have considered this aspect. Considering the same, there shall be stay of all further proceedings. Notice the petition is permitted to take out hand summons on the counsel appearing before the trial court. In the month of January, memo shall be filed, or else the stay granted with this court. Stands vacated.
Highly obliged. Grateful to you, Lordship.
Cell number 48 adjourned. Cell number 49. Rudra, Bhushan.
Lords, and for the petitioner in this case, my lords, in this I have challenged demand notice which is issued by respondent bank. My lords, on 29/11/2022, page number 28 and 29 of the writ petition, my lords. My lords, they had issued demand notice on 29/11/2022. Page number 28 and 29 are the relevant pages, my lords. My lords, in this, there are three properties. One is agricultural land and another is agricultural land and the third one is also agricultural land. My lords, the next page, annexure D, page number 31. This possession notice also pertains to the same agricultural lands. There are three properties. My lords, these two demand notice which were issued in 2022, which were which are caused by Honorable DRT in SA 161 of 2023. The said order is at page number 33.
On what ground they are
My lords, on the discrepancies of the outstanding amount mentioned in the demand notice and possession notice. My lords, they have issued one more demand notice at page number 17, my lords. Page number 17 is the latest demand notice. 28/2025. My lords, in this, page number 20 is the relevant page, my lords. My lords, in this, surprisingly, they remove the word agriculture, agricultural, and they only say land in survey number 105, land in survey number 107/2.
First round of litigation, this issue with regard to the nature of the land was raised by you?
Yes, my lords.
What did the tribunal say?
My lords, the tribunal did not opine on that contention which I had taken in 161 of 2023. My lords, in this, survey number 245 is also mentioned, but
So
the
what does
fourth.
it mean? What does it mean? You have question on the ground of agriculture, that's it's an agriculture land.
Yes,
And number two is with regard to the
discrepancies on the outstanding amount
So
mentioned.
court told, the tribunal only said only with regard to the discrepancy. With regard to the agriculture, there should have been a finding on that.
Yes, my lords, there is no finding, my lords, but in this 28/2025, there is inclusion of one more property which was never mentioned in 2022 demand notice and possession notice, that is at page number 4.
Mortgaged or not?
My lords, for this demand notice, I have also replied under 13(3)(a).
This property is mortgaged or not?
My lords, it is mortgage. It is mortgage.
If it is
My
not
lords,
there in the earlier notice, that it will not preclude the bank from.
my lords, I'm just
showing
pointing
the
on,
property.
I'm just pointing out that that property was not at all mentioned in 2022 demand notice and possession notice. My lords, for this demand notice,
What is wrong, it is set aside for
Let's-
whatsoever reason.
just two more submissions. After the demand notice was issued, I have replied on 16th October 2025, my lords. My lords, to that reply, they have issued a reply notice on 30/10/2025, page number 22. I'll read the relevant parameters. The very fact that the scheduled properties are mortgaged, the bank gives the secured creditor to proceed under SARFAESI Act, and the secured properties are also not put to agricultural use. My lords, I'm relying on one of the judgment passed by this honorable court. My lords, admittedly, these properties are agricultural properties and there is a poultry farming going on in these scheduled properties. My lords, page number 7 of my judgment, my lords.
Some matter has come up of,
My lords, I'll just point out one of the paragraph in that judgment, my lords. Page number 7,
we'll see the law later, let's understand the facts.
my lords, page number 7 of my judgment.
Yes.
He initiated 13 to 13(4), etc., and he referred an essay before the DRT. Where DRT given an order, I just point out that order. In view of I issued 13(3)(a) not given, reply, and some discrepancy in the amount which I mentioned, that is the reason set aside by the 13(4). Lord kindly come to the order passed by DRT, page number 13.
No, now coming to the aspect, whether it is agriculture land or not.
It's not. I'll point out from the record only, in fact, their objection.
In the earlier round, when you issued a 13(2) notice, in that have you stated that it's an agricultural land or not?
I stated before the DRT it is not agricultural property, and in fact they said I constructed 500 lakh rupees shed over the property, and shed is there, house is there, Then my lord, in ITC's blue question is very clear. Even though some portion, some activities there, doesn't mean that my lord, it's agricultural property. There is no agricultural activity going on. That is one aspect. Apart from that, now my lord, I should remand notice on my lord 28 2025 annexure A. My lord, pursuant to my lord, the DRT passed an order saying that you are not given a 13.3. I am not preferred in the appeal. I thought of it as viable for me to issue remand. Then they given a reply. That is at page number 49. But kindly see for a moment. It is app says that if they agree, they can give a reply. In the reply which they are given, not even one word about agriculture property. Kindly see that. What I should consider? But kindly come to NHL page number 49.
Malaj, on submission, if there is no one word about agricultural property in the reply notice, why is there a para number 3 regarding agricultural use? They themselves have mentioned that the scheduled properties are not at all.
Let us read from the
Yes,
papers.
yes,
Why should
yes.
we?
Kindly come to
Yes.
page number 49 for a moment. Annexure L.
Where is his reply?
They
Page
give
number-
a reply to my 13.2 at page number 14 and annexure L.
Please read that.
2025. The demand notice you had reached so and so dated. They're telling a lot some difficulty which I faced.
There is something wrong with the page numbers.
Malaj, page number 49. Page number 49 of the writ petition.
49 to my lord 51,
52.
They say stating in the last few lines. In fact, Miller nowhere they said it's agricultural property. In the light of all the above stated facts, circumstances, we strongly believe having been targeted by the bank, etc., etc. So next, in spite of your earlier demand which position notice that passed by the DRT, Bangalore pending OA pending before the DRT in Bangalore, you are desperate to repeated attempt to fix or sector loan, agricultural sector loan under the Service Act 2002. Give rise to the questions we strongly believe and of the opinion that probably you are scared to establish your claim before the court of law, and hence you desperately try to seek shelter or protection under Service Act 2002. With all your above facts, so reiterate that you are not willful to.
So please tell from this your reply under 13.3.
No, subsequent to that, I consider 13.3. Now, my lord, one more development. I should 34 also. Now, at the most, my lord, this in whatever they are grown. In fact,
No, let him say, let him show, let him,
19
please show from this 49 reply.
Yes, madam.
Where did you say that our land is agricultural land and
Malaj,
the surface proceedings are
the
not?
first para, the third para, we are surprised and shocked to notice your good self's understanding about the provisions / guidelines of Surface Act 2002. Though the agricultural sector advances borrowing
That is
accounts are
not one and the
exempted.
same. Agriculture sector advances, borrowing
Malaj,
accounts.
the last page, Malaj, page number 52.
Yes.
In spite of your earlier demand notice and possession notice, which were caused by Honorable DRT 1 Bangalore and pending OA is pending before Honorable DRT 1 Bangalore, your desperate and repeated attempt to fix our agricultural sector loans under the Surface Act give rise to questions. Well, we have said that these are agricultural lands, even if it is not mentioned. Assuming that even if it is not mentioned, it is already mentioned in our reply notice. They have replied to this reply notice stating that those poultry farms doesn't come under agricultural use. For that, Malaj, I have produced a citation, Malaj's judgment. I may be permitted to read this specific paragraph, Malaj. Page number 7.
agriculture activity going on there.
Yes, Malaj. Page number 7 of my judgment. Page number 7 of my judgment. As observed by this court in E. Bhaskar Rao's case, a poultry farm is an agricultural activity and does not require the land to be converted to a commercial purpose for putting a construction thereon, usage thereof for business. If that be so, a building which had been put on agricultural land cannot be to be said a commercial building coming under so and so. The land continues to be an agricultural land, and the poultry farm cannot be said to be a commercial activity entitling the panchayat to levy any tax, let alone under the said provisions. Malaj, this is the judgment, Malaj. Malaj, there is Karnataka Town Planning Act. In that also there is definition for poultry farm. I may be permitted to read, Malaj. Agriculture includes horticulture, farming, growing of crops, fruits, vegetables, flowers, grass, fodder, grease, and or any other cultivation of soil, breeding. Malaj, Karnataka Town Planning also mandates that, also states that poultry farm come under agricultural activity. And also, Malaj, Karnataka Land Reforms Act 1961. In the definition, they also state that Section 2D, my lords, definitions, poultry farm come under the agricultural lands. My lords, based on that, 13(2), which the respondent bank has issued, is illegal and is against the laws laid down by the legislature in SARFAESI and Karnataka Land Reforms Act.
Where is the law laid down in surface?
My lords, there is a law laid down, my lords.
Saying that,
My lords, section 31I.
it says poultry farming is
It's
agriculture.
told it doesn't say that poultry farm exactly, but it says that any security interest created in agricultural land. My lords, this poultry farm comes under agricultural land.
Yes, yes.
It's a matter of fact, there is a house, there's a shed, their entire case is into the DRT earlier. I have invested 500 lakh rupees to construct the shed. It's not saying by the poultry and house, whatever. It's also by instruction, oral instruction, just to my body. There is no agriculture activity there. There is no agriculture activity. There is no farming or some farm is not there. It's all shed and houses there. That is one. Even though nomenclature is agriculture land, there is no agricultural activities going on. Therefore, ITC uses blue post judgment when there is no bar for the bank to proceed further.
What is the judgment?
ITC uses blue post. It says that, for example, there are 3 land. Out of that one portion of the property, even though there is an agricultural activity is there, by the Honorable Apex Court, I will produce a judgment tomorrow and one more judgment, Ravichandran judgment in Honorable Andhra Pradesh High Court. It says that there is no bar for the bank to initiate the action against poultry farms. That's 2 judgments. In that land, that judgment, it says that ITC uses blue post, where even though there is an agricultural activity is going on, there are surrounding or some other land, it is not used for agricultural land, there is no bar for the bank to proceed further under sufficient. One aspect. Now I took a 13(4). And 13(2), there no point of time they said that my property is agricultural property. I given a reply. Act says I have to give a reply within 15 days. That I read. My lord can find it at page number 22. I given a reply as per required by law. Now I issued a 13(4). 13(4) issued 1 month before. They can challenge this issue also. Let them take up before the DRT. Kindly see the outstanding. It is nothing but delay tactics before this honorable court they are playing. It's more than huge outstanding. There are 19 crore rupees. As on today.
How much?
18 crore, can you come to page number
19 crores.
18 crore,
18.97.
7 lakh, they don't want to pay any money. Earlier rounds of litigation, they have taken some other defense and DRT orders, can you see, only on 13(3)(a), nothing else. The DRT set aside 13(4). Now they are coming to this honorable court saying that, no, our property is agricultural property, even though there is no registration.
Well, there is an OA pending before DRT.
OA is something different.
There is an OA pending before DRT. And RDDBA effect, they have initiated. And there is no bar against agricultural property and SARFAESI.
So why can't you go before the tribunal?
Malats, there is a question of law in this writ petition. Malats,
that question, nowhere that question of law DRT can't decide.
Malats, last time in SA 161 of 2023, which I had questioned that these properties come under agricultural land and they themselves have stated in demand notice and possession notice that those properties are agricultural land.
You have borrowed an amount of rupees 19 lakh crores.
Yes, Malats.
So without paying the amount, on some ground or the other, you come before the court saying that it is an agricultural land. Then why you are not paying the outstanding amount?
I am not running away from the debt, Malats. Malats, I am only stating that there is an OA pending before DRT. Malats, they have filed their petition before DRT and under RDDB and FAC. I have filed my written statement. If there is a decree against me, I'll pay it, Malats, not under SARFAESI, Malats, because they themselves have.
DRT decide that.
Malats, they themselves in their demand notice and possession notice have stated that these properties come under agricultural land.
You have an alternative remedy, go there. But
Malats,
but not to these kind of litigants. You have borrowed 19 crore rupees.
Malats,
you come before the court with all these technical
Malats,
grounds.
there is a home loan as Malats, there is a home loan as well. That is including that, Malats.
The writ petition is filed, seeking the following prayer. The petitioner has borrowed the amount from the respondent bank by mortgaging the lands. According to the petitioner, those lands are the agriculture lands. And he has established a poultry farm in the same. It is an agriculture activity. and the bank cannot initiate the surface proceedings. In the earlier round, in the year 2022, when the bank has initiated the surface proceedings, petitioner has approached the DRT and filed SA number 161 of 2023, dated 31st July 2025, whereby the DRT had set aside the proceedings initiated by the bank under section 13(2) on the ground that
Page number 46, paragraph 22.
that the demand notice under section 13(2) is a foundational statutory requirement, and the borrower's right under section 13(3) are directly linked to the accuracy of the amount demanded. An incorrect statement of dues in the demand notice defeats the object of giving the borrower a fair opportunity to make a representation, to take remedial measures, and such a defect goes to the root of the proceedings. Further, the representation dated 25/1/2023 made by the applicant after 63 days from the date of demand notice does not require consideration under section 13(3) of the Surface Act. However, the delay in representation does not cure the fundamental defect in the demand notice itself. On this ground, the tribunal has allowed the SA. Thereafter, the bank has issued the demand notice dated
28, 2020.
20.
August 2025, and it's page number 17.
On 31/7/2025, the bank has issued another demand note.
That's on 28.
Bank has issued the demand notice dated 28/2025. After the petitioner has given a reply dated 16/10/2025 to the demand notice, raising the agriculture exemptions under section 31I. After that, he has filed WP number.
Considered and given reply on 22, page number 22. That their reply I consider.
He given a reply and the bank has given a reply under section 13(3)(a). The petitioner filed WP number 32523 of 2025. And the same was disposed of, stating that it was premature because the bank had not replied to the petition's letter dated 16/10/2025. It is stated that the bank's reply is dated 30/10/2025. It is stated that the properties that are mortgaged are not used for the agriculture purpose. Then counsel appearing for the petitioner submits that the properties, the poultry farm is it is a, what is that? It is a agriculture activity.
Agricultural.
Comes under the agriculture activity. Hence, the surface proceedings cannot be initiated. He had relied on a judgment, an order passed by a coordinate bench of this court in K. Narasimhamurthy versus Sondekoppa Gram Panchayat and others, arising out of red petition number 38871 of 2016, dated 5th September 2023. He relied on paragraph number
9.
9. Relying on this, land council submits that the initiation of the surface proceedings is bad and the same has to be set aside. Next, land council appearing for the respondent bank submits that in the earlier round of litigation, the essay is dismissed only on the ground that the essay is allowed on the ground that there is discrepancy with regard to the amount. Later, when they have issued the demand notice, petitioner has sent his reply. In the reply is silent about the nature of the lands, except saying that they are entitled for what did they say? Agriculture. That where is that reply? Page number?
My reply, Page number 49. Page number 49. And the relevant para
is
is at page
stated
number
that-
52.
That the agriculture sector advances oblique borrowing accounts are exempted under the provisions of the Surface Act. It is submitted that they have given a detailed reply to the same under section 13(3)(a), stating that the lands are not used for the agriculture purpose, as such the petition is not entitled for the benefit and the surface proceedings can be initiated. It is submitted that the outstanding,
13(4) also issued.
and they have issued the 13(4),
1911 to
1911,
2027.
2025. It is submitted that as on today, the outstanding amount is an amount of rupees 19 crores and odd.
Well, that's 18 crores.
Huh?
18 crore 97 lakh.
18.
18 crores 97 lakhs and odd. It is submitted that it is the petitioner has an effective alternative remedy and the DRT will adjudicate all these questions that are raised by the petitioner and the petition is not maintainable. In response to that, then counsel with the petitioner submits that it's a question of law as such has come before this court. Next para, having heard the counsels on either side, that is the material on record. As on today, a substantial amount of rupees 18 crores and odd is the outstanding. This court has perused the demand notice, the reply, and also the reply given by the bank under section 13(3)(a) of the Surface Act. All the issues that are raised before this court, the petitioner as well agitate the same before the DRT, considering the substantial loan amount that is outstanding. This court is not inclined to interfere, inclined to pass any orders in this petition. Hence, the court is passing the following order. The petition is disposed of, giving liberty to the petitioner to avail the remedy before the DRT. From today, for a period of 4 weeks, the respondent bank shall not take any coercive steps.
Grateful.
The period the petition is pending before the court, petitioner is entitled for the said exemption.
Malaj, can it be 5 weeks, Malaj? Can it be 5 weeks, Malaj? 4 weeks. No, Malaj. Malaj, 5 weeks, because in the last week I won't be in town, Malaj.
5
That's-
weeks. Yes.
Grateful.
Mr. Vignesh Shetty accepts notice on behalf of the respondents.
Cell number 50.
Grateful.
Narayan Bhatt.
Here for the petition.
Petitioner.
My lord, I am neither a borrower nor a purchaser from the borrower. My lord, this is a fraud played by the bank officers in collusion with the respondent number 2 and 3.
2 or 2 and 3, what is the relation
My
between you
lord,
and 2
they
and
have
3?
purchased it. My lord, the facts are like this. In the year 2010, my lord, a joint development agreement was entered into. My lord, then flats were, my lord, offered to the general public. I entered into an agreement in 2011
With whom?
with the developer.
Who is he? Is he the
He is not a party before the DRT, my lord. My lord, then all the payments, my lord, were paid in the year 2012 as per the agreement, and payments were complete. Then, my lord, the property, my lord, finishing was not done. That's why, my lord, he went on postponing the registration. He registered it, my lord, in the year 2017. My lord, the flat is measuring 1,718 square feet. My lord, in the supplementary agreement, exact dimensions are mentioned. My lord, the respondent number 2 and 3, my lord, they appears to have approached the first respondent bank and availed, my lord, something around 90 lakhs rupees.
Who are they?
My lord, they are total strangers. They are not traceable.
No, strangers, and they have nothing to do with this building. They are not the developers. They are
not developers.
the
According to the bank, my lord, the developer sold this, my lord, to different respondent number 2 and 3.
When?
My lord, in 2015.
That is before your sale.
Before my sale. My lord, the dimensions of the flat do not match with the sale deed. That is the first. Then immediately, my lord, the section 13 notice was pasted on my door. Immediately I approached the civil court. I obtained an injunction against the sale notice and all further proceedings. My lord, that injunction, your lordship gets it at annexure H. My lord, that will clear all facts instead of, my lord, I narrating it to your lordship. Bank, my lord, did not challenge that injunction order. Your lordship may kindly turn to page 128. My lord, may just read, my lord, from the IAS page 137, para 4.
Yes.
To these applications, IA number 1 and 2, the defendant number 8 has filed objections and also filed interlocutory application number 3 and order so and so, rule 4 of the CPC, to vacate the temporary injunction granted by this court, wide order dated so and so. The defendant number 8 has also filed a written statement and objections to IA number 1 and 2 as under. The suit of the plaintiff is not maintainable. Same is barred by section 34 of the Suffice Act, and hence injunction cannot be granted by the civil court. In fact, defendant number 7 has availed loan from the defendant number 8 by mortgaging the suit settled property on so and so. Outstanding loan amount is 93.6 lakhs. As the defendant number 7 has failed to repay the loan amount, the defendant number 8 has issued notice under section 13(2) of the Suffice Act, dated 17.
Property was mortgaged on 15/5/2021.
Yes, my lord. According to them,
25/5/2015,
15, my lord.
much before their sale date.
Yes.
My lord, may I just point out, my lord, the agreement, your lordship, before my learned friend is pointing out that my sale deed is subsequent. Your lordship may kindly turn to annexure P, my lord. Annexure P set.
Page number.
My lord, 1 second. My lord, page number 338,
Yes.
dated 19/12/2010. Then, my lord, may I just point out to 2 receipts, my lord, for having made this payment. My lord, your lordship gets it at
No, this agreement of sale is between who?
between the developer and me, my lord.
Hmm.
Then, my lord, I made some of the payments were made through check, some of them by cash.
19/12/2010.
Then,
Hmm.
then, my lord, and your lordship may kindly turn to page 365.
Hmm.
My lord, annexure P16. My lord, payment is made through check dated 21st March 2011. Entire P series, my lord, are the receipts. The last receipt, my lord, is at P21. It is at page 372. That is 23rd July 2012. My lord, 3 lakhs. My lord, payment is complete in 2012. Agreement is of 2010. Registration, my lord, is only in 2017. My lord, I am put in possession. The electricity meter stands in my name. My lord, the khata stands in my name. I am paying the property tax. None of these documents are available with the second or the third respondent, and bank did not verify any of these things. Now, your lordship may kindly see, my lord, the dimension mentioned in the supplementary. My lord, in the khata, your lordship may kindly see the dimensions, page 373. My lord, bottom, last entry, serial number 14, TR Rekha, SF 205. Dimension, my lord, of the flat is 1,718 plus 150, my lord, car parking. Now, your lordship may kindly see the sale deed between the respondent number 2 and 3. It is at annexure E, my lord,
No, let's come, please come to your sale deed, page number.
my lord, annexure A, my lord. My lord, it is at page 23. It is dated 6/4/2017.
Vinay.
Vinay is not there, my lord. It is me.
Vasalya.
It is me. Vinay's sale deed is at annexure E, page number 55. My lord, there the dimensions are different. It is not 1718. Your lordship gets it at page 68. Very cleverly, my lord, this sale deed is drafted in favor of second and the third respondent. Page 68. Your lordship may kindly see Schedule E property. Residential apartment building, flat number SF5 in second floor of Sanjana Sovereign, having 1,650 square feet.
Built-up area.
Built-up area. Your lordship may now kindly see, my lord, the built-up area mentioned in the khata as well as, my lord, in the supplementary agreement. Your lordship gets it at page 331. My lord, serial number 10, 205 SF5, 3 bedrooms, 1,718 square feet. In the sale deed, my lord, to the second and the third respondent, my lord, it is mentioned as 1,650 square feet. Your lordship may kindly see, my lord, the khata. My lord, it is at page 373. It is not 1,650, it is 1,718 square feet. My lord, this is a fraud played, my lord, by the bank officers in collusion with the respondent number 1, 2 and 3. My lord, there is an injunction against the possession notice. My lord, they proceed. Your lordship may kindly see, my lord.
What did you do after the suit?
Suit is pending, my lord.
Huh?
Suit, my lord, I have to take instruction. I just want. I filed a OA. My lord, kindly see the prayer sought before. So nothing to, my lord, I am not initiated in surface action. So only DRT action. I just point out. My lord, kindly come to prayer for a moment before this honorable court. That is at page number 19. Wherefore, this honorable court may kindly be pleased to call for the entire records pertaining to the case of the petitioner pertaining to OA number 1617/2022 on the file of the DRT 1 Bangalore and grant her following reliefs. 1. Issue writ of certiorari any other appropriate writ order or direction quashing the final order passed by the Honorable DRT dated 30th 5/2025 passed by the Honorable DRT Bangalore in OA number 1617/2022 produced at annexure. Let us just point out annexure. So order passed by the Honorable DRT under section 19 pursuant to original application filed by me for recovery of money. I'll just point out annexure.
No, he is not a party to all that.
He is party.
My lord, I have been wrongfully made a party. I am not a borrower nor a purchaser from the borrower.
Have you contested it? Have you contested it?
Yes, my lord, I have contested.
Then what did the DRT say?
My lord, DRT says their sale deed in favor of the respondent number 2 and 3 is earlier to my sale deed. It doesn't go into all these things. It says that, my lord, there is an injunction. It has nothing to do with that.
When did you file the suit? Is prior or OA is
My lord,
prior?
immediately suit is prior to the OA. My lord, immediately this when the notice of this 13th notice was pasted, immediately, my lord, I approached.
No,
For my recovery of money.
before that, he has filed a suit. He had obtained an injunction. Whether the suit is maintainable, whether the injunction that is granted is right or wrong, unless and until that is vacated, you contest the matter. Why should you take the things forward?
I am not, I filed a suit, otherwise that will be time barred. I have to file a suit before the DRT for recovery of my money. I filed it before the DRT.
No, it has to, till further orders are passed by the suit, in the suit. How can you proceed with this?
No, I am not, I just pointed in this way. When I filed a suit before the DRT, he contested. He filed his written statement. DRT, my lord, considered his evidence as well as, my lord, the written statement filed before, my lord, I just pointed in this way. In the security tendon, my lord, this honorable, the apex court very clearly, my lord, held. Suit is filed against my surface action, my lord, kindly appreciate. 13 to 13-4, my lord, there is some stay. I am not gone, I am not 1 inch further proceeded pursuant to my lord surface action. Original application which I filed under section 19, as per Satyavati done is clarified, there is no bar for the bank to my lord initiate both actions. Now 13-2, there is a stay. I am not proceeded 1 inch further. I am not put the property for auction. I filed a suit before the DRT. DRT, my lord, after giving an opportunity to the my lord petition hearing, and my lord allowed the petition. Now, my lord, the only remedy for them is to go before the DRT under section 20. DRT, my lord, after giving an opportunity, my lord, both the side that written statement taken on record, evidence adduced, everything after that, my lord, he passed the final order. He can't come before the honorable court and say, apart from this, just 2 sale deeds. One is for a 2015 sale deed in my favor of my borrower, which not created a mortgage in my favor 2015. Their sale deed, my lord, 2017. Look, DRT on that base, there is already existing sale deed.
The court also has to look what is, whether the document is corresponding to the extent and other things.
Court, my lord, gone into detail.
Where is that?
Kindly go to the page number.
Where is this discussion about the discrepancy of the extent?
It is no discussion.
Page number 240 annexurium. My lord,
Two?
Page number 240 annexurium. Before that, my lord, I'll point out my suit. My original application pending filed before the DRT. On the face of it, my lord, that petition itself is not, my lord, at page number 151. I filed an original application before the DRT on dated, my lord.
No, when you are mortgaging, when somebody is offered a property for mortgage, you will not, don't have to check anything.
I have checked my sale deed is first, my lord.
It's not about the sale deed. What is the extent that is mentioned in the sale
But I
deed?
will restrict today also, my lord, my submission may be recorded. I will restrict what my sale deed says. I am on that. No also, my lord, let me measure, my lord,
Okay,
pursuant to
somebody gives you a property mortgage saying
what-
that
You have
this
taken
is,
valuation, value gone.
please understand that this is my property, this is 2000 square feet. Sale deed says it is 1800 square feet. And that property and the property that is mortgage is one and the same.
Hey, no, my lord, the property.
Not.
The sale deed is there. As per my sale deed, we have taken a valuation report also required, my lord, I produce.
Better we talk less about your valuation reports.
No, my lord, it is the case. My lord, now he can't come and say before the my lord, go alone. Pursuant to that, he can't, my lord, it can't be one more appeal court. My lord, I'm so sorry to make this submission. He has to go before the DRT under section 20. There are umpteen number of judgments. No, DRT dealt.
There are judgments that we know about an alternative remedy. Why are we hearing all these matters from morning to evening?
It's not bank initiated action, the surface action 32 issued, 13 for issued, sale notice is not so. So DRT pass an order, it's also court, my lord, after giving an opportunity both the side, evidence reduced, everything, my lord, taken on record, then pass an order. Then, my lord, alternative remedy in section 20.
Yes.
And I just point out, my lord, order passed, I say before the honorable court, order passed under section 19. What section 20 says, my lord, I just point under article. For him, there is no court fees also for that. No pre-deposit. Only, my lord, what is the difference between, my lord, kindly come to section 20 for a moment, my lord.
RDB.
Appeal to the appellate tribunal. Same as provided in subsection 2, any person agreed by an order made by the or deemed to have been made by the tribunal under this act may prefer an appeal to an appellate tribunal having jurisdiction in this matter. Since he is a third party, my lord, there is no pre-deposit also before DRA.
Section 20.
Section 20, 19 and 20, my lord. I just pointed
Yes.
first 19. I filed an application and DRT pass an order under section 19, 90. I just read for a minute, section 19.
Yes. Yes. Application to the tribunal.
Please, my lord, we can file an application for recovery of money. When a bank or a finance institution has recovered any debt from any person, it can make an application to tribunal within the local jurisdiction. So that where I filed an application pursuant to that DRT allowed. Now, kindly come to section 20. Save as provided in subsection 2, any person agreed when order made or deemed to have been made by a tribunal under this act may prefer an appeal to the appellate tribunal having jurisdiction in this matter. So, my lord, now my lord, kindly come to the order passed by the DRT. It's a detailed order. After it is not expert. If the expert, my lord, I would not opposed matter may be remanded to DRT and for a fresh consideration. Because the party is contested, therefore detailed order has been passed. Only, my lord, alternate remedy.
My lord, I had stopped, my lord, reading the civil court's order. Your lordship may kindly turn to page 139. All the points, my lord, pleaded by my learned friend has been, my lord, discussed. My lord, that has been passed after hearing him. He had filed an application for vacating. After hearing him, my lord, the injunction has been confirmed. May I just request your lordship kindly see page 139. The lordship got it, my lord.
Yes.
Reasons. Since all these points are interrelated with each other, they are being taken up together for discussion at a stretch in order to avoid repetition of discussion of facts. It is the case of the plaintiff that she purchased the suit scheduled property bearing flat number 205 in second floor, Sanjana Sovereign apartment situated at so and so, by a sale deed dated 6/4/2017 executed by defendant number 125 through their general power of attorney holder defendant number 6. On the other hand, the defendant number 8 bank has contended that the suit scheduled property was sold by the defendant number 126 in favor of defendant number 7 as per the sale deed dated 25/5/2015, and the defendant number 7 has mortgaged the suit scheduled property with defendant number 8 for borrowing loan. The title of the defendant number 125 over the land wherein Sanjana sovereign apartment has been constructed is not in dispute. Even it is not in dispute by any of the parties that the defendant number 126 have entered into joint development agreement for construction of the apartment building called as Sanjana sovereign apartment, and in fact the said apartment has been constructed also. The only dispute is regarding the sale of apartment SF-205 situated in the second floor of the said apartment building. The plaintiff claims to have purchased the suit scheduled property bearing flat number 205 from defendant 125 represented through the general power of attorney holder defendant number 6. At the same time, the defendant number 8 in claiming that the suit property was sold by defendant number 126 in favor of the defendant number 7
Come
and
to
defendant number.
paragraph number 12.
With regard to prima facie case, it is concerned, though the sale deed allegedly executed by defendant number 126 in favor of the defendant number 7 is earlier in point of time. From the documents produced by the plaintiff, it appears that in the encumbrance certificate for the prior to 2006 to 2021, there is nothing entered in the encumbrance register maintained by the concerned authority about the sale deed executed by defendant number 126 in favor of defendant number 7. At the same time, the plaintiff has produced a copy of the registered sale deed dated 6/7/2017 in respect of flat number SF-205 situated in the second floor of Sanjana sovereign apartment building. As can be seen from the supplementary agreement dated 27/6/21 entered into between the alleged owner and developer, it is not the flat bearing 205 shown have measuring 1,718 square feet, but in the sale deed allegedly executed by defendant number 126 in favor of defendant number 7, measurement of the flat sold is shown as 1,650 square feet. Therefore, the question arises that even in the supplementary agreement measuring flat number SF-205 is shown as 1,718 square feet. As to why the measurement in the sale deed allegedly executed by defendant number 7 is shown as 1,650 square feet. Furthermore, when there is a registered sale deed in favor of defendant number 7, the same ought to have been entered in the encumbrance certificate, but it is not entered in the same, which also shows that there is some fraud or where there is some mistake committed by defendant number 7 and 8 in the sale deed allegedly executed by defendant number 126 in favor of defendant number 7 and sanctioning the loan in favor of defendant number 7.
The order that is passed in the suit is the temporary injunction restraining defendant number 8 from interfering with the plaintiff's possession or the suit scheduled property or dispossessing the plaintiff from the suit property in any manner. The defendant number 8 is restrained from interfering with the plaintiff or the suit property, dispersing so and so. In any way enforcing the notice dated so and so. This is another order. Before that, there is an order from the court not to interfere with this portion.
I'm not going to interfere with the position. I'll file a suit for recovery of my money. I'm not, my lord, I just point out. There are two acts.
How will you recover it?
My lord, the BRT, my lord, may execute the RC at that time, that point of also.
No. Now, what will you do now?
As long as, my lord, now, my lord, what will happen before the BRT? The execution procedure is different. The recovery officer, pursuant to my lord OA, the recovery certificate will be drawn. Pursuant to recovery certificate, recovery officer will give a notice to all the concerned parties. Then he will invite my lord, everybody's my lord, then he will put the property for my lord, annexure and etc. and we put the property for auction. Not by me. Unless and until this stays got vacated, I will not initiate the action to Surface Act. That is my lord.
Surface Act is only part of an order.
No.
The remaining part says that, no, I'm not talking not about the Honorable Supreme Court. I'm talking about the order that is passed by the civil court, which is staring at you. Who are you? You are a party to that. It says you should, his possession shall not be interfered.
I will not interfere. I will not interfere. I have taken an order.
Then I will pass an order till the suit is till the suit.
Have it tomorrow. I file my objections. May not be.
No. Intermodal. There is an intermodal in this.
Pardon, no, my lord, it is a fresh matter.
Pass an intermodal.
Everybody will challenge the OA order before this one is put. There is what?
Not about the OA order. Every case is not one and the same, Mr.
In my favor, my or favor. 2017 days.
What are you doing? When is this order passed?
My lord, this is passed, my lord, on May 25th of May 2025.
Annexure M is my lord, 30th May 2025. 6 months before.
There are two orders by two different one by DRT, one by a competent court.
My lord, with respect of proceedings issued as section 19 civil court orders. I have filed.
No, whether the proceedings are maintainable before the civil court or not.
Civil court order is 22, my lord, July 22, 26 July 22.
22.
22 civil courts.
I also filed a suit in the year of 2020. My lord, there is no.
When is your suit?
2022.
Which month?
Month I have to find out, my lord, because it's not species.
Please come. The present writ petition is filed, questioning the order that is passed by the DRT in OA number 1617 of 2022. Why you have come before this court questioning that order after these many years?
My lord, no, my lord, this is past 25.
Oh, 25, 35, 2025. The facts of the case are, the petitioner has entered into an agreement with the builder in the year 2010.
2010, my lord.
2010, and the sale deed is executed in his favor in respect of a residential flat in the year 2017. The bank has initiated the proceedings for recovery of money against the
Respondent 2 and 3, my lord.
respondent 2 and 3, as they have mortgaged the property in favor of the bank and obtained the loan. When the bank has initiated the proceedings on the Surface Act, the petitioner has approached the civil court, that is the 8th Additional City Civil and Sessions Judge at Bangalore, by filing OS number 5567 of 2021, dated 26th July, OS number 5567 of 2021, and also filed an IA seeking interim injunction.
Two IAs, my lord.
I had filed IA number 1 and 2 seeking the interim injunction that came to be ordered by order dated 26th July 2022, whereby the court has directed the bank from interfering with the plaintiff's position over the sue schedule property or dispersing the plaintiff from the sue schedule property in any manner till disposal of the suit. And further, IA number 2 is also ordered, whereby the bank is ordered not to enforce the notice dated 14/9/2021. The bank has approached the DRT and filed OA number what is that number?
1617 of 22.
OA number 1617 of 2022, and the order came to be passed on 30/5/2025. When counsel appearing for the petitioner submits that the civil court, while granting the injunction, has observed that the property which is mortgaged to the bank by the respondents herein 2 and 3, there is no in the encumbrance certificate, the same is not reflected. That's what is the order of the civil court.
That is the order of the civil court. That is the
148, the defendant number 8 is restrained from in any way enforcing the notice dated 49.
That is IA number 2, IA number 1. No, you shouldn't read only what is favorable to you.
147 onwards, my lord, up to 149.
Then the court has observed that the encumbrance certificate does not reveal the sale deed of the year 2015. The court, considering the fact that the petitioner is residing in the said apartment and the balance of convenience is in favor, has granted the injunction way back in the year 2022. The bank has filed the OA in the year 2022, and the orders are passed in the year 2023. 25. There is no dispute about the fact that the injunction is subsisting as on today. And what is the action taken by the bank against the said order, interim injunction that is granted by the civil court is not forthcoming, considering the counsel appearing for the bank submits that when an order is passed in the OA, there is a remedy available to him to approach the DRAT, and the petitioner cannot be permitted to come before this court. This court is conscious of the fact that an appeal lies to the DRAT, but in the facts and circumstances where the bank, which has suffered an interim injunction in the year 2022, files and where there is an order not to interfere with the peaceful possession and enjoyment of the property of the plaintiff, approaches and files the OA. Now, the execution of that would only be by selling the property, whether it is by the bank or by the authorized officer. In these circumstances, this court deems it appropriate to grant what is the stay you're seeking?
Annexure M, my lord.
Finds it appropriate to stay the operation and implementation of the order dated 30/5/2025 in OA number 1617 of 2022. The respondent.
Petitioner, my lord. There are other two people also there in the annexure M.
Against them, let him execute, my lord.
As far as the petition is concerned, the respondent bank shall file its objections. This is matter after vacation.
Much obliged.
Yes. Mr. Vignesh Shetty takes notice on behalf of the respondent on instructions of its. Yes.
Cell number 51 adjourned, cell number 52.
What had happened in this matter, my lord, pursuant to my lord, my mortgage. My lord, the borrower, my lord, parted with my lord, entered an agreement of sale. My lord, in fact, my lord, subsequent to that, my lord, in the year of 2024. Therefore, my lord, I given representation to my lord, at page number 71, annexure F, to cancel the my lord, subsequent to my mortgage and subsequent to I sold the property in favor of some third party. I mean, my lord, take notice on the
See your prayer.
prayer, my lord.
Issue a mandamus to
Without directions to
respondents
respond to remove the illegal subsequent entries from the scheduled property in
entries
view of the representation.
from
So
the
and so.
scheduled property.
One case, this honorable court considered,
The representation dated 17/1/20. To whom you have given the representation?
my lord, sub-registrar, my lord.
No.
I understand, my
What
lord.
I'm not able to
I-
understand.
No,
is
no, I understand, my
Because
lord,
the
what
bank
will-
is filing the writ petition, it will be listed before this court.
That I don't know, my lord. Registry is.
No, it shouldn't be, because you are seeking some entries to be removed from the sub-registrar. Court, whichever is the roster, that has to go there. Because bank is a petitioner, that doesn't mean that it will
No,
come
no,
here.
I understand, my lord.
List
Let-
this matter
No, no, I
before the
mean,
appropriate
I'll take
court.
notice on this respondent, my lord.
List this matter before the court having roster.
Grateful, my lord.
Cell number 53.
For the petitioner in this case, the anti-suit injunction, my lord, where the trial court has not given the 39 rule 1 and 2 injunction in favor of the wife, where the husband has filed the petition before the American court and he has sent the notice to the wife, my lord.
No, I remember what happened.
My lord, 19 is the next date, my lord. The entire order sheet is here.
So far,
notice is-
nothing has happened.
My lord, she has got the PDF and everything. I've sent the entire OS, my lord. In fact, he has replied
So you
saying,
said the matter was coming up on yesterday or today.
yes, my lord, 16th, my lord. 16th, my lord.
It will come up on 16th again.
No, my lord, it was on, last date was 6/12, my lord. I'm sorry, my lord. So
What
on
happened?
6/12, he has not appeared, my lord. Not the advocate has filed any wakalat or memo for.
Notice is served on him.
Yes, my lord, it is served, my lord.
Then what did the court do?
My lord, the court, via court, it is not served. From the respondent wife, sorry, petitioner wife, it has been served. But he has replied, my lord.
What is the order on 6/12?
My lord, on 6/12 is via WhatsApp, email, and through court and speed post has to be sent, and which have taken all these steps, my lord. Process has been paid, but he has not. It has not reached him, my lord. Via court, whatever I have done, but through the wife petitioner, whatever I have done, he has replied to that, my lord. So that I am filing one memo, my lords, where he has replied.
Now the trial court, the family court, when is the matter posted?
My lords, next date is 19 12, my lord, same this month.
This matter after vacation.
My lords, in the interim, my lords,
No, no, no,
what
no.
happens is if he obtains divorce, my lords, then, my lords, I can't contest the matter there, my lords. That is why I'm before your lordship.
That's
my lord.
all, it's all your apprehension.
No, my lords, he has replied saying that I will take divorce, my lord. My lords, he is marrying some American citizen there. So it will be a problem for me, my lords, because all my cases he withdraw, because he was allowing me to take to the US along with my child, I agreed to withdraw. After withdrawal, he's going there and he is marrying some American citizen there, my lord. Then I cannot.
Where from you are saying all this?
My lord, he has said directly to the child also, my lord, but I could not take the record. But this is what the instructions from the client, my lord.
He told the child.
Child, yes, my lord.
That is getting married.
Yes, my lord. This is my instructions of my client, my lord.
When did you file the suit? Seeking, when did you file the suit? Suit.
My lord, I filed suit on 17/11, my lord. 17/11/2025, my lord. After receiving the notice from him from the America, my lord. The page starts from page 60, my lord.
No, when he has sent you a mail, you didn't respond to the mail. You came to the court and filed the suit.
My lord, from past 2 years, he has not taken me to America, ma'am, my lord. Because of that, I did not reply.
So that's what I'm saying. It is only your apprehension that he will marry.
He has
Something
told
is
himself,
going to
my lord. He has
happen.
initiated the proceedings.
No, but from the
already.
last 2 years, nothing is happening.
No, my lord, he has already initiated proceedings now. Now I have received a legal
Where do
notice.
you get that?
My lord,
Where do you get that he has initiated proceedings?
page 60, my lord. Page 60, my lord. Because I am unable to contest their, my lords. That is why before your lordship.
Last time you didn't say so, this one.
My lords, before that, I saw the, I mean, I.
Well,
showed
last
the
time what you said was that
email.
he may likely to initiate. That's what you said.
I apologize.
When is this? This page 60. What is the date? I'm not able to see.
Lords, this is the notice which the petitioner has received, my lords. Insofar as divorce is concerned, thereafter,
Where is the date? Nothing.
my lords, date is in 1 second. 13 November 13, 2025, my lords. Last page 72, my lord. And thereafter, advocate has also issued legal notice, my lord, saying that to give all the financials. My lord, he has also sent this email to my office, Accenture, the advocate, my lord, from the firm. That is in M1, my lords. Page 69, my lords.
Please come. The writ petition is filed. To quash the order dated 25/11/2025.
My lords.
What
Issuing
is the
notice.
order to be quashed in that?
My lord,
She has only issued notice.
yes, my lord, in this stage, my lord, where anti-suit is filed, if notice only issued, that too after 1 week, my lord, that is why I was.
So you don't want notice
Right.
to the respondent.
Yes, my lord, I mean.
The petitioner has filed.
IA number 3. My lord. Page 114. My lord.
Has filed OS number 514 of 2025 before the third additional family court Bangalore seeking an anti-suit injunction. In that an IA is filed seeking restraining the respondent from continuing with participating in or prosecuting the proceedings initiated by him before the Worcester Probate and Family Court, Massachusetts. It is submitted that the husband has left the wife and the children or child,
One child, one daughter.
and the
Minor
daughter here and left to US. it is submitted that earlier.
Fifty-six writ petition, my lords. Page 56. He has said that he'll take me. I have withdrawn my 498A case and all the cases.
Earlier, the petitioner has filed a complaint under section 498A, which is registered as crime number 0034 of 2018. Then the police have filed a charge sheet in CC number 18183 of 2018 before the jurisdictional magistrate. The respondent had filed criminal petition 6075 of 2018, seeking to quash the charge sheet. Then in the year 2019, he moved to this United States for employment, leaving the petitioner and the child. And they are living in Bangalore. He has instituted MC number 4848 of 2021, seeking dissolution of the marriage. Thereafter, he has filed a memo to withdraw MC number 4848 of 2021, acknowledging the settlement that is dated 7/1/2023, acknowledging the settlement and confirming that he no longer wishes to press the divorce petition since the petitioner and respondents are willing to reunite and reside together.
Settlement is in page
In
40.
view of the said settlement, the charge sheet that is in CC number 18183 of 2018 is quashed. On 9/7/2025, an email was sent by the respondent to the petitioner threatening that unless she accepts his settlement terms, he would initiate proceedings in the United States and he will file a divorce petition. Then on 6/8/2025, she received the summons to appear within 20 days from the Worcester Probate and Family Court, Massachusetts, to appear within 20 days from the date of service. It is stated that she had no visa and she has no capacity to travel to US. As such, she has filed this petition. The trial court has directed the notice to the respondent. Land counsel for the petition submits that unless an injunction is granted, it would cause hardship to the petitioner. And the court has failed to understand the imminent necessity of granting an interim injunction. Considering all these aspects, this court, there shall be a direction to not a direction, the respondent is restrained from continuing with participating in or prosecuting the proceedings initiated by him before the Worcester Probate and Family Court, Massachusetts, in docket number. So it's there in paragraph prayer B. Notice to the respondent.
Then number 54,
Deeply obliged.
GB Nandish Gowda.
My lord, the petitioner and respondents, my lord, the grandparents. My lord, the both petitioner daughter and son-in-law. Petitioner is the maternal and respondents is the paternal grandparents. Petition filed, my lord, under section 13 of the Guardian and Wards Act. In fact, my lord, the case listed for final arguments, my lord, in the month of November 2024 itself. On filing the application by the respondents, my lord, my lord, it is recalled. Now it is still the stage of cross-examination of the respondent only.
Which year is this?
My lord, 2021. He sought for disposal, speedy disposal, my lord. That's all, my lord.
Which court is this?
My lord, the 7th Additional District and Session Judge, Bangalore Rural District, Bangalore. In fact, my lord, the husband of the
petition is filed, seeking a mandamus, directing the 7th Additional District and Session Judge, Bangalore Rural District, Bangalore, to dispose of the pending petition filed by the petitioner that is GNWC number 33 of 2021. It is submitted that, in fact, the matter was posted for
My lord, the final arguments on
On?
merits on, in the 28/11/2024.
the, on 28/11/2024 itself. And so far, the same is not disposed of with the learned judge. Considering the submission of the petition, this court is passing the following order. So and so is directed to dispose of the matter as expeditiously as possible, but not later than April 2026.
Much obliged.
The notice to the respondent. This court is not proposing to issue notice to the respondent as disposal of the cases in the interest of both the parties.
Much
Yes.
55, Naveen Kumar.
Mr. Naveen Kumar pays Tambur, kindly call on Friday. Naveen Kumar pays Tambur. Kindly call on Friday.
What is this matter?
Restitution, in restitution conjugal rights, he has filed an IFR visitation right, Your Honor. It was rejected on the maintainable ground.
Rejected by reserving liberty to the petitioner to seek relief in accordance with law under separate proceedings. Notice to the respondent. Petition is permitted to take out hand summons once the memo is filed is the matter.
Cell number 56, Satish HTV. Mohammed Ibrahim.
Respondent.
Let's kindly permitted to file an affidavit.
Affidavit, take that. Have you served a copy on him?
Yes, ma'am. Copy served.
The action has taken place. Anyway, the overdue is 41 lakhs. Entire due is around 1 crore. I'm not going for that. 41 lakhs. He said that he will pay as per the affidavit in 8 weeks. And every 2 weeks, 10 lakhs, 10 lakhs, last is 11 lakhs. I have no issue. I've given to him in bank also. The thing is, if he doesn't pay the first installment,
Then you can proceed with the, you can finalize the auction.
that's what I want. Single default. I want.
The
Small house.
The petition is filed. Seeking the following prayer. When the matter came up on 8/12/2025, it is submitted by the land counsel for the petitioner that he is ready to clear the outstanding amount. According to the petitioner, the outstanding amount is rupees 30 lakhs. And according to the learned counsel appearing for the respondent bank, the outstanding amount is more than 56 lakhs. Then this court has directed the learned counsel appearing for the respondent bank to inform the petitioner counsel what is the outstanding amount,
Overdue amount.
Overdue.
the overdue amount, to regularize the account, what is the overdue amount. And it is undertaken by the petitioner that he'll come up with an affidavit. Today when the matter came up, he has he placed a memo before this court. As per the memo, that the overdue loan amount is rupees 41 lakhs. He is to, what is this? I
That's-
state that the third respondent is ready to pay.
Third respondent is a principal borrower.
No.
I am the guarantor.
No, how can you file an affidavit on his behalf?
My lords, I am undertake to, in fourth paragraph, if the respondent fails to honor the above terms and condition, I am the guarantor of the loan. I will take responsibility in clearing the above loan.
It is stated that the third respondent, who is the principal borrower, you are the
Principal,
guarantor.
he is my cousin.
Third respondent is a principal borrower, is ready to pay the entire outstanding amount of rupees 41 lakhs within 8 weeks from today, and in 4 equal installments. That is, in every 2 weeks, he will pay rupees 10 lakhs. If it is stated that if the respondent fails to honor the terms and conditions, as the petitioner is a guarantor, he'll be taking the responsibility in clearing the
Mortgager.
Huh?
Guarantor and mortgage.
mortgager. He'll be taking the responsibility in clearing the outstanding amount without fail. Considering the the undertaking affidavit, the land counsel appearing for the respondent bank submits that the auction was conducted on
Yes, ma'am.
yesterday, and the same was not finalized.
Not finalized, there is
Ah,
a bid. we have
It is
not
submitted, like, you went ahead or it was?
finalized. Went ahead. There is a bid.
It is stated that
We have not
the
finalized.
auction, as it was not, in view of the order passed for this court, they have not finalized the same. It is submitted that as submitted by the petitioner, if he fails to pay 10 lakhs by every 2
weeks.
The time, I think it's better we fix it instead of saying it.
2 weeks from
2 weeks.
What is the date today?
Today is 10.
24.
Today is
10.
10,
Second week is 24 or
24. Then
31st. Not 31st.
24, 31st, then
24, not 31st. That is, Wednesday, that is, one month.
1.
1 month,
Uh,
26. Then after 15,
mm,
then after 29.
mm. Accordingly, this court has passed the following order. Petitioner shall pay the first installment on 24th of December, second installment.
That is on, sir, 8.
Huh?
That is on 8, 2 weeks after.
8th.
8.
That is on 8/1,
And 22/1
22/1.
and 29. And
5 to
then 5. 5.
5/2. That is 10 lakhs each on installment he shall pay. If, second point number 2, if the petitioner fails to pay, petitioner oblique third respondent fails to pay any installment, the bank is at liberty to finalize the auction.
proceeding.
Accordingly disposed.
loan may be regularized.
Huh?
Regularize the loan.
On such payment, the bank shall regularize the-
2 months will be there, then that also has to be.
after that.
After completion.
57, Girish B. Baldare.
Challenging the sale auction notice dated.
You have the instructions?
The sale was scheduled for today, it's not taken place, for want of bidders.
What is questioned before the court?
The sale notice.
Sale notice. page
No, they have
number-
not conducted the sale now.
Yes, ma'am. That may be recorded and it.
And will say that it has become infectious. The writ petition is filed saying the following prayer, land counsel appearing for the respondent bank submits that as for the want of bidders, the auction could not be concluded. And this writ petition has become infectious, dismissed as infectious. Yes, 57.
Cell number
It was
57.
liberty to, if any fresh
This is
sale notice,
57. Next. Huh?
if any fresh sale notice has issued, liberty to.
Liberty not
always a
required.
liberty.
You can go ahead. Yes.
Madam,
What is the
Name.
name?
Your name.
Natasha and Murthy.
No. Who is the advocate? Bank standing counsel.
Please, my lord,
You are
Natasha and
you are the
Murthy,
standing
please.
counsel, so and so takes notice on behalf of the respondent bank.
Cell number 58, adjourned. Cell number 59.
Yes,
59.
challenging section 14 order passed by the trial court, my lords. Page
Notice on behalf of the respondent.
Page 12, my lords.
what is your name? V. Suresh. Give papers to them.
My lords.
So and so.
One submission, my lords. Overdue use 0 rupees. My account is active. Last,
Everything will hear once the respondent
my
comes up with
only submission
instruction.
on 12/12, my lords, they have indicated that they will take physical possession
On,
on 12/12. That is,
tomorrow
their-
we'll have, get
Kindly.
instructions by tomorrow. Serve the
I will
papers.
serve the papers.
So and so. What is that? Suresh. V. Suresh takes notice on behalf of the respondent, then counts for the petitions to serve the copy of the writ petition. This is matter tomorrow. It's next.
Great.
Cell number 60, adjourned. 61. Cell 61, Giri Malaya for appellant.
I appear for appellant. In this case, medical board has sent a report.
What is, where is
Since
the
the
report?
disability was in dispute, this honorable court has referred the matters to local medical board for reassessment of the disability.
89.8%.
Earlier also, same was there. Tribunal has taken 50% to assess the loss of earning capacity instead of taking 89.7%.
Huh?
That only, but our contention before this court, when the 89% disability, whether she can give an evidence before the court or not is the question.
That
Anyhow,
technical
medical
issue,
board is given,
a board has given
therefore-
that you cannot, so what is, let us do the calculation. There is order.
And also future attendance charges is not.
We'll
considered.
see what it is.
%50 with future prospect is considered.
Given her complaint related to visual difficulties, it is recommended that she also seek an evaluation from an ophthalmologist for further assessment of visual disability. If that is also coupled, it will be something else. Yes. Come to the table.
In case, 35 of the tribunal judgment.
35. No, where is the, there is no table?
No, there is no synopsis.
No, you're seeing, maybe you're seeing some other file?
No, that.
Because there is no table.
No table. The same is mentioned in the.
MFA 3978?
ಸರಿ ಇದೆ ಅಲ್ಲ ಇದ್ರೊಳಗಿಲ್ಲ ಲಾಸ್ಟ್ ಮಾಡಿದಾರ
Future medical, heading H of the, in pagination 35 of the tribunal judgment mechanism.
35.
Yes, it is there. So now please come to this. Pain and suffering, what do you say?
Only 75,000 is awarded. That is the lowest.
Then medical expenses as it is.
Loss of income during later.
1 minute, please come to that paragraph, page number 35 and look at the table. As per the table, we'll go.
Yes.
40,200. Towards loss of income.
Loss of only 3 months is considered. Thrice the appellant was treated as inpatient. That the third operation was conducted in the 8th month after the accident.
She has admitted in the hospital, how many days she was admitted in the hospital, that has to be taken into consideration. Regarding her, she has stated in her.
This is a case where we will take minimum 6 months with all these kind of, which year is this accident?
2020.
2020. What is the income?
14,500.
14,500 into 6. It comes to 87,000. Then loss of future towards, how many days was in hospital?
Now 14 days.
14
with
days.
breakup, 3 occasions.
Total 14 days.
Total 14 days.
Then this incidental expenses we will reduce.
In this case, my lord.
Loss of earning capacity during later period also it's on the answer because only 14 days. She might have taken the treatment, but.
In the.
No, as far as the incidental expenses, we are considering the hospitalization. So this we will take 14,000.
In this case, even now the appellant is not able to walk independently.
Loss of future income. What is the age?
38 years.
30?
38 years.
38 years. So
50.
the income taken at 14,500 less 40% future prospects. It comes to 5,800. It comes to 20,300 into 12 into, what is the multiplier?
15. 15.
15. Into the disability as per the
89.8%.
89.8. That is 90.
90.
it's coming to 32 lakhs 88,600. Then what is this loss of future prospects? One more 5,22,000.
Please, they have
Well,
one last.
bifurcated.
Future prospect.
Future prospect
Independently
separately
they
have.
have taken it.
and it's-
So then what do you say about is requirement for attendant charges throughout?
There is no evidence from the doctor.
There is, there is a evidence of the doctor.
No.
With-
50% disability, how they will,
That is cognitive disability is concerned, they have stated, Mirat. That's what I am wondering. In spite of this, how this, she has given the evidence before the court has not observed anything regarding that. That
There is,
Could after examining the patient, place of National Institute of Medical and Health of Neurosciences. Biofrontal contusion following RTA.
is head injury.
And the patient and having gone through all available medical records during the medical board meeting. Based on the neuropsychological assessment conducted at NIMHANS. So
there is evidence of the doctor with, she cannot walk without independently. She needs help for all purposes.
what do you say? Will grant some amount attendant?
But that is my submission, Mirat. Regarding that, Mirat, when she has given the evidence, court has not observed that. She has given the evidence at length. There is no such observation by the court. Now they are saying that not she is need an help. Without the, when she produced, given the evidence before the court, there is no evidence to that. Therefore, my respect submission, Mirat, the compensation occurred. 90% disability and the compensation what it is granted is on the
Loss of amenities?
75,000 is granted.
Will grant one of another of 25,000. Future medical expenses. What is evidence of the doctor?
No, they itself produce the document of 24,000 and our medical bills. What has already granted 20,000. What else it is recorded?
What do you say?
Regarding in the, since the appellant suffering is with a disability of 90%.
No,
she has to-
future, not necessarily that he requires future medical expenses. We'll leave that, future
Okay.
medical expenses. We'll grant any legal expenses 10,000.
One more submission. Regarding liability, pay and recovery is to be done. Accident is happened prior to amendment. There are the number of the judges.
Yes. It comes to 36 lakhs 39,800 against 21 lakhs.
30,700.
Please come. Agreed with the award passed in PC number 520 of 2021 by so and so. The dated 1st April 2024, the claimant is before this court seeking enhancement of the compensation. It's a case of the claimant that on 25/11/2020 at about 7:30 p.m. he was going by the side of the road. At that time, the rider of the motorcycle came in a rash and negligent manner with high speed and dashed against the petitioner. Due to that, the petitioner sustained injuries and admitted in the hospital. According to them, the petitioner was hale and healthy before the accident and he was earning 18,000 per month. The tribunal on the issue of rash and negligent, on the issue of the negligence, the court has held that the accident had happened because of the rash and negligent driving of the rider of the vehicle, rider of the vehicle.
Motorcycle.
And he was not having a valid driving license.
Minor.
He is a
Minor,
minor.
yes.
The court has held that the owner is liable to pay.
Please.
ಅಲ್ಲ
The court has held that
ಅದಲ್ಲ ಮೈನರ್ ಅಂತ ಇದ್ರಿಗೆ ಈ ಕೇಸ್ ಎಲ್ಲ ಬೇರೆ ಏನೋ ನೋಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ನೋಡಿ
the owner is liable to pay the
ಬೇರೆ ಯಾವ್ದೋ
compensation.
ಕೇಸ್ ನೋಡಿದ್ದೀರಾ
When it comes to the compensation, the tribunal has awarded the compensation as per the table given below at internal page 35. Extract the table. When counsel appearing for the claimant submits that, as per the evidence of the doctor, the disability is 89.65%, and the court, without any basis, had taken disability at 50%.
50%.
50%. It is submitted that, considering the disability on all the counts, the compensation that is awarded by the tribunal was not just and reasonable. Then counsel appearing for the respondent insurance company submits that,
23 years.
as the claimant was able to give evidence, the court has taken 50% and there are no grounds to enhance the compensation. Next para. When this matter came up on the last occasion, this court has directed the petitioner to appear before the medical board. A coordinate bench of this court has directed the petitioner to appear before the medical board by order dated 1/4/2025. Now the report is placed before this court. As per the report, the disability sustained by the petitioner is 89.8%. 89.8%. First, coming to the issue of the liability, though it's a minor or a,
23 years. 23 years.
it's not minor, the person is not having a driving license. Though, as this accident had taken place prior to the amendment, though there is no driving license, still the insurance company is liable to pay the compensation and record the same from the owner of the vehicle. Then coming to the compensation, considering the injuries that are sustained and also the disability sustained by the claimant under the head of pain and suffering, this court is granting an amount of rupees 1 lakh medical expenses as awarded by the tribunal. Coming to the loss of income during the later period, this accident had taken place in the year 2020. 14,500 into 6, 87,000 this court is granting. Coming to the incidental expenses, he was in hospital for 14 days, but the court had granted 50,000. This court is granting an amount of rupees 14,000. Coming to the loss of future income, as per the report placed before this court, that the claimant had sustained 89.8% disability. This court is taking it as a rounding off to 90%. 14,500 plus 40% future prospects would come to 5,800. Then his income is 20,300 into 12 into 15 into 90 by 100 is 32,88,600. Coming to the loss of immunities, considering the disability of 90%, this court is granting an amount of rupees 1 lakh in the light of the law laid down in Mekala versus legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 36,39,800. Accordingly, the appeal of the claimant is partly allowed. Any delay? By enhancing the
No.
compensation from an amount of rupees 21,30,700 to 36,39,800. The amount the insurance company shall pay and record the same from the owner of the vehicle. The enhanced amount shall carry 6% interest. Next,
Bill number 62.
Entire amount,
Whole amount.
what was granted?
6%.
But liability was fastened against you.
No, it was 6% only.
6%.
The entire compensation amount shall carry 6% interest. Yes,
Bill number 62, FS Dabali.
yes, Mr. Dabali.
Appeal made by questioning the finding of the term on the point of negligence as well as the quantum. The tribunal has not
How much is granted?
7,73,000 has been awarded. Though the
What is the
trust
admitted amount?
will deposit more 50%, 3.5 lakh,
Huh?
3.5 lakh.
It is submitted that on the point of quantum as well as negligence, the insurance companies before this court, they shall be stay on 50% on such 4 weeks on such deposit. The respondents are at liberty to withdraw notice to the respondent.
Second respondent, notice to second respondent, driver of the first one.
Dispense with.
Dispense.
A memo is filed seeking dispensation of notice to second respondent.
respondent.
Dispense with at the risk of appellant. Yes, next.
Serial number 63, 64 adjourned. Serial number 65.
Yes.
Submission, Madam.
Ranapati
Serial
Bhatt.
number 63, Madam, MFA 8701 of 2025, not a connected matter, Madam.
86.
8701 of 25.
Morning, it's already delinked.
Please, watch out.
Yes.
Number 65.
This case, I am appearing for
Ranapati
petitioner.
Bhatt.
This honorable court, my lord, that last date of hearing that we have submitted draft copy of, my lord, the gift deed, which is to be executed by the respondent to the petitioner. That is one shop and one house. That he has deserted her, my lord, from past 20 years. And my lord, petition, this honorable court was directed to pay 20,000 maintenance. That's also not paid. And my lord, he has got married. Therefore, my lord, that they have submitted another this thing, another marriage took place, and my lord, he has deserted. Ultimately, my lord, that draft submitted by us, which they have not registered. If it is registered, my lord, that everything will be settled.
Read for the terms, whatever we agreed before your my lordship. We requested the other side to, we will also file an divorce petition, consent petition. Because my lordship during the pendency of the petition, she was taken the amount from the respondent for the given consent. Thereafter, she didn't turn up. That's why I will request.
Let him show, my lord, that I have taken and consent. I'll withdraw with this petition. I have given consent and I have taken money from him if it is given consent. Let him show, because, my lord, this, kindly see the order sheet before this court. Kindly for a moment, my lord, I'll place your lordship. Order dated, my lord, 16/4/2025. Am I permitted to read?
Anyhow, from 16/4/2025, both of you are fighting like this. We'll see after vacation, list after vacation. Yes, 66.
Serial number 66.
My lord, she is alone, my lord, that for
After list is
Allah,
on the reopening.
whatever direction that let them pay, my lord, till then, my lord, 20,000.
The list is on reopening day.
Yes.
The
Number
66.
66. CN Srinivas Rao.
Not completed the order, stay granted by this.
Knew that.
Only 1 lakh rupees is deposited.
He has not paid any amount, or he has paid some amount.
He deposited 1 lakh rupees, 5,000. 1 lakh 5,000 is deposited.
How much is supposed to deposit?
5 lakhs 63,000 total amount. Half of them.
No
2 lakh 50,000.
representation on behalf of the petitioner, then counsel, the respondent submits that the interim order is not compliant with in toto. This is matter for dismissal on Thursday. Yes, next.
18. Serial number 67.
In this case, appear for petitioner, my lord. In this case, 125 petition filed by the wife, my lord, or dismissed, stating that, but my lord, she is,
Yes.
she is having illicit relationship with some other, my lord, but that has not been proved by the husband, my lord. In the judgment
Notice
itself,
to
also.
respond.
Notice, please.
Yes.
Serial number 58. MB Chandrachud.
Maintenance has been paid by the petitioner, my lord. I am producing the acknowledgement.
Yes, he has paid, it seems.
1,32,000 has been paid before the trial court. Ma'am. Order sheet is also there.
Let them withdraw.
1 lakh.
Let them withdraw.
Pardon.
Amount they can withdraw.
They have taken the cash in the court itself. My lord.
Oh.
That was the note.
We'll see after vacation. This is matter after vacation.
Interim order. Ma'am.
Interim order earlier granted is extended. It is submitted that as per the order, the amount is paid.
Serial number
Yes,
69.
69.
A.N. Radhakrishna for appellant.
This is also maintenance case. There is no interim order. For the first time, it is coming before the Supreme Court. Let's may kindly observe.
as per your lordship's direction, both parties are appeared before the Honorable Court, and there is a counseling by the Honorable Court also, wherein your lordship has read the pulse of both the parties. And here is a case where interim maintenance was given for 8,000 per month. Now it has been enhanced to 16,000. And is a school teacher. According to liabilities and these things, my lord, he is drawing as a sum of rupees 80,000. But liability is much earlier to filing this complaint. He has raised loan for construction of house and all these things. This the learned section judge has not considered. Second thing, my lord, I have produced certain documents to show that she is leading immoral life. That also not considered. And the third,
We'll see after vacation.
warrant has been issued, my lord. Warrant has been issued. My learned friend is only.
Sorry, my lord.
Warrant has been issued.
Kindly, my lord.
Subject, my only respectful submission, my lord, subject to deposit.
To deposit.
I leave it to the Honorable Court because,
How much is the outstanding as of now?
my lord, according to the, if it is considered 8,000, 98, if it is taken as 8,000, 98,000 is due. If it is taken, 1 second, sir, please, I will not shush up anything. If it is taken as 16,000, 3,94,000 is due. I leave it to the Honorable Court with great respect. And I have got good case on merits also, because I'm submitting
What is granted by the court at 16,000?
16,000 now. Earlier it was 8,000. In between, I request to Lord's may kindly, subject to deposit.
Deposit 50% of the amount and continue to pay. We'll see after vacation.
Please, my lord, please, my lord. And in the meantime, please call for records, my lord. Records is required.
Then counsel for the petitioner submits that. Earlier, the court has granted 10,000.
8,000, my lord.
8,000, and now it is enhanced to 16,000. It is submitted that he has got material to show that the petitioner is certain allegations are made against the respondent. However, this court will consider the same at the time of hearing. As an interim measure, there shall be stay of all further proceedings pursuant to the order dated so and so, on the condition that the petitioner shall deposit an amount of rupees 1,50,000.
Please.
1,50,000 within 6 weeks from the date of receipt of the copy of the order, and shall continue to pay an amount of rupees 10,000.
90,000 they are getting, 1 lakh rupees they are getting the monthly salary.
No, no, I will show it.
The petitioner shall continue to pay 12,000 per month.
May I make one request, my lord? 10,000 is reason.
Now you said that you will leave it to the court.
No, even then, my lord, there must be reasonableness with great respect.
Then you shouldn't leave it to the court.
Let's make it as 8 weeks and 10,000 rupees, because I will show 70,000 I am incurring.
8 weeks, 10,000.
Please, my lord.
After vacation.
Please, my lord.
Number
Call for
70.
records may be called for, my lord. Records.
Call for the records.
Please, my lord.
Number 70, Sachin BS.
Let's say for the petition, my lords, 125 proceedings, my lords, 12,000 is awarded. Earlier, my lords, interim maintenance of rupees 6,000 was awarded, my lords. Petitioner, my lords, he is unemployed, my lords. He's currently not working. Both the petitioners and respondents, both are not working, my lords. And also, my lords, earlier, my lords, 6,000 was awarded, my lords. Now suddenly, my lords, it's my lords awarded of rupees 12,000, my lords. I'm unable to pay rupees of 12,000. And also there is 490.
1,000 you were able to pay.
6,000, my lords, there is no dues, my lords. I'm been paying from the day one, my lords. There is no due at all, my lords. Subsequently, my lords, 498%.
Fine for a child is also there.
Only wife, my lords.
Please come. Learn counsel for the petitioner. Submits that the court has granted how much?
12,000 rupees.
12,000 as maintenance, and earlier it was 6,000, and the petitioner was in a position to pay the same. Considering the submission, they shall be stay on the condition that it should pay 9,000 every month by 5th of every month, and the arrears also at 9,000, if any, within 8 weeks. Yes.
Please, my lords.
What is
Oblige,
the
my lords.
respondent?
Cell number 71.
Let's- Records may be comments. Records, my lords. Please, my lords.
Yes.
Oblige.
Cell number 71, Vedachala.
According to petitioner, filing affidavit to clear out all outstanding dues.
You gave a copy to him?
Yes.
This case on submission, my lordship. Outstanding
they have to clear the loan amount, they have more than 1.4 crore has to be cleared.
Please, my lord.
You can revert out, that is
Already
to.
action has been taken, my lord.
Huh?
Action has been taken place and subsequently the purchaser of only sales
We,
agreement are not.
we paid in all about 64 lakh to the petitioner hearing, my lord.
Amount is paid.
Already 85 lakh rupees sum of amount he has paid, my lord.
We paid about 85 lakhs to the petitioner.
My lord,
In this affidavit, they have now stated about amount payable to the respondent number 2, that is action purchaser.
No, that I'm not able to understand. Why they should state that the amount to be paid to you?
To sell the property, my lord, before action, by suppressing the fact that it was mortgaged to this bank, they collected the amount about 26 lakh. During the course of action sale, my lord, we paid an amount of rupees 37 lakh to the bank. Now, bank, my lord, is agreed to return the amount along with some nominal interest. Insofar as the amount payable to the respondent number 1, my lord, respondent number 2, by the petition, my lord, it is not stated in the affidavit.
My lord, the property is valued over 4 crores 50 lakhs. We'll let the sale take place next month. They have undertaken to sell the entire property, and we'll clear all outstanding dues to R1 and R2 by the end of 31.
In the affidavit, you don't even say what is the outstanding amount. It's like that you file one
It
affidavit.
was unclear as to what amount was.
Just they have stated that, my lord.
File a better affidavit, let's this matter after vacation.
By Monday, please, my lord, otherwise it is a long, old
Wednesday.
Wednesday.
Yes, 72.
Cell number 72.
Wednesday to file a better affidavit from the
Rajaya.
This is matter on Wednesday, by the time the petition shall file a better affidavit.
72.
This case already
Next week, my lord.
Bank, my lord.
1 week, my lord.
They also are outstanding nearly 70 lakh is there, my lord.
I will furnish the
From
details.
3 years, they are enjoying the interim order, my lord.
I'll list this matter on Tuesday by the time.
Next week, I will furnish.
But on that day, I'll dismiss the petition. Yes, list this matter on Tuesday, no further time.
16. Cell number 73.
I am for the petitioner, Your Honor.
73.
I am for the petitioner, Your Honor. My lords, I am the auction purchaser. I have purchased the property from the respondent bank, Your Honor, in the year of 2024, August 2024. The sales certificate issued on 26/11/2024, Your Honor. Till date, they have not registered. Due to as per the BBMP circular, my lords, first the bank has to be kata in their name. Then they have to register sales certificate in favor of the purchaser, my lords. In the they are not did, my lords. In the meantime, my lords, the property was trespassed by the third party. They have not taken any action from. For that reason, we have filed the writ petition, my lords.
My lord, we've already issued a sales certificate. So in respect of ownership, title is already passed. In respect of the registration, my lord, they have to get it registered. We are in fact issuing a letter wherein they have to, by the authorized officer, where they have to submit before the BBMP as per the new BBMP circular. What has happened is they are not coming to collect the letter. In fact, physical possession is with us. My lord, we kindly see the earlier order.
You file your objection.
I file my objection.
Respondent shall file objections after vacation. Next.
Cell number 74.
Let's kindly pass over. Kindly pass over the matter.
Also at 4:45. After vacation.
Cell number 75.
This case appear for respondent, my lord.
Petitioner. I may be permitted to withdraw the petition, my lord, with the liberty to file the suit. Reason is, my lord,
The liberty
respond
to
number.
file the suit.
Please, the respond number 3 and 4 are my brother and sister-in-law, who mortgages my property as well.
The petition is dismissed, land counts for the petitioner submits that he may permitted to.
Cannot be granted that,
Huh?
They have already filed in a suit. It's entirely different. That's a different cause of action.
The land counts for the petitioner submits that he may permitted to withdraw this writ petition, availing the remedies available to the petitioner, accordingly dismissed as withdrawn with the liberty to avail the remedies under law. Yes.
Cell number 76. Vashita, yes.
My lord, 6 crores due, my lord. This is section 14 order has been challenged. And
Stay is there.
My lord, there is no stay, but there is this that this is subject. Any further action is subject to the writ petition. What is the result of the writ petition? That's why we are not.
No representation for dismissal. on Tuesday, 77.
Serial number 77. 77, Manjunath C.
Milords, I appear on behalf of the petitioner, Milords. Milords, this is a writ petition which we have filed seeking directions to the lenders for compliance with prudential framework and signing of an intercreditor agreement as per the prudential framework for stressed assets dated June 7, 2019. Before filing this writ petition, Milords, we had also issued a representation to the RBI seeking whether the lenders, where there is a set of consortium lenders and one is a separate Deutsche Bank. We requested whether there is a direction, whether they are required to comply with the prudential framework or not. RBI in its reply stated that since this matter is now pending before the High Court, we are not going to entertain. This is a sub judice matter before the High Court. RBI has not issued any clarification, Milords. And the second illegality, Milords, as per our prayer, Milords, we are challenging that the lenders did not file.
Sorry, ma'am.
Who is 4327?
I'm sorry, what's what?
4327 respondent.
I'm for respondent number 4 bank, my lords, for State Bank of India, respondent number.
Respondent number 3, my lords.
Other than respondent number 3, my lords, the other banks are part of a consortium. And if my lords were to see the order sheet,
Union of India is number 2.
RBI number
Bank,
1.
who is general manager.
Minutes,
State
I'm
Bank
appearing
of
for the
India.
respondent number 1 RBI, my lords.
5 Canara Bank.
4, 5, 6, and 7 are part of one consortium. My lords were to see the order passed by this honorable court about 2 dates ago. I don't remember the exact date. I think 17th or 18th November. There was a direction to convene a meeting.
1711.
1711. So if the petitioners were willing to offer a minimum of 50 crores out of a total outstanding balance of about 80
The
odd.
petition is willing to offer rupees 50 crores to the consortium banks. led by
That
the State
meeting
Bank
was
of-
convened.
For a consideration as one-time settlement offer for full and final payment.
Take it off. They remove the memo.
No, there was a direction to convene the meeting
Yes,
within
Manoj,
2
that
weeks.
meeting was convened. Other side, he copied. I'm so sorry, Manoj, that should submit it with the memo.
This order is on 1711.
Yes, sir, that's been complied with. Even the petitioners were there, Manoj, the discussion was held, but unfortunately,
on
Manoj, no
212.
consensus could be arrived at.
What happened?
We offered Manoj 50 crores.
50 crores. And
They are now saying that, it is not possible. And in fact, Manoj, the RBI regulation, in fact, RBI, Manoj, has not even filed their objections. RBI regulations, all lenders, Manoj, must meet and then, Manoj, take a decision. One of them, Manoj, has not come there.
All of them have met, that was the meeting.
No, not, yes, ma'am, except Deutsche Bank. Deutsche Bank is outside our consortium.
Therefore, they also have to, Manoj, come in terms of the regulations of the RBI. This is, Manoj,
In any event,
Let
my
them
matter
keep
may
all
require
that-
hearing at
all
5
that
o'clock
we
if you don't want to trouble my lords by any means. Possibly, Mr. Holla is right, the RBI may have to take a stand in this.
Who appears for RBI?
I am representing the RBI, my lords. We'll file a
What is the
detailed
stand of
objection. My lords, in this, it is between the consortium lenders. So in between RBI notification has been referred to by the petitioner. So we'll file a detailed objection in this matter. In fact, to see from RBI point of view, my lords, it is for them to decide the dispute. So RBI never comes in picture.
This matter
However,
after
we have been
vacation.
added.
By the time the respondent, the RBI shall file its objection.
I'm grateful.
interim order, whatever is there, Manoj.
Interim order.
That interim order, my lords, just to clarify, of course, we had undertaken that there is one, as far as we are concerned, I'm not sure about Deutsche Bank. As far as we are concerned, there is one section 14 proceeding, which was listed on 8th. I think my learned friend on the other side could clarify on what date it's gone to. if the matter, I can assure the court, my lords, if the matter comes there. 22nd, we'll take an adjournment on the next.
With respondent number 3, my lord, they are not
22nd
the part of
December.
consortium. My lord, the interim order is operating against them as well. My lord. We were never the part of consortium.
You'll see anyhow that interim order is operating.
That's a separate section 14 proceeding.
Yes, this is matter
Grateful.
after vacation. Interim order granted on so and so is extended to the next.
Cell number 78, Sanket Yamenaki.
I appear for the petition before this honorable court. My lord, the short point before this honorable court is a quantum of interim maintenance awarded by the trial court insofar as the children are concerned, who are the minors. 6,000 each has been awarded in respect of the children studying in the Baldwin school. If your losses may kindly see annexure E, page number 39, the affidavit of
We'll take up
income.
this matter some other day.
May I make
So,
only
what
one
you do?
mention before this court. In the meantime, let them pay at least the arrears which have been awarded by the trial.
We will see. 79 and all this, no, all this family court matters listed on wherever 82, 84, 86, all the family court matters list on Friday.
Serial number 79.
1 minute, I'll call. List on Friday. Then 80 will come on, 79 and 80 will come on Friday. Then what about 81?
80 is concerned. Can I make a request? 80 is concerned. Instead of Friday, could it be revised to Monday
Monday it won't reach even if I list. That's why I said
or Tuesday?
Wednesday as per the Wednesday. Yes.
My lord,
Fun.
Lord, 81.
They will come on Friday. Friday the list will be small. Yes.
Lord, 81, I need to file objections.
1 minute. 80?
81.
81. When did you file your wakalat?
Lord, I filed my wakalat recently. I got my papers just last week, my lord, from the bank.
Yes, list is matter next week. Yes, 82.
Lords, I appear for petitioner. There's emergency and requesting for interim prayer. Should we kindly have it next week?
Yes, next
Any
week.
date, my lords?
83.
In 83, my lord, my lord, serve the copy of the affidavit to clear the pending EMIs along with the security interest, my lord.
Who appears, Mr. Lokesh?
I'm there, my lords. I'm there. I'm appeared for the respondent, my lords. I'm there.
Serve on him.
It is served, my lords.
This
It can be, petition can be
On
disposed.
Friday. 83 on Friday. But it is, we'll see on Friday. Yes, Friday.
Number 84.
My lord, I appear for the respondent in this case.
If my lord goes after EMI, again I had 2 months.
Friday is when? Day after tomorrow. 84.
84, I appear for the respondent in this case.
Yes.
Let's 80.
84, let this come on Friday. 85.
In 85, my lords, seal number 85, my lords, appear for the respondent. my
Which
lords.
one?
85.
Go for the
85,
respondent.
appear-
Yes.
My lords, may I make a submission, my lords?
Let it
This-
come on Tuesday.
May I just, I don't want to burden the court, my lord. 60-day period for my surfacing notice ends on 31st December. Before that, I can't take action, my lords. Let them not create false emergency. First way, upon reopening, my lords.
This is matter after vacation.
Grateful.
Till then, my lord, interim order.
my lord, I am for the respondent, serial number 86.
When was it granted interim order?
Not granted, my lord.
We will, when there is no, when the time itself elapses in the end of December, what will they do now?
Not to participate.
No. Yes, next.
My lord, serial number 86, my lord. Your lordship asked when he will appear for cross-examination in India, my lord.
79 will come on Friday, tomorrow. Yes.
Cell number 86.
For the petitioner, my lord.
But I am for the respondent. On last occasion, your lordship, you asked him when he will appear for the cross-examination in India, my lord. For that purpose, the date is fixed.
That is 86, sir.
Yes, my lord. Yes, my lord.
It will come day after tomorrow, Friday.
Yes, my lord. Yes, my lord.
Yes. Yes, 87. When both of you are appearing, why it will be taken up for preliminary hearing? All these MFA matters after
My
vacation.
lord, one submission. My lord, serial number 88, kindly have done and 13, my lord, Lok Adalat,
Refer to
only
Lok
for
Adalat.
claimant.
The Lok Adalat,
Please.
88, refer to the Lok Adalat.
One submission, interim order granted in session 53 by hand, my lord. Apologize, my lord, so that I can send it
Yes,
via email.
the, all other MFAs, RPFC also after vacation. This 92, what is this?
My lord, serial number 92. My lord, I am for the petitioner in that. My lord, in brackets there were, it was mentioned that no further adjournments will be granted in that. My
No,
lord,
this is
it
a,
is
this is
the matter
as per the limitation, the
section
lordship
14
is yet to decide. Well, after vacation, it will be possible.
Section 14 order limitation, my lord.
I will pass orders on, list this matter on Friday.
93, my lords.
Grateful.
On Friday.
93, my lords. Partly heard matter.
That's 92, there is an interim order, my lord.
Interim order, all, wherever interim
Yes.
order is there, it will be extended.
Grateful.
My lords, 93, my lords.
Ah.
I appear for the respondent. Can it be by tomorrow, my lord? 2:30.
Why?
Partly heard matter.
2024 matter.
Please, it's an urgency.
Let it be in the list on Friday, then see if it reaches.
My lord, one submission, my lord.
My lords,
There is a
date.
memo for,
Memo?
memo for posting, my lord. Yesterday I-
Memo posting at 4:55.
My lords, date. My lord. Can it by tomorrow, my lords?
Submission, my lord, and someone.
My lords.
Serial number 53, my lord. Please, my lord, because in
No urgency for that. We will upload the order by tomorrow. No hand delivery is required.
Okay, deeply opposed.
What of sir? Serial number 78. Sir, 82 date ಮಾಡಿದ್ರು. Serial number 78.
ಈಗ ಬರ್ಕೊಳ್ಳಿ. ಎಲ್ಲಿಂದ ಹೇಳಿ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ 77 78 12
ಹೇಳಿ
79 ನಾನೇ ಬರ್ಕೊತೀನಿ ನಾಳೆ 79 then 80 next Wednesday ಅಂದಲ್ಲ 17 12 ಆದಿ ದೇವಾನಂದು so and then 81 and 17 12 next week 82 or FC matter 18 12
Madam, 18 12 va? 18 12.
82 18 12
Okay.
83 12 12 84 12 12 85 after vacation 86 12 12 87 ಯಾವುದು 86 12 12 Friday so 87 that is 16th ಅಲ್ಲ
Ma'am, 12 this Friday. 87 this Friday. It's a covered by issue.
12 12 ಅಂತ ಹೇಳಿ 12 12 ಅಂತ ಬರ್ಬೋದು 88 ಲ್ಯಾಂಡ್ ಲೋಕ್ ಅದಾಲತ್ ಆಮೇಲೆ 89 to 91 after vacation
Madam, 78.
92 12 12 93 12 12
Madam, 78.
93.
ಸೊ ಎಲ್ಲಿದೆ ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಬರಿ
Madam, 93.
93 12 12 day after tomorrow 79 78 12 12 sir